WP ನಿಮಗೆ ಬರುತ್ತಲ್ಲ.
छब्बीस साल में बड़े से बड़े मुस्लिम
Lords, the respondent, my lords, initiated proceedings against the petitioner before the land grab being court, my lords. Petitioner filed
Next week ಹಾಕ್ಬಿಡಿ.
Lords,
ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್
termination of service challenged.
ಟರ್ಮಿನೇಷನ್ ಆಫ್ ಯಾವಾಗಾಗಿತ್ತು ಟರ್ಮಿನೇಷನ್
ಅದು CAT
ಯಾವಾಗಾಗಿತ್ತು
ಡಿಸ್ಮಿಸಲ್ ಆದ್ಮೇಲೆ ಇಲ್ಲಿ ಬಂದ್ರು.
CS ಅಲ್ಲ ಟರ್ಮಿನೇಷನ್ ಯಾವಾಗಾಗಿತ್ತು
CAT ಆರ್ಡರ್ ಓನ್ಲಿ ಚಾಲೆಂಜ್.
ಅದನ್ನ ಕರೆಕ್ಟ್ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡ್ಬೇಕು.
Lord,
ಆಫ್ಟರ್ ವೆಕೇಶನ್
Lord, I am moving the matter for 2:30 for this reason. Lord, sub-registrar counseling, my lords had granted an interim order, my lord, till the disposal of, my lord, the application. My lord, day before yesterday at 1:30, my lord, pronounced. My lord, 6 o'clock, an order is passed giving effect to the transfer, my lord, counseling. My lord, we are likely to be, my lord, relieved today. Lord,
ಏನ್ ಮಾಡಕ್ ಬರ್ತದೆ ಅದು ಮಂಡೆ
tomorrow, my lord, in the.
ಬೆಂಚ್ ಇದೆಯಾ ಇಲ್ಲೇ ಅಲ್ಲ ನಾಳೆ ಬೆಂಚ್
In fact,
Lord,
your lordships have said till after disposal. my lord.
Agency, my lord, because
Huh?
now we are going to relieve.
ಎಲ್ಲಿಂದ ಯಾವ್ದು
Sub-registrar state.
ಆಯ್ತಲ್ಲ ಹೇಳಿದ್ರು ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಬೇರೆ
Lord,
ಅದೇ ಉತ್ತರ
Lord,
Make one.
ಸುಮಾರು ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ
Lord, in that event, my lord, it will be, my lord, we will be relieved, my lord.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ ಏನು ಮಾಡ್ಲಿಕ್ಕೆ
Lord,
ಬರಲ್ಲ
we will take, my lord, we will take,
ಆದ್ರೆ ಏನು ಸೋಮವಾರ ಏನು ಸರಿ ಮಾಡಕ್ ಬರಲ್ಲ
Lord, we will take chance, my lord.
ಯಾವ್ದೋ ಒಂದು ಸ್ಟ್ರಕ್ಚರ್ ಅನ್ನು ಡೆಮಾಲಿಷನ್ ಮಾಡ್ತಾರ ಅನ್ನೋ ರೀತಿ ಅಲ್ಲ
Lord, it will lead to, my lord,
ಏನ್ ಮಾಡಕ್
we will take chance, my lord, at 2:30, my lord.
ಹೆಂಗ್ ಇವತ್ತು ನಾಟ್ ಪಾಸಿಬಲ್
Your lordships had protected as your lordships may just clarify till after disposal your lordships had said.
ಅಂದ್ರೆ ಏನು
My lords, till
Disposal
and after.
ಆದ್ಮೇಲೂ ಕೊಡ್ಬೇಕು
My lords,
ಅಂತಾನ?
till we approach that
till
for
after.
day or two, my lords, respite for a day or two, my lords.
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ 30 next week
My lords, this writ petition is against the order of reversion, my lords. The order was passed on 28/11. They are being reverted, my lord. Kindly have it Monday.
28/11 Tuesday ಹಾಕೊಳ್ಳಿ ನೋಡ ಓಕೆ
Two RFAs, parties have arrived at a compromise, my lord.
ದೇ ಆರ್ ಕಾಂಪ್ರಮೈಸ್
Could it please be listed on Monday?
ತಳಿ ಯಾವತ್ತು ಬರುತ್ತಾ ಓಕೆ ನೆಕ್ಸ್ಟ್
Matter pertaining to pension, my lords.
Pension.
Immediate next-
ಇಮಿಡಿಯೇಟ್ಲಿ ಇನ್ ದ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಜನವರಿ ಹಾಕಿ ಓಕೆ
My lord, Monday, ನಾಳೆ
ಮಂಡೇ
Monday.
ಮಂಡೇ ಕೊಡಿ
My lord, this is RFA
RFA ಏನು ಯಾವ ಇಯರ್ದು
2016, my lord,
2016 ಸೂಟ್ ಯಾವ ಇಯರ್
16.
16 ತಳಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವಾಗ ಹಾಕೊಳ್ಳಿ ಓಕೆ
Serial number 21, adjournment.
21
We are for appellant, my lords. We are engaging the senior BK Sampath Kumar is not available for due to emergency.
RFA 2017
Yes, my lords.
all right in the last week of January
Kindly give Monday, it's possible.
ಮಂಡೇ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಕೇಳೋದು ಅದು ಬಂದಾಗ ರೆಡಿ ಇರಲ್ಲ ಓದ್ಕೊಂಬರೋದು ಎಷ್ಟಂತ ಓದೋಣ ಕೆಟ್ಟ ಭಾಷೆ ಎಸ್
I represent this.
The appellant, this matter.
We in fact new trend we want to set in ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ನಾವು ಕೊಡ್ತಾ ಇದ್ದೀವಿ ನಮ್ಮೆಲ್ಲ ತೀರ್ಪುಗಳನ್ನು
ಹೌದು.
ಜನಸಾಮಾನ್ಯನಿಗೆ ಅರ್ಥ ಆಗುವುದು ಹೇಗೆ ಇಂಗ್ಲೆಂಡ್ನಲ್ಲಿ 1730 ಲ್ಯಾಟಿನ್ ನಲ್ಲಿ ನಡೀತಿತ್ತು ಎಲ್ಲ ಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ 1730 ಅವರು ಇದು ನಮ್ಮ ಭಾಷೆಯಲ್ಲೇ ಆಗಬೇಕು ಅನ್ನುವಂಥ ಶಾಸನವನ್ನ ಮಾಡಿದರು 1730 ಇಲ್ಲಿಯವರೆಗೆ ಅಂಗ್ರೇಜಿ ಭಾಷೆಯಲ್ಲೇ ನಡೀತದೆ ಎಲ್ಲ ಇಂಗ್ಲಿಷದ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಆಂಗ್ಲ ನ್ಯಾಯಾಲಯಗಳಲ್ಲಿ ಆ ಭಾಷೆಯಲ್ಲೇ ನಡೀತದೆ ಯಾಕಂದ್ರೆ ಎಲ್ಲರಿಗೂ ತಿಳಿತದೆ ಅನ್ನೋದು ಅಬ್ಜೆಕ್ಟ್ ಆಫ್ ಲಾ ಈಡೇರಬೇಕು ಅಂದ್ರೆ ಎಲ್ಲರಿಗೂ ತಿಳಿಬೇಕದು ಅಲ್ವಾ ಪೂರ ಜಜ್ಮೆಂಟ್ ತಿಳಿಲಿಕ್ಕಿಲ್ಲ ಇವಾಗ ಕೇಶವಾನಂದ ಎಲ್ಲ ನಾವು ಓದಿದ್ರೆ ನಮ್ಗೆ ತಿಳಿಯಲ್ಲ ನಿಮ್ಮೆಲ್ಲ ತಿಳಿಬೋದು ಆದರೆ ಇಂಥ ಜಜ್ಮೆಂಟ್ಗಳನ್ನ ರೀಸನಿಂಗ್ ಪಾರ್ಟ್ ತಿಳಿಲಿ ಬಿಡಿ ಅಟ್ಲೀಸ್ಟ್ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಇದೆಯಲ್ಲ ಅದನ್ನಾದ್ರೂ ಕನ್ನಡದಲ್ಲಿ ಕೊಡಬೇಕು ಅವಾಗ ಆ ಲಿಟಿಗಂಟ್ಸಿಗೆ ಅರ್ಥ ಆಗ್ತದೆ ಓ ಏನು ಹೇಳ್ಯ ನೀವು ಆ ಜಡ್ಜು ಈ ನ್ಯಾಯಾಲಯ ಏನು ಹೇಳಿದೆ ಆ ರೀಸನಿಂಗ್ ಎಲ್ಲ ಬಿಡೋಣ ಜುರಿಸ್ಪ್ರುಡೆನ್ಷಿಯಲ್ ಪಾರ್ಟ್ ಬಿಟ್ಟು ಹಾಕ್ಬೋದು ನಮ್ಗೆ ಆ್ಯಕ್ಚುಲಿ ನಮ್ಮ ಕೈಕಾಲಿಗೆ ಪೆಟ್ಟಾಗುವಂಥದ್ದು ನಮ್ಮ ಬಟ್ಟೆಗೆ ನಮ್ಮ ಕಿಸೆಗೆ ಹಾನಿಯಾಗುವಂಥದ್ದು ಯಾವುದಿದೆ ಅಂತ ಅವನಿಗೆ ತಿಳಿಬೇಕು ಇದನ್ನ ಇವತ್ತು ನಾವು ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಯಾಕೆ ಅಂದರೆ ನಿನ್ನೆ ಭಾರತ ಭಾಷಾ ದಿವಸ, ಭಾರತದ ಭಾಷೆಗಳಿಗೆ ಮಾನ್ಯತೆಯನ್ನು ಕೊಡುವಂಥ ದಿವಸ ರಾಷ್ಟ್ರೀಯವಾಗಿ. ನಿನ್ನೆ ನಮ್ಮ ಶ್ರೀಯುತ ಎಸ್ ಎಂ ಕೃಷ್ಣ ಅವರು ಕಾಲವಾದರು ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ಕಲಾಪ ಇರಲಿಲ್ಲ. ಹಾಗಾಗಿ ಇವತ್ತು ನಾವು ಒಂದು ಅಂಗ್ರೇಜಿಯ ತೀರ್ಪು, ಇನ್ನೊಂದು ಕನ್ನಡ ಭಾಷೆಯ ತೀರ್ಪು, ತರ್ಜುಮೆ ಅಲ್ಲ, ಎರಡೂ ತೀರ್ಪುಗಳನ್ನು ನಾವೇ ಬರೆದಿವಿ. ತರ್ಜುಮೆ ಅಲ್ಲ, no translation, like Tagore used to write English poems also and Bengali poems also. That way we have done. English judgment ಬರ್ದೇವಿ, ಕನ್ನಡದ ಜಡ್ಜ್ಮೆಂಟು ಬರೆದ್ಬಿಟ್ಟಿವಿ. ಅದರ ಆರ್ಟಿಕಲ್ ಅನುಚ್ಛೇದ 348 ಪ್ರಕಾರ ಹೈಕೋರ್ಟು ಮತ್ತು ಸುಪ್ರೀಂ ಕೋರ್ಟದ ಭಾಷೆ ಇಂಗ್ಲಿಷ್. ಅಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ಓನ್ಲಿ ಅಂತ ಹೇಳಿಲ್ಲ. ಎಲ್ಲೆಲ್ಲಿ ಆ ರೀತಿ ಓನ್ಲಿ ಅನ್ನೋ ಪದ ಬೇಕಿತ್ತು ಅವರು ಓನ್ಲಿ ಅಂತ ಅನ್ಕೊಂಡು ಸಂವಿಧಾನದಲ್ಲಿ ಅನೇಕ ಆರ್ಟಿಕಲ್ಸ್ ನಲ್ಲಿ ಉಪಯೋಗಿಸ್ತಾರೆ. ಅದನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದೆ ನಾನು. ನಂತರ 348(1) ಅದರಲ್ಲಿ ಮತ್ತೆ ಪ್ರಾವಿಷನ್ಸ್ ಇದೆ. ದಿ ಗೌರ್ಮೆಂಟ್ ಮಾಡಕ್ ಬರ್ತದೆ, ಗವರ್ನರ್ ವಿತ್ ದ ಅಸೆಂಟ್ ಆಫ್ ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ಒಂದು ಆರ್ಟಿಕಲ್ ಇದೆ, ಸಬ್ ಆರ್ಟಿಕಲ್ ಇದೆ. ಅಲ್ಲಿ ಕನ್ನಡದಲ್ಲೇ ಮಾಡಲಿಕ್ಕೆ ಇದೆ. ಯಾರು ಇವತ್ತಿನವರೆಗೆ ಯಾರು ಆಕ್ಚುಲಿ ಸ್ಟೇಕ್ ಹೋಲ್ಡರ್ಸ್ ಇದ್ರ ಬಗ್ಗೆ ಡಿಸಿಷನ್ ತೊಗೊಳ್ಳಿಕ್ಕಿತ್ತು, ತಗೊಂಡಿಲ್ಲ. ನಾವು ವೇಟ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ ಎಂಡ್ಲೆಸ್ಲಿ, ಕನ್ನಡದಲ್ಲಿ ಪ್ರಾರಂಭ ಆಗಬೇಕು. ಆ ಕಾರಣಕ್ಕೆ ಈ ರೀತಿ ತೀರ್ಪನ್ನು ನಾವು ಬರೆದೇವಿ. ಮೊದಲು ಸಂವಿಧಾನ ಹೇಳುವಂತೆ ಇಂಗ್ಲಿಷದ ತೀರ್ಪನ್ನು ಓದ್ತೇವೆ, ನಂತರ ಕನ್ನಡದ ತೀರ್ಪನ್ನು ಓದಿಬಿಡುತ್ತೆ. In the above circumstances, this appeal succeeds. The impugned judgment and order of the learned single judge are set aside. Contesting respondents' application in IA number 2 of 2023, filed under Order 7, Rule 11D of CPC, is dismissed. As a consequence, appellant suit in TOS number 1 of 2023 having been revived, the same needs to be tried and disposed of on merits in accordance with law. We have done this one. We have considered, we have agreed with you that there is a limitation. Please. We accepted this one, we rejected the content. But both of you did not have a holistic view of Limitation Act at all. Section 14 is considered to be soul of Limitation Act 1960, 1908 itself, Gonsil said long ago. 14 says, where you prosecute proceedings in other courts bona fide, yes, that should be discounted. ಆ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಅನ್ನು ಇಬ್ರು ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ರಿ. ಒಂದ್ ಲೈನ್ ಹೇಳಿ ನೀವು ವಿಶದೀಕರಿಸ್ತೀವಿ, ಅದನ್ನ ಸಬ್ಸ್ಟ್ಯಾನ್ಶಿಯೇಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಇಷ್ಟು. ಹಾಗಾಗಿ ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯದ ತೀರ್ಪನ್ನು ಆಧರಿಸಿಕೊಂಡು ನಮ್ಮ ತೀರ್ಪನ್ನು ನಾವು ತಯಾರಿ ಮಾಡಿದ್ದೇವೆ. ಕನ್ನಡದಲ್ಲಿ ಮೇಲ್ಕಾಣಿಸಿದ ಕಾರಣಗಳಿಂದಾಗಿ ಈ ಮೇಲ್ಮನವಿಯನ್ನು ಪುರಸ್ಕರಿಸಲಾಗಿದೆ. ಏಕ ಸದಸ್ಯ ನ್ಯಾಯಾಧೀಶರ ಪ್ರಶ್ನಿತ ತೀರ್ಪು ಮತ್ತು ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಲಾಗಿದೆ. ಪ್ರತಿವಾದಿಗಳು ಸಲ್ಲಿಸಿದ್ದ ಮಧ್ಯಂತರ ಅರ್ಜಿ IA ಸಂಖ್ಯೆ 2/23 ಅನ್ನು ವಜಾಗೊಳಿಸಲಾಗಿದೆ. ತತ್ಪರಿಣಾಮವಾಗಿ TOS ಸಂಖ್ಯೆ 1/2023 ಮೇಲ್ಮನವಿದಾರರ ದಾವೆಯನ್ನು ಪುನರುಜ್ಜೀವನಗೊಳಿಸಲಾಗಿದೆ. ಅದನ್ನು ಕಾನೂನಿನ ರೀತ್ಯ ವಿಚಾರಣೆ ಮತ್ತು ವಿಲೇವಾರಿ ಮಾಡಬೇಕಾಗುತ್ತದೆ. ಯಾರೂ ವೆಚ್ಚವನ್ನು ಭರಿಸುವಂತಿಲ್ಲ. ಕಾಸ್ಟ್ ಮೇಡ್ ಈಸಿ.
Common man will understand now. Hereafter a common man will understand things.
ಅರ್ಥ ಆಗ್ಬೇಕು. ಇಲ್ಲಪ್ಪ ಬೇರೆ ನಾವು ಇಂಗ್ಲಿಷು ಅಥವಾ ಅವ್ರಿಗೆ ತಿಳಿಯದ ಭಾಷೆ ಹೆಂಗೆ ಅವ್ರಿಗೆ ಏನ್ ಮಾಡ್ಬೇಕು?
May I make one request, matter was
ಫಾರ್ ದಟ್ ರೀಸನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇತ್ತೀಚೆಗೆ ಆಯಾ ಭಾಷೆಗಳಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ತೀರ್ಪುಗಳು ಸಹಿತ ಬೇಕು ಅನ್ನೋದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೆ. ಮಾಡಿ
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಎರಡು ಎಲ್ಲ ತೀರ್ಪುಗಳು
ನಮ್ಮ ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನ 2400 ಜಡ್ಜ್ಮೆಂಟ್ ಗಳನ್ನ ನಾವು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡಿ ಈಗ ಇಟ್ ಇಸ್ ಅವೈಲಬಲ್
ಅಷ್ಟು ಮಾಡಿ
ಕನ್ನಡದಲ್ಲಿ. ಕರ್ನಾಟಕದ್ದು 1400ಕ್ಕಿಂತ ಜಾಸ್ತಿ ತೀರ್ಪುಗಳು ಈಗ ಕನ್ನಡದಲ್ಲಿ ಟ್ರಾನ್ಸ್ಲೇಷನ್ ಆಗಿರುವಂತದ್ದು.
It's a good step, my lord. At least hereafterwards,
ಕನ್ನಡ
common man will understand.
ಕನ್ನಡದ ಅವಸಾನ ಆಗ್ಬಾರ್ದು ಅನ್ನಂಗಿದ್ರೆ ಕನ್ನಡಕ್ಕೆ ಮಾನ್ಯತೆ ಸಿಗಬೇಕು. ಕನ್ನಡದಲ್ಲಿ ವ್ಯವಹಾರಗಳು ಸಾಂವಿಧಾನಿಕ ಸಂಸ್ಥೆಗಳಲ್ಲೂ ಸಹಿತ ನಡೆಯಬೇಕು.
My lord's judgment will send a good message for other judges.
We do not know, but at least we have
He will have a
we have done our part.
ILR ನ 2016 ವರೆಗಿಂದು ಈಗ ಫ್ರೀ ಅವೈಲಬಿಲಿಟಿ ಇದೆ. ಕನ್ನಡ ತೀರ್ಪುಗಳ ವರದಿ ಅಂತೇಳಿ ILR ಕನ್ನಡ ಇದೇನಿತ್ತು ಅದನ್ನು ಸಹಿತ ಈಗ ನಾವು 85ರಿಂದ ನಮ್ಮ ಹತ್ರ ಇದೆ. ಅದನ್ನ ಈಗ ಆಸ್ ಎ ಫ್ರೀ ಸರ್ವಿಸ್ ಅದನ್ನ ILR ನಲ್ಲಿ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಕೊಡ್ತಾ ಇದ್ದೀವಿ.
Please. Minutes, may make one request, minutes.
Ah.
Matter was, minutes, set down for cross-examination of DW1,
Ah.
and this application came to be allowed. Minutes, now the matter has to be, minutes, sent to the registrar. minutes.
ಪುನರುಜ್ಜೀವನಗೊಳಿಸಲಾಗಿದೆ ಅಂತ ಹೇಳೋದು.
ಹೌದು,
That
ಅಂದ್ರೆ
proceedings are revived.
minutes, matter has to be posted before the registrar, minutes, for the further
ಅದು
cross-examination.
ಮುಂದೆ ಏನೇನಾಗ್ತದೆ
Please.
ಆಗತ್ತೆ.
Oblige.
Okay, thank you.
Oblige.
Thank you.
Here for respondent number 3, my lord.
I represent the appellant.
Memo for retirement filed by Educator for R2, Kumar R.S. Gowda. ಇಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ರಿಟೈರ್ಮೆಂಟ್ ಕೊಡಲ್ಲ.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ 3ನೇ ಕೌನ್ಸಿಲ್ ಚೇಂಜ್ ಮಾಡಿರೋದು. ಆಮೇಲೆ ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 and 2 ದೇ ಆರ್ ದ ಬಿಲ್ಡರ್ಸ್. ಅದರಲ್ಲಿ ಅವರು ಲಾಯರ್ ಪದೇ ಪದೇ ಚೇಂಜ್ ಮಾಡಿ ಕೊನೆಗೆ ಅವರು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
Memo seeking leave of court to retire from the case after 10 years cannot be entertained and therefore rejected. Okay. You have to argue. Start.
Lord, this is basically, my lord, in the trial court, a suit for specific performance was filed. The trial court framed as many as 6 issues.
Very orders ಎಷ್ಟೇ ಬಂದಿದೆ.
It was listed last week, my lord. My lord said you would hear the matters finally and dispose it off today, my
We
lord.
said that.
Yes, my lord.
We will have it next week for hearing at
A date may be fixed, my lord.
2013 ಅನ್ನು ನಡೆಸ್ತಾ ಇದ್ದೇವೆ ಅದಕ್ಕೆ. ಅಲ್ಲ ಕೆಲವೊಂದು 16 ತೊಗೊಂಡೇವಿ 17 ಡಿಪೆಂಡಿಂಗ್ ಅಪಾನ್ ಏಜ್ ಆಫ್ ದ ಸೂಟ್.
Only short question on which
next.
the suit came to be dismissed of mine is that it is out of time. That's all the question. Otherwise, other issues have been answered affirmatively in my favor.
ಔಟ್ ಆಫ್ ಟರ್ನ್ ಅಂತನ
ಅಲ್ಲ, out of time.
Limitation.
Time barred ಅಂತ. Date fixed under the agreement is, the suit is filed thereafter.
ಕೊಡಿ ಅಗೋದಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅದು. ಆಲ್ ಅದರ್ ಇಶ್ಯೂಸ್ ಆರ್ ಹೆಲ್ಡ್ ಇನ್ ಯುವರ್ ಫೇವರ್.
Other issues have been held affirmatively in my favor.
Yeah.
Lord,
ಟೈಮ್ ಬಾರ್ಡ್ ಎಲ್ಲಿಂದ ರೆಕಾನ್ ಆಗ್ಬೇಕು ಅಂತಾರ ಅವ್ರು.
page 278 of the paper book, from the entire paragraph, I mean, it commences from 276, ಅಂಶ 4 ಅಲ್ಲಿಂದ ಶುರು ಆಗ್ತದೆ. The trial judge goes on affirmatively answering all the issues, but issue with regard to whether the suit is out of time or not.
Where is that paragraph?
Now,
Issue number 4 is at 270.
277, my lords, may
Where
kindly
is
be
the
at
treatment of the proposition?
77, it starts from 276. But the relevant would be for my lords to consider it on 277. Can I draw my lord's attention to some middle part of the paragraphs,
Yes.
which sentences in continuation reads like this: Nishane 17ರ ಒಪ್ಪಂದದ ಜಾರಿ. Did my lords got it?
Yes.
ಕುರಿತು ಪ್ರತಿವಾದಿ ವಿರುದ್ಧ ಯಾವುದೇ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಂಡ ಬಗ್ಗೆ ಆಗಲಿ, ನೋಟಿಸ್ ನೀಡದ ಬಗ್ಗೆ ಆಗಲಿ ಸಾಕ್ಷ್ಯಾಧಾರ ಹಾಜರುಪಡಿಸಿಲ್ಲ. ದಿನಾಂಕ 30/8/2006 ಎರಡನೇ ಪ್ರತಿವಾದಿಗೆ ಪತ್ರ ಬರೆದು ದಾವಾ ಸಿ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿ ಒಪ್ಪಂದ ಕಟ್ಟಡ ಮುಗಿಸಲು ಸಾಧ್ಯವಾಗಿಲ್ಲ ಹಾಗೂ ದಾವಾ ಆಸ್ತಿಯಲ್ಲಿ ಕಟ್ಟಡ ಕಟ್ಟಿ ಮುಗಿಸಲು ಪುನಃ 11,45,000 ವಾದಿ ಕೊಡಬೇಕೆಂದು ತಿಳಿಸಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
ಯಾವಾಗ ಕೊಡಬೇಕಿತ್ತು ಈ ಅಮೌಂಟ್ ಅನ್ನ?
This is an extra amount which he demanded, apart from the amount mentioned in the agreement. He goes on demanding
When it was demanded?
The amount that he demanded was when the construction was finalized in the year
Date.
2013.
Date ಹೇಳ್ಬೇಕು. ಯಾವತ್ತು
Dates,
demand ಮಾಡಿದ್ದು?
I'll finish the date. The date is the 6/5/2008. Additional documental ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ. Some documents were filed along with the application under Order 41 Rule 27, which were there on record before the trial court, and subsequently it could not be exhibited.
ಸಾಕಷ್ಟೆಲ್ಲ ಮಾತಾಡ್ತೀರಿ. ಡೇಟ್ ಅನ್ನು ಕೊಡಿ ಅಂತ
My lord,
ಕೇಳ್ತಾ
38/2006, if I may assist, my lord, 38/2006, my lord, exhibit P21 at page number 254.
Okay, one
Is the notice issued by us?
38
2006,
exhibit
P21. In paper book, page 254. This was
Exhibit 221, na?
21, my lord.
21.
Page number 254, my lord, in the paper book. Agreement to sell.
Before.
Agreement to sell is dated 7/6/2002, my lord.
Really? 254 even.
Yes, ma'am.
Seven.
Additional document selling. DA.
Come to 258 exhibit P22. What is the date of public notice?
Date of the public notice is not brought forth here.
Nim notice, sir.
At the date of publication. Twenty 20th of March 2013. 20th of March 2013.
Only that much.
Limitation is the issue, my lord. 2002 is the, my lord, I am for the subsequent purchaser, my lord, because builder, respondent 1 and 2, they're not appearing before the court. And my lord, again,
Who entered into?
my lord, what happened, my lord? My lord, so far as respondent number 3 is, my lord, is a retired army man, and he's, my lord, fought for this country for several years. Is that, my lord, also retired as the rank of a colonel. Post his retirement, with whatever little savings he had, my lord, he approached the respondent 1 and 2, my lord, to purchase an apartment, and then they executed sale deed insofar as this apartment is concerned. Not disclosing the fact that early R1 and R2, my lord.
Who appears for builder?
He's changed enough counsels, my lord, and then nobody is willing to appear for him. He made an application before the committee to appear himself, but this honorable court committee felt he is unfit to assist the court. And my lord, for the last 2 years, it's only getting dragged on because of respondent 1 and 2, my lord, builder.
Yeah.
And if my lords permit me, I will assist the court so far as records are. Yes, ma'am. Sorry.
ಅಲ್ಲಿ ಬೇರೆ buildings apartments ಇದಾವ?
Idare, next to it, this is
ಅದ್ರಲ್ಲಿ
B204. Next to it, it is vacant. If they hand over vacant possession of that apartment of the same size, of same infrastructure, I'm glad.
In fact, I have filed an affidavit to that effect, my lord. What are the vacant apartments in the property, in the same complex, my lord, which is owned by the builder, my lord.
ಅವ್ರ ಸರ್ವಿಸ್ ಆಗಿನೂ ಬಂದಿಲ್ಲ ಏನ್ ಹೇಳ್ತಾರೆ ಅವ್ರು?
He is,
B204,
Sufficient
right?
tax.
Next is B0. You are happy to receive it. Registration charges.
I have given the list of apartments which are owned by.
Sorry, registration charges, if we base it, he has to pay because he did not have to pay. It's not required to pay registration charge. It's to get the possession. Without any additional cost. Registration charges.
Point number one, Metro Bangalore Assembly. Point number two, Metro Developers and Promoters.
Both are run by the husband and wife.
That is the only contention which.
That is the only contention.
ಇದೆಲ್ಲ ಅವ್ರ ಪರವಾಗಿ.
ಅದು ಎಲ್ಲ ಅವ್ರ ಪರವಾಗಿದೆ, but 2002 agreement, they filed the suit in 2013. I mean, I'm only assisting the court from the records, which, my lord, because I am a subsequent purchaser, my lord, where it was not informed to us saying that there was a case pending. Suit was dismissed, my lord, and during the pendency of the appeal. What he pleads, my lord, the builder, that summons from this honorable court was never served on him. So he was also not aware of pendency of the appeal. And sale deed, insofar as the respondent number 3 is concerned, happened in 2019. And subsequently, I was impleaded, my lord. Fag end of my life, my lord, where I'm suffering from several ailments, and then all my retirement money is gone into this buying this apartment. And in my affidavit, I've also given 3-4 other apartments which is owned by the very same builder, my lord. Paragraph number 19 of my affidavit, my lord, I've stated apartment B201 is 2 BHK, A502, 503 are 3 BHK, and B403 is also 2 BHK.
Lispendence
Yes, my lord.
does not depend upon the knowledge of the buyer.
Absolutely. my lord.
Pendentality. Anyway, one factor
I-
served the country
Yes, my
is a
lord.
factor. We consider that.
And
also.
yes, my lord, that was the only contention, my lord.
If the court directs the respondent number 1 and 2 with regard to the vacant apartment which is
ಇಲ್ಲಲ್ಲ, ಅದಕ್ಕೆ
adali registration charges, once again I have to bear the that's a problem to me.
not if
Here, I bore the registration charges, got it registered.
That is only
Again,
so
to
far.
take another vacant one, in substitute of this, I will have to again shell down the registration charges.
ರಿಜಿಸ್ಟ್ರೇಷನ್ ಚಾರ್ಜ್ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿನ ಯಾವ್ದು
Stamp
ಮಾತಾಡ್ತಾ ಇದ್ದೀರಿ?
Stamp
Fact-
duty,
In
stamp
fact, my
duty.
lord, so far as that initial agreement is concerned, only undivided share in the land was conveyed.
ಏನು ಇಲ್ಲದಕ್ಕಿಂತ
Something is better.
something is.
It may come up to almost 3 to 4 lakhs. Eh? With today's,
ಅಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಇದೆ?
please,
ಅಪಾರ್ಟ್ಮೆಂಟ್ಗೆ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ಇದೆ?
6.5%, my lord.
6.5%.
And,
Same
it-
other
it-
convenience.
In 2019, when I bought, we paid around 64 lakhs for the apartment, my lord. And about 3 to 4 lakhs would be the registration charges if I have to bear as on today. And so far as the,
ಸಪೋಸ್ ನಾವು ಅಪೀಲ್ ಅಲೋ ಮಾಡಂಗಿತ್ತು ಅಂದ್ರೆ
yes, my lord.
ಲಿಸ್ಪೆಂಡೆನ್ಸ್ ಇದನ್ನೆಲ್ಲ ಟ್ರೀಟ್ ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
Yes, my lord.
ಅಲ್ಲಿ ನಾಲೆಡ್ಜ್ ಆಫ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಈಸ್ ಇರ್ರಲವೆಂಟ್ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
Yes, my lord.
52ಕ್ಕೆ.
Yes, my lord.
ಹಂಗಾಗಿ ಸಪೋಸ್ ಇಫ್ ವಿ ಫೀಲ್ ದಟ್ ಇಟ್ ಶುಡ್ ಬಿ ಅಲೋಡ್, then are you to shell out part of that money?
My lord,
Or you
if I-
want
my
that
lord,
your sale deed should be set aside?
all his lifetime earnings, his retirement
You
money.
have said that.
Yes, yes, my lord.
He was a
In
great
fact,
warrior.
And plus,
He fought, everything we have noted.
yes, my lord, he's
But law
also
is-
suffering from Alzheimer's, my lord. And he's been spending money on his treatment, and he's not in a position to bear anything, my lord. In fact, settlement was proposed by this honorable. court,
Settlement
my lord. Yes, my lord.
ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಪಾರ್ಟ್ ಆಫ್ ದಟ್ ಅನ್ನ ನೀವು ಅಂದ್ರೆ ಇಫ್ ವಿ ಡಿಸೈಡ್
Yes, ma'am.
ವಿ ಡು
Yes.
ನಾಟ್ ನೋ, ಜಸ್ಟ್ ವಿ ಆರ್ ಡಿಸ್ಕಸಿಂಗ್, ವಿ ಆರ್
Yes,
ಟೇಕಿಂಗ್
ma'am.
ಆಲ್ ಎಂಟೈರ್ scenario into
To buy peace, my lord, a portion of it, my lord, maybe a portion, my lord. So far as the registration charges.
that portion will have to be defined.
And which the builder was supposed to pay, my lord, because of what he's put us in soup, they are also not in a position to enjoy, and I'm also not in a position to enjoy.
Why you should improve that? Proceed, I'll build it. We will have that. The contribution.
ಅಲ್ಲ ಏನು 50% ಜಾಸ್ತಿ ಆಗುತ್ತೆ 50%. ಏನ್ ಮಾಡಕ್ಕಾಗೋದಿಲ್ಲ.
Heard, reserved.
Much obliged. Fact, my lord, if my lords may kindly note, my lord, in my affidavit, paragraph number 19, I've given those apartments which are as on today standing in the name of the developer, my lord.
Para 19,
Paragraph 19, my lord. 4 apartments are still are in the name of the builder, my lord, as on today, which is not sold by him. Much obliged.
All.
But I represent the applicant.
For the respondent, my lord, it's my
Yes, yes.
application for,
They have filed an application for seeking for an interim order of injunction. I
Ah.
filed my objection. Just 3 days ago, they have served the copy to me.
my lord, if I may make submissions, my lord.
3 days back you were given.
My lord, I've filed, 3 days back, I've given them, my lord, if I may make submissions on the application, my lord. In this.
ಅಲ್ಲ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ.
ಇಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ ನೀವು.
ಅಲ್ಲ
I have to-
ನಾವು ಹೇಳ್ತಾ
I have
ಇದ್ದೀವಿ
to file.
ಅವ್ರ
my-
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ they are alienating the assets of the company. They have pledged the shares of the company as security.
I will just get the information and I
But
will.
till then you should not do anything.
Alla, in this case, my lord, I will get the instruction.
Very well. But in the meanwhile ಏನೂ ಮಾಡಂಗಿಲ್ಲ. ಯಾವತ್ತು ಹಾಕ್ತೀರಿ ಹೇಳಿ ಯಾವತ್ತು ಹಾಕೊಳ್ತೇವೆ.
Just-
Otherwise ನಾವು ಸಪೋಸ್ ಡಿಫೀಟ್ ಆಗಿ.
Yes, my lord. 3 days time may be granted.
Counsel for the appellant seeks a short period of 3 days for filing objections to IA number so and so filed by the respondents herein. Full stop. In the call this matter next week. And in the meanwhile,
May I make one more submission?
Ah.
I have already deposited 1 crore 10 lakhs. It's a suit for recovery of money. 3 crores is the decretal amount. 1 crore 10 lakh is already deposited.
whether you want to sell now.
No, my lord. I will get the information.
ಅದಕ್ಕೆ ಅಲ್ಲಿವರೆಗೆ ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಇನ್ ದಿ ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಜನವರಿ, ಸೆಕೆಂಡ್ ವೀಕ್ ಆಫ್ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ರಿಓಪನಿಂಗ್ ಆಫ್ ದ
It could be taken up in the next week itself, my lord, because I don't
ಬಹಳ
know.
ಟಫ್ ಇರ್ತದೆ, ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇರ್ತದೆ ಅದೆಲ್ಲ.
Because without
The
filing
meanwhile-
the objections, they have obtained the interim order now. Virtually,
No,
they got
no,
the order. my lord.
In the meanwhile, no transfer or no alienation shall be made nor encumbrance be created in respect of shares in question.
The suit schedule property, my
Suit
lord.
schedule
Suit
My
schedule.
lord, my submission, my lord, without hearing us, virtually they got the order. my lord.
You now
They should
tell
have
us,
served the.
do you want to sell the property till this order is passed on this? Suppose if you do that, where they should go?
It could be taken tomorrow itself, my lord. I will get the
Correct.
instruction.
Namagu
Without
time
getting the
ಬೇಕು.
instruction,
Call
they have
next week.
indirectly obtained the order, my lord.
Call. Call next week. Call. ಇದೇ ಆರ್ಡರ್ ಎಂಟ್ರಿ ಮಾಡು. Till next date of hearing, no income, no alienation nor encumbering of suit schedule property. LRs of appellant ವಕಾಲತ್ ಹಾಕ್ಬೇಕಲ್ಲ.
Yes, we will file it in the office.
Next.
Representing for petitioner, my lord.
Ah.
All office objections are complied, my lord, except translation.
ಆಗಿದೆಯಾ? Translation dispensed. All in the second week of January.
Probably.
Okay.
It's matter of
And what?
retrospective promotion and seniority, my lord.
Huh?
This may be ordered, my lord.
ನೋಡೋಣ
Please.
ಇಲ್ಲ second week of January. Okay. Yes, sir.
APA for the petitioner, my lord.
Ah.
Only rejected its application, rejected its objection,
and secure the petitioner next date appearing. That is the order, my lordship. In the,
Objections to 227.
please, my objection to main, KLJP, my lord.
Objections.
That is rejected and secure the petitioner next date appearing. That order is challenged.
ಅಲ್ಲ HBC ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
ಆಗಿಲ್ಲ. HBC ಟೈಮಿಗೆ ಕರೀರಿ ಅವ್ರು. ಅಲ್ಲಿ ತನಕ ಯಾಕೆ ಬೇಕಪ್ಪ? ಎಲ್ಲರನ್ನು ಕೋರ್ಟ್ನಾಗ ಇಟ್ಕೊಂಡ್ಬಿಟ್ರೆ ಕೆಲಸ ಮಾಡೋರು ಯಾರು? ಹೊಲದಲ್ಲಿ ಕೆಲಸ ಮಾಡೋರು ಯಾರು? ಫ್ಯಾಕ್ಟ್ರಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡೋರು ಯಾರು? HBCಗೆ ಕರೀರಿ. HBCಗೆ ಬೇಕಾಗತ್ತೆ ಅಕ್ಯೂಸ್ಡ್. ಆ ರೀತಿ ಮಾಡಿ.
ಇಲ್ಲಿ ನೋಟಿಸ್ ಟು R4 ಅಂತಿದೆ ಸ್ವಾಮಿ. ದಿ ಲಾಸ್ಟ್ ಅಡ್ರೆಸ್ ನೋನ್ R4 ಇದೆ ಅದು. ಸೊ ದಟ್ ಹಿ ಕೆನಾಟ್ ಬಿ
ಬಿಡಿ ಹೋಗಿ. ಅದಕ್ಕೆ HBCಗೆ ಅಪಿಯರ್ ಆಗಿ ಅಲ್ಲಿ ತನಕ ಏನು ನೀವು ಅಪಿಯರ್ ಆಗೋ ಅಗತ್ಯಿಲ್ಲ. ಹಿಯರಿಂಗ್ ಬಿಫೋರ್ ಚಾರ್ಜಿಗೆ ಅಪಿಯರ್ ಆಗಿ.
ಓಕೆ.
ಆ ರೀತಿ ಮಾಡಿದ್ದೇವೆ ನಾವು ಈಗಾಗಲೇ.
That is 15064 of 24.
ಬರ್ಕೊಳ್ಳಮ್ಮ. The challenge is to the order dated so and so made by special court under the established under the land grabbing act ಇದೆಯಲ್ಲ ಅದ್ ಮಾಡ್ಕೊ. So and so.
2000.
First, learned counsel for the petitioner. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ petitioners?
ಫೋರ್ ಪೆಟಿಷನರ್ ಒಬ್ರೆ.
Argues that setting criminal law in motion is not a child's play. Wide Pepsi Foods versus so and so 1998 SC 120, and this having not been borne in mind by the court below, comma, there is error apparent on the face of the record warranting indulgence of this court. First, learned AGA on request appearing for the official respondents opposes the petition, contending that in more or less similar cases, comma, the courts have declined indulgence, although after giving some reprieve. First, as an instance, he cites WP number between
15064
disposed of bias on.
2/12/24.
Next part, having heard the learned counsel for the parties and having perused the petition papers, we are inclined to grant a limited indulgence in the matter to the effect that the petitioner shall not be summoned personally in the matter, personally to appear in the proceedings in the court below till the stage of HBC is attained. First, all other contentions are kept open.
ಏನಾಗಿದೆ
Disposed of.
ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ದಿ ಎಂಟೈರ್ 70 ಸರ್ವೆ ನಂಬರ್ 70 ಆಫ್ ಯಶವಂತಪುರ ವಿಲೇಜ್ ಅಂತ ಹೇಳಿದೆ. ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನನಗೆ 52 ನಲ್ಲಿ ಗ್ರಾಂಟ್ ಆಯ್ತು 2 acres 3 ಗುಂಟ.
ಅದನ್ನ ನೀವು HBC ಅಲ್ಲಿ ಹೋದಾಗ ನೀವು ಹಿಂಗಾಗಿದೆ 227 ಸ್ಟೇಜ್ ಇದೆ ಇಲ್ಲಿ. ಆ 227 ಸ್ಟೇಜ್ ಅನ್ನ ನಾವು ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೇವೆ ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡಬೇಕು ಅಂತ. ಆ ರೀತಿ ಮಾಡ್ಕೊಂಡು ಡಿಸೈಡ್ ಮಾಡಿ.
ಎರಡೇ ಒಂದು ಸ್ಮಾಲ್ ಕಂಟೆನ್ಷನ್ ಮೆಲಾಡಿ ಇಸ್ ದಟ್
at that stage 27 3 20 24 is not even before first
one
even hearing before charge shall be accomplished in the presence of the law advocate representing the petitioners, dispensing with personal presence of their personal presence. Okay, ಏನಿಲ್ಲ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಟ್ರೀಟ್ ಮಾಡಿ ಇಟ್ಬಿಟ್ಟಿವಿ.
Subject to cooperation. Cooperation. Subject to cooperation.
ಅದರ್ ಕೇಸಸ್ ಅಲ್ಲಿ ಏನಾಗಿತ್ತು ಅಂದ್ರೆ there are three complaints filed against me. One of them. ಇನ್ನೊಂದು ಏನಾಯ್ತು ಅಂದ್ರೆ RNS ಮೋಟರ್ಸ್ ಒಂದಿತ್ತು, ಇನ್ನೊಂದು ಸ್ಪರ್ಶ್ ಹಾಸ್ಪಿಟಲ್ ಇತ್ತು. ಅದಕ್ಕೆ BBMP ಅವರು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದಾರೆ. ದೇರ್ ಇಸ್ ನೋ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇನ್ ಸರ್ವೆ ನಂಬರ್ 70 ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅದರಲ್ಲಿ. ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ those two cases were ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. I also belong to the same survey number of 70. I also belong to the same survey number. ನಂದು ಅದೇ ಸರ್ವೆ ನಂಬರ್ ಲೇ ಇರೋದು.
But you were not present when the
No, I was present at that particular day. I was present on that particular day. Subsequently,
ಆಯರ್ನಾದ್ರೂ ಒಬ್ಬ ರೇಟ್ ಅಲ್ಲಿ
subsequently also I have appeared before the court.
ಅಲ್ಲಿ ಲಾಯರ್ನ ಇಟ್ಟು HBCಗೂ ನೀವು ಬೇಡ, HBCಗೆ ಲಾಯರ್ಸ್ ಅಷ್ಟೇ ಸಾಕು ಅಂತ ಹೋಲ್ಡ್ ಮಾಡೇ ನಾವು ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ.
ಹಾ.
ಹಿಯರಿಂಗ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಸ್ಟೇಜಿಗೆ ನೀವು ಬೇಕಾಗಲ್ಲ, ಆಯ್ತಾ? ಅಲ್ಲಿ ಲಾಯರ್ ಇದ್ರೆ ಸಾಕು, ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಹೋಗೋದು ಬೇಡ. ಅದು ಆದ್ಮೇಲೆ ಇನ್ನು ಆರ್ಡರ್ ಆಗತ್ತಲ್ಲ, ದ್ಯಾಟ್ ಯು ಕ್ಯಾನ್ ಚಾಲೆಂಜ್ ಹಿಯರ್ ಅಂತ ನಾವು ಮಾಡಿದ್ದೇವೆ ಈಗ.
One my submission, my lord, is that when the BBMP itself have submitted to the court, there is no encroachment as far as.
ಅದನ್ನೇ ಹೇಳ್ಬಿಡಿ ಅವತ್ತು HBC ಅಲ್ಲಿ
ಹೇಳಾಗಿದೆ ಅದು. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಆಲ್ಸೋ ಹಾಕಿದ್ದೀನಿ ನಾನು.
HBC ಪೋಸ್ಟ್ ಆಗಿದೆ ಬ್ಯಾಟ್ರು. ಆರ್ಡರ್ ಅನ್ನು ನೋಡಿ, ಸ್ವಲ್ಪ ಆರ್ಡರ್ ಅನ್ನು ಓದಿ. It is posted for HBC and none was there from your side. Therefore, a court get a little annoyed and summoned you. All contentions are kept open for being urged at the stage of HBC, including the parity cases wherein accused have been set free. All right.
For the petitioner, connected the party.
6.1, I refer to Mr. Narayan Bhattan.
have filed.
In that matter, I am appealing for the additional respondents 71 to 76 not that. My friend actually think.
I filed tomorrow morning, I filed the amended petition, my lord.
Tomorrow morning you are filing.
Please. Amended cast title along with petition.
Amended cast title to be filed.
Filed.
File. Post this matter after amended cast title is filed.
ಅಲ್ಲ ಫೈಲ್ ಆಗಿದೆ, ಮಾರ್ನಿಂಗ್ ಮಾಡಿದ್ದೆ.
ಇವತ್ತು ಮಾಡಿರಾ?
ಮಾಡಿದ್ವಿ.
Today itself.
ಪ್ಲೀಸ್. ಅಲ್ಲ ಇವತ್ತು ಮಾಡಿದ್ದೆ.
Or 5 to or 13 not ordered.
My lord.
In 6.1.
My lord, regarding first matter, my lord, I filed a wakalat, undertake to file a wakalat, my lord, regarding the respond number 5 to 28.
5 to 28.
28.
Similar respondent in connected.
Same second matter also.
Learned counsel Shri so
Yes,
and
ma'am.
so
Yes, ma'am.
appears for respond numbers 5 to 28.
Yes, ma'am. 5 to 28.
28. ಬೇರೆಯವ್ರಿಗೆ ಏನಾಗಬೇಕು?
ಬೇರೆ they are the review applicants before the my lord tribunal. They are also petitioner like this.
ಯಾರಿಗೆ ನೋಟಿಸ್ ಮಾಡಿರಲಿಲ್ಲ?
ಎಲ್ಲರಿಗೂ ನೋಟಿಸ್ ಆಗಿದೆ. They are the contestant.
5 to 7, 15 to 78.
ಅವರೆಲ್ಲ ರಿವ್ಯೂ ಅಪ್ಲಿಕೆಂಟ್ಸ್ ಬಿಫೋರ್ ದಿ ಟ್ರಿಬ್ಯುನಲ್. ದೇ ಆರ್ ದಿ ಲೈಕ್ ದಿ ಪಿಟಿಷನರ್ಸ್.
ಅವ್ರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ ಏನು?
15 to 17.
ನಾನೇ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀನಿ ಸರ್. ಹೂ ಆರ್ ದಿ
ನೀವು ಮಾಡ್ತಿದ್ರಾ?
ಬಿಕಾಸ್
ಅವರನ್ನ
ಪ್ಲೀಸ್.
ಮತ್ತೆ ಅಲ್ಲಿ ಈ ಕಡೆ ಬರ್ತಾ ಇದ್ರಿ ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಗೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಅವ್ರಿಗೆ ವಕಾಲತ್ತರ ಹಾಕ್ಬೇಕಲ್ಲ?
ಹಾಕ್ತೀನಿ ಸರ್.
ಶ್ರೀ so and so appears for
ಬಿಒ ಅನಿಲ್
for respondent numbers 15 to 17 in companion WP 7440 of 2024. ಉಳಿದಂಥವ್ರಿಗೆ ಯಾರಿದ್ದಾರೆ? ಸರ್ ಎಲ್ಲರಿಗೂ ಸರ್ವಿಸ್ ಆಗಿದೆ. You also appear in connected matter.
Yes, ma'am.
ಯಾರ್ಯಾರಿಗೆ ಅದು?
5 to 28.
5 to 28 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಆಗಲ್ಲ. WP 782 ನಾಗ ಆಗ್ತದೆ.
ಅದು 5 to 13 ಇನ್ ಕನೆಕ್ಟೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ದೇ ಆರ್ ದಿ ಸಿಮಿಲರ್ ರೆಸ್ಪಾಂಡೆಂಟ್.
ಅವರೇ ಇದ್ದಾರೆ.
ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು.
ಶ್ರೀ so and so appears. ನೋಡ್ರಿ ರಾಘವೇಂದ್ರ ಅವ್ರು ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತದೆ ಬರ್ಕೋಬೇಕು. ಜಸ್ಟ್ appears for so and so so and so. Call immediately after vacation. Yes.
Date may. One date
ಬರತ್
may be.
ಇಮಿಡಿಯೇಟ್ಲಿ ಬರುತ್ತೆ. ಅವ್ರು ಕೇಳ್ಬೇಕು ಡೇಟ್. ನಿಮ್ಗೇನಿದೆ? ನಿಮ್ಗೇನು ರೆಸ್ಪಾಂಡೆಂಟ್? ಎಸ್. Keith Reddy, Mr. Reddy.
Petitioner's counsel. Very short point. on
ಏನೋ
the
ನಾನ್
app-
ಕಂಪ್ಲೇಂಟ್ಸ್ ಏನೇನಿದೆ?
But I'm told that has been attended to. If your lordships would like the registry to verify, I can have that done. But otherwise, what arises for consideration is a very short point.
Hmm.
Not on the applicability or otherwise of the Consumer Protection Act. But the complainants before the consumer forum,
ಕೊಡಿ.
please.
ಎಂಟ್ರಿ ಮಾಡಿದೆ ಅಲ್ಲ ನಿಮ್ಗೆ?
ಇದೆ.
Entry order to continue, call after vacation.
Very.
One respectable submission. So far as only as this petitioner is concerned, so ಬೇರೆಯವ್ರ ಮೇಲೆ execute ಮಾಡ್ತೀವಿ. So far as this petitioner is concerned.
Interim order so far as petitioners. ಎಷ್ಟು ಜನ ಇದೆ?
But the petitioner is only one, but the other persons are my directors.
Why you do you, they are not here.
No, that's right, but the only submission is please protect the director.
So far as petitioner is concerned.
Please.
Okay. Call application.
Lord, there's a question of jurisdiction, he may not be able to, that's why I'm not.
No, no.
Please.
Next.
But I am for the petitioner, Mila.
Commerce. Yes.
But I am for the petitioner, Mila.
Yes, Vijay Kumar.
Lord, the petitioner retired on 31/8/2010, my lord. On an audit report submitted in 2004 and 5, my lord, alleging that there is a shortage of 1,71,890, my lord.
Similar matter ನಾವು ಯಾವ್ದೋ ಟ್ರೀಟ್ ಮಾಡಿದ್ವಲ್ಲ, ಯಾವ್ದದು? BT ತಿಪ್ಪೇಸ್ವಾಮಿ ವರ್ಸಸ್ Karnataka State Adult Education Council, Justice Rajendra Babu's judgment. Audit objections are no ground ಅಂತ hold ಮಾಡಿದ್ದು.
Yes, madam.
Notice ತೊಳಿ ನೋಡೋಣ.
Yes, madam.
Lord, I had the benefit of interim order, my lord, before the tribunal. my lord.
ಮಾಡಿರ್ತಾ?
Yes, ma'am.
Lord,
The AG, learned AG is requested to accept notice.
he
for
admits that he is misappropriated, my lord.
Respondent.
He's also remitted that money to my lord.
No, no.
Remitted also.
Yes, my lord. Yes, my
ಎಲ್ಲಿದೆ
lord.
admission ತೋರಿಸಿ.
A2, my lord.
Page.
Lord, the remittance was made, recovery, it was recovered and remitted in 2005 itself, my lord.
Not
See.
4.
ಎಲ್ಲಿದೆ ಓದಿ.
104, my lord, page number.
Not 4. ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
In page 110, my lord.
ಪ್ಯಾರಾಗ್ರಾಫ್ ನೀವು ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಹೇಳ್ಕೊ? 50 ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ ಇದು. ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಂತ ಐಡೆಂಟಿಫೈ ಮಾಡ್ಬೇಕು. ಇಷ್ಟೆಲ್ಲ ಓದ್ಕೊಳಕ್ ಆಗ್ತದ ನಮಗೆ? ಗ್ರಿಟ್ ಇದು.
In page 110, my lord, last third paragraph, my lord. ಎರಡನೇ ಸಾಕ್ಷಿದಾರರಾದ ಶ್ರೀನಿವಾಸ ರಾವ್ ಇವರು ಒಂದನೇ ಆರೋಪದ ಬಗ್ಗೆ ನಿಶಾನೆ P2 ಮತ್ತು P21 ಉಲ್ಲೇಖಿಸಿ 1,71,890 ವ್ಯತ್ಯಾಸವಿರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ.
ಪೂರ ಓದ್ಬೇಕು. ಅಡ್ಮಿಷನ್ ಅಂದ್ರೆ
Yes,
ಆ ರೀತಿ ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಒಬ್ಬ ಮ್ಯಾನ್ ಆನ್ ದ ಸ್ಟ್ರೀಟ್ ಓದಿದ್ರೆ
it is,
ಇದು ಅಡ್ಮಿಷನ್ ಆಗಿದೆ ಅಂತ ಅನ್ಸ್ಬೇಕು.
ಅಲ್ಲ, it is
ಇನ್ಫಾರ್ಮ್ ಮಾಡ್ಲಿಕ್ಕೆ
it is in their pleadings also, my lord, that they have
ತೋರ್ಸಿ.
remitted.
ತೋರಿಸಿ.
In the pleadings, my lord.
ರೆಮಿಟೆಡ್ ಅಲ್ಲ, ಯು ಹ್ಯಾವ್ ರಿಕವರ್ಡ್.
We have recovered.
ಅದು
Allah, they have
remittance
paid that amount which they have misappropriated, my lord.
You have recovered it.
Yes, my lord.
That is not remittance. There is difference between these two. When remittance he makes, it will be volition. When you recover, it is compulsive.
Please, my lord. It is an application also, my lord.
Admission ತೋರಿಸ್ಬೇಕು. ನೀವೇನ್ ಹೇಳಿದ್ರಿ? You said that he has admitted
Yes, my lord. He has, my
misappropriation.
lord. He has, my lord.
Admit ಮಾಡ್ಕೊಂಡಾನ. We'll call this matter next week. Just
Please,
look into and
please,
point out.
Mark, please.
Learned AG
Let
is
there be an
requested to
interim
accept
order.
notice for respondents. Let us see. Call
I'll
next,
point out. my lord.
call next week.
Lord, till such time, let there be interim order.
No entry model. Next.
appears for the petition. The
Yes,
order, annexure F, my lord, page number 145. I've been a penalty of 4 annual increments to cumulative effect, or with deferring for 4 years, my promotion was deferred, my lord. That I challenge this order. By challenging this order, there are 242 days of delay. The Honorable Tribunal was pleased to allow the dismiss my application only on the ground of delay and lateness. Your lordship may kindly page the last page of the impugned order, page 160.
ಏನ್ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಏನಿದೆ?
ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಸ್ವಾಮಿ, ಅದ್ರಲ್ಲಿ ನಾನು ಕೋವಿಡ್ ಟೈಮಲ್ಲಿ ಬಂದು ಮೊದಲು ತಗೊಂಡೋಗಿ ಕೊಟ್ಟಿದೆ. ಕೋವಿಡ್ ಟೈಮಲ್ಲಿ ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟು ಅವರು ಕೊಟ್ಟಿಲ್ಲ, ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟಿದ್ದೆ. ದೆನ್ ಐ ವೆಂಟ್ ದಟ್ ಐ ಡಿಡ್ ನಾಟ್ ಫೈಲ್ ಅಂತ ಹೇಳಿದ್ರು. Then I taken the paper from the advocate and entered the matter to the other advocate.
COVID came to an end when? Started on 25/3.
ಅದೆಲ್ಲ ಆಗಿ 242 days ಇತ್ತು. ಅದು ಮುಗಿದ ಮೇಲೆ ಅವ್ರ ಹತ್ರ ಯಾಕೆ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಕೊಟ್ಟು. Then I taken the file log.
ಎಲ್ಲಿ explanation ಇದೆ? Explanation ತೋರಿಸಿ.
Explanation the IAM log.
You offered that.
In the IA.
IA ಇನ್ನ KT ಹಾಕಿತ್ತಾ?
IA before, yes, madam. IA before the Honorable KSCT.
Page number? ಡಿಲೇ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ.
ಹೌದು ಸರ್.
First question will be, where is the explanation ಅನ್ನೋದು?
Page number 126, madam. Page annexure B. Page number 126. 126, in page 126, annexure B. I filed the affidavit. Page number, the relevant paper entry is paper 128 onwards, not that.
ಟ್ವೆಂಟಿ 2022 ವರೆಗೆ ಎಕ್ಸಾಮ್ಷನ್ ಸಿಗ್ತದೆ.
ಹೌದು ಸ್ವಾಮಿ. ಅದು 200, ಅದು ಒಪ್ಪಿದ್ರೆ ಅದು I don't do that.
ಫೈಲ್ ಮಾಡಿದ್ದೆ ಅವತ್ತು.
Application was filed on
ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ KT ಅಲ್ಲಿ.
ಅಲ್ಲಿ 242 days delay. Some application was filed on.
Brother,
annexure A,
Brother Khan, 128 ಗೆ ಬನ್ನಿ. Para 4.1 ನೋಡಿ. 1/3/2020 ಇಂದ 28 February 2022 ವರೆಗೆ ಡಿಲೇ ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ.
Please,
ಬಿಕಾಸ್ ಆಫ್ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇದ್ರಾಗ ಹಿಂಗ್ ಡಿಲೇ ಆಗ್ತದೆ.
ಅಲ್ಲ ಇಲ್ಲಿ Lordship para 8 of AAT order. 153 on page 153.
153.
Para 8 discussion on that limitation.
15/3/2022, 28/2022, not read. Expired between 15/3/2028, notwithstanding the actual balance period. All persons shall have limitation period of 90 days in the event actual balance period of effect from greater than 90 days, that longer period shall apply. For extended 90 days. 1/3/2022 only. No, this may not be, this reasoning may not be correct. This reasoning of the tribunal runs counter to what the apex court said in 5 judgments relating to COVID.
No, only one submission was that. Where 2013-12 SEC, page 649, S.R. Pattaji, I refer relevant portion of the at page 1, sorry, my lord, yesterday I had some difficulty with my payment to my family, therefore I could not get the reply. Page number 23, your lordship, again, extracted the relevant portion of judgment. S.R. Pattaji.
Read section 21, how it is structured. 21.
21 is on par, but it is extracted, your lord. In the very same order.
Just
156, your lord. 156 ಅಲ್ಲಿ extract ಮಾಡಿ. Section 21.
In case where a final order is made, and 20 has been made in connection with the grievance, unless the application is made within 1 year from the date on which such final order has been made. Then one more section is left.
123, 121 subclass 3, subsection 3, that was not extracted. That is on par with sufficient cause. Section 5 of the Limitation Act. That was not referred to at all.
Petitioner who has suffered some punishment order was before the State Administrative Tribunal in application number 551 of 2023, calling the same in question. First, the tribunal denied relief to the petitioner on the ground of delay per se. First, next one. Learned counsel appearing for the petitioner vehemently argues that in matters like this, the delay should not figure as a factor at all, especially the COVID pandemic intervening and relaxation having been granted by the apex court for all the citizens in a wholesale way in the matter of limitation. First, he also points out that the tribunal selectively employed section 21 somehow not adverting to its other provisions, which otherwise would have come to aid of the petition. And thus there is infirmity in the order of the tribunal warranting interference of this court. First. Next paragraph. Learned counsel AGA on request appearing for the official respondents resists the petition, contending that the tribunal, having considered the matter of delay in an appropriate way, has denied relief to the petitioner, semicolon. After all, law will not come to the aid of sleepy and indolent, said Bentham. First, there being no proper explanation offered for the delay brooked, order of the tribunal denying relief to the petitioner cannot be faltered. First, so contending, he seeks dismissal of the petition. Having heard the learned counsel for the parties and having perused the petition papers, we are of the considered opinion that a legitimate cause brought to the court cannot be turned down on delay and laches. After all, section 21 provides for construing the explanation offered for the delay bit liberally, as held by this court in so and so, which is that judgment. Kulkarni, other day you argued that matter. That way, na? Which is that WP have to give now.
Yes, ma'am.
First, in considering explanation for condoning delay, merits of the matter also figures as one of the factors, which aspect has not been adverted to by the tribunal. First, after all, if delay was condoned, that would not have added merit to the case of the petitioner to the disadvantage of the other side. First, the apex court in 1967, 67, so it said like this. Next part. In the above circumstances, this petition having been favored, impugned order of the tribunal is set aside and the matter is remitted to the portals of the tribunal for consideration afresh in accordance with law on merits.
Second respondent is Loka, if I can this.
Alle, Loka, Prasanna Shetty. The cost made easy.
Sorry, Lord.
Next.
Sorry, Lord. They are their office subsection, not production of the translated copy.
It's all right. Translation not there.
Great.
Yes.
Section is a translated copy. Here A14 you are challenging suspension order, my lord.
Suspension order.
Yes, ma'am. On basis of disproportionate of property, my lord. The
Just
source.
percent.
Yes.
Just
Source
percent ಇದೆ.
230, 230%.
131 ಹೇಳ್ತಾರೆ source report ಅಲ್ಲಿ. In the impugned order ಮೇಲೆ 230. The source report are prepared on 13/6/2022, my lord. FIR was registered on 16/6/2022, my lord. Suspension order came to be issued on 4/3/2024. 1 year, 9 months, my lord. After that.
The list of properties ಎಲ್ಲಿದೆ?
List of properties, my lord.
In page 170, my lord. 170.
170.
Please, my lord. I beg a pardon, 145, my lord.
145.
ಅದು
source report.
170 ತರ ಕಾಣಿಸ್ತಾ ಇತ್ತು. I beg a pardon, my lord.
144 announced.
These are all agriculture.
147, 147.
145, 146, 147, all, my lord.
131%. And thereafter, I made a given statement submission 1/2/24, my lord. On 26/10/2023, my lord. Page number 192, annexure 812, my lord. I given reply to the Superintendent of Police, page number 192, annexure 812, my lord.
192.
Yes, my lord. The 210 onwards, my lord, relevant portion, my lord, property. my lord. 210. Roman.
ಡಿನೈ ಮಾಡಿರ ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಹೌದು ಅಲ್ಲ ಅನ್ನೋ
ಇಲ್ಲ,
ಬಗ್ಗೆ
ancestor property, my lord. My mother was sold the property in the year 2012, my lord. 1 crore 90 lakhs, my lord.
My lord,
I
it
have
is,
produced the annexure A1 to A3, my lord.
it is not his case that, my lord, his mother was living independently, my lord.
And
And
thereafter,
the
my lord,
amount, my lord, it is 4 crores 12 lakhs 50,000, my lord, 230% andre. And moreover, my lord,
annexure A4 and A5, my lord. The mother of the petitioner was gift deeded to the
district registrar, my lord.
wife, my lord. And one more, my lord, in the impugned order, my lord, they entrust the matter to the Lokayukta, my lord, Upalokayukta. 14 is contrary to the Kempaya judgment, my lord.
ಯಾಕೆ?
Disproportionate property is, my lord. The department
be.
has initiated, yes, my lord.
ಏನಂತ ಹೊರಡ್ ಮಾಡ್ಯಾರ ಡಿಸ್ಪ್ರಪೋರ್ಷನೇಟ್ ಪ್ರಾಪರ್ಟಿ
Yes, in the identical issues, my lord, page number.
No, my lord, that case is completely different. Kate has observed that, my lord. It is completely, facts and circumstances are
same
different. If my
similar-
lords may kindly see,
Please.
ವಿಚ್ ಇಸ್ ದಟ್ ಗಿವ್ ಅಸ್
its facts are completely different, my lord.
ಜಸ್ಟಿಸ್ ಸಂಜಯ್ ಗೌಡ್ರ ಸಾಹೇಬ್ರದ್ದ
Supreme Court, my lord. Yes. Sir, J&K.
ಕೆಂಪಯ್ಯ ಕೇಸ್ ನಾಟ್ ಅಪ್ಲಿಕೇಬಲ್ ಅಂತ ಹೇಳಿದಾರೆ KT.
ವಿಚ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸೇಸ್ 14A ನಾಟ್ ಇನ್ವೋಕೇಬಲ್
Para 8, my lord.
ಪ್ಯಾರಾ
8, my lord.
8
The definition of the word action, in section 2(1) reads under.
14A ಬಗ್ಗೆ ಎಲ್ಲಿದೆ
14, 7(2) is in observation notice. And in identical circumstances, annexure D, my lord, very same similar employee, my lord. Annexure D, my lord. Page number 253, my lord.
253
Yes. 253. The identical issues, the identical department employee, my lord. Approach the Belagavi Tribunal, my lord. The tribunal was set aside the suspension order, my lord.
ಅಲ್ಲ, ಅದು even
Relevant portion, my lord, annex, page number
ಆನ್ ವಾಟ್ ಗ್ರೌಂಡ್
268, my lord, para 19, my lord. Refer the Kempaya case. Para 19, my lord. 268, my lord.
19
Yes.
No, this is a case of this, in this also 14A is invocable or not is not decided.
ಅವ್ರು ಮಾಡಿಲ್ಲ ಇದರಲ್ಲಿ.
ಎಲ್ಲಿ?
ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ. 14A ಅದೇನು ಹೇಳಿಲ್ಲ ಇದರಲ್ಲಿ.
ಇಲ್ಲಿ ನಿಮ್ಮಲ್ಲಿ 14A ದಲ್ಲಿ ಇಂಟ್ರೆಸ್ಟ್ ಆಗಿದೆ ಏನು
ಹೌದು 14A ಮೇಲೆ ಇಂಪ್ಯೂಂಟ್ ಆರ್ಡರ್ ಮೇಲೆ.
ಕರೆಕ್ಟ್
Yes, 14A.
14A ಬಗ್ಗೆ ಇಲ್ಲಿ ಒಂದು ಸೆಂಟೆನ್ಸ್ ತೋರಿಸಿ ಈ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಕೆಂಪಯ್ಯ ಜಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಂಥ ಕೇಸ್ಗಳನ್ನ 14A ಕೆಳಗಡೆ ಮ್ಯಾಟ್ರ್ ಕೆನಾಟ್ ಬಿ ಇಂಟ್ರೆಸ್ಟೆಡ್ ಟು ಲೋಕಾಯುಕ್ತ ಅಂತ ತೋರಿಸಿ
ಇದರ ರೆಫರ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ಇದ್ರಲ್ಲ
And the suspension order after one year 9 months ಮೇಲೆ.
ಮಾಡ್ತಾರೆ ಮೊದಲೇ ಮಾಡ್ಬೇಕಿತ್ತು ಆಮೇಲೆ ಮಾಡ್ಯಾರ ಅಷ್ಟೇ ಅದು ಬರಲ್ಲ ಇಷ್ಟೆಲ್ಲ ಇದ್ಕೊಂಡು ಮತ್ ನಾವೇನಾದ್ರು ಅಬ್ಸರ್ವ್ ಮಾಡಿ ಈಗ ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡಿದಕ್ಕೆ ನಾವು ಅಬ್ಸರ್ವ್ ಮಾಡಕ್ಕಾಗ್ತದೆ ಅದರಲ್ಲಿ
Next week I will.
and moreover, my lord, suspension order.
No such question. Markal. The short question that arises in this case is as to whether misdemeanor of the kind can be entrusted to the Lokayukta under Rule 14 capital A of 1957 rule, CCA rules 1957. First, in support of his contention that such a reference cannot be made, counsel relies upon Apex Court decision in State of Karnataka versus Kempaya, 1998, 6 SCC 103, paragraph 6,
8 and 9.
8 and 9. And another, first up. He also draws attention of the court to a judgment of the KAT, page number another,
Page number 253, my lord.
dated 30 May 2024, entered in application number 10563 of 2024 between Sridhar BS versus state and another. First one. Next one. Learned AGA appearing for the official respondents opposes the petition, drawing attention to the list of, a long list of properties which the petitioner owns. And the same is stated to be what percent to
230%.
230% in excess.
131, my lord.
130 to 30.
131.
My lord, it is forthcoming in the
Where is that?
ಇಲ್ಲ, impugned order 230, my lord. In the source report, my lord, 131.
Anyway, impugned
impugned order.
Page number 147, my lord, first.
She also contends that the ruling cited before the court have not considered the entrustability of inquiry of the kind
Yes,
to the local.
loci.
First, we agree with this. We also agree with the reasoning of the tribe, therefore dismissed.
My lords, I may be permitted to withdraw my lords. Filing a
Counsel for the petitioner seeks leave of the court to withdraw the petition. Memo hakidra? Filing a memo. First, memo reads as that the respondents do not have objection for granting leave to withdraw. Correct?
ಇಲ್ಲ, mutually ಇಬ್ರು
In the above circumstances, petition is disposed of as having been withdrawn. Public. First made easy. Next. Naika Pandit.
Lord, this matter pertains to Ballari death case.
Yes.
My lord, may I make one request, my lord? All officials are in Belgaum, my lord, for session. We are unable to get their, so my lord, could it be taken tomorrow? They are coming back today, my lord.
ನಾಳೆ ಹಾಕ್ಬೇಕು ಇಲ್ಲ ಅಂದ್ರೆ
Yes, please, my lord, please.
One another development. Now they agree that the fault lies with the Karnataka State Medical Supplies Corporation. And on 8th, they have appointed a high power committee to look into the lapses in respect of supply and non-testing of drugs in the empaneled laboratories of the KSMs.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
ಅವ್ರದ್ದೇ ಆರ್ಡರ್.
ಅವ್ರದ್ದೇ ಆರ್ಡರ್. ಅಲ್ಲ, ಅವ್ರಿಗೆ ಮುಟ್ಟಿರಲ್ಲ, ನಿಮಗೆ ಮುಟ್ಟಿರುತ್ತೆ.
ಇಲ್ಲ ಇಲ್ಲ.
Tomorrow, at the request of learned DGA, file of petitions. Again on Monday. Monday. Okay. Monday.
ಬೆಳಗ್ಗೆ ಹೇಳ್ತಿದ್ರಿ.
ಅಲ್ಲ, ಬೆಳಗ್ಗೆ ಬೆಂಚೇ ಇಲ್ಲ. No bench. Okay.
Great.
Next.
Oblige.
Petition.
Yes, madam.
Will comply today itself, kindly.
ಏನದು compliance?
Office objection is there.
Office objection
If it's
being
not forthcoming.
insignificant, overruled. Overrule ಮಾಡ್ಬಿಡ್ತೀವಿ. Objection ಇದೆಯಾ? Overrule ಮಾಡ್ಲಿಕ್ಕೆ?
No. I have sought for mandamus.
Yes, sister, tell. ಏನಿದೆ?
It's a 2018 construction, my lord. It's a BDA matter.
BDA notice ಆಗಿಲ್ಲ. BDA notice ಆಗಿಲ್ಲ. Is contested response.
ಯಾರು appear ಆಗಿಲ್ಲ?
BDA.
Fresh matter notice. AG appears for response number 1. Panel counsel. See, Ajay Kumar. Panel counsel is requested to accept notice for response 2 and 3.
It may be taken up tomorrow, my lord.
Why?
Tomorrow bench ಇಲ್ಲ.
There is,
So much urgency.
because there is a threat of demolition. I have sought for interim order.
Demolish ಮಾಡ್ತೀರಾ?
ಅವರು
Okay.
BDA.
Till next date of
Then
hearing, no
please.
precipitatory action shall be taken in respect of subject building.
Oblige.
Yes, sir. Urgency ಏನ್ರ ಇದೆಯಾ? ಏನ್ urgency ಇಲ್ಲ. After vacation call ಮಾಡಿ.
Urgency ಅಂತ ಹೇಳಕ.
Call this matter. Entry ಮಾಡಿದ್ಯಾ? Entry ಮಾಡಿ.
Favor my lord, I have moved the matter. That's why.
After vacation ಮಾಡಿ. Call immediately after vacation. Okay. Next.
Appear for the petitioner.
with your lordships. ಕಂಪ್ಲೈನ್ಸ್ ಇದನ್ನ ಮಾಡ್ಬೋದಾ ಕಂಪ್ಲೈ ಮಾಡಿದಾರ ಸರ್ ಅದನ್ನ ಕಾಣ್ತದೆ ಸರ್ ಸರಿ ತೆಗೆದ
With your lordship's permission, my lord.
ಇದೆಯಲ್ಲ ಸರಿ ಓಕೆ ನೆಕ್ಸ್ಟ್ ಎಸ್
With your lordship's permission, my lord.
ಎಸ್
I appear, my lord, for the petitioner in item number 15, my lord.
15
My lord, now, my lord, this is a consumer case where, my lord, the respondent number 1 is the complainant, my lord. My lord, I am a bank, my lord. I have given, my lord, a OD loan of 50 lakh rupees to the complainant, who is a jeweler, my lord. He is running business from 2 shops, my lord. One shop is numbered 4108 and another one
issue emergent notice and interim order as prayed for.
Much
Till next date of
deeply
hearing.
obliged.
Yes, next.
Deeply obliged, my lord.
Much the limit for
Okay, for the petitioner's counsel.
yes sir.
Very peculiar situation.
Ah.
The claimant in an arbitration is a public sector undertaking. There is a tender floated, some part of the contract was given to me. Because of COVID, I was not able to perform some part of it because the supply had to come from China. These are for solar, my lord, cells of this
Solar panels.
Solar panel cells, my lord. All of the world gets them only from China. There was obviously very badly hit during, my lord, the pandemic. Therefore, there was a escalation. Now, my lord, my rival suppliers also procure from China. They also had the same problem. The PSU would terminate and then make a claim for the differential, that is the difference between what I was given the contract at and what
Other
the
side says.
other is subsequently given. I asked for that information even prior to the arbitration under right to information. That is denied to me on the ground of section 81D of, my lord, the RTI Act. Your lordship, may please have a look at page 133 of the petition.
820 apply ಆಗ್ತದಾ
It does not apply according to me.
apply ಆಗಲ್ಲ ಅಂತ
ಆಗೋದಿಲ್ಲ.
ಮಾಡಿದ್ರು
In fact, it gets even better.
that's what
In the arbitration, I make an application for discovery of those documents under the Karnataka Arbitration Center rules as well as, my lord, Arbitration Act. and
what the
Contempt.
tribunal said.
Tribunal said, no, before the tribunal, respondent would say these are public documents in the statement of objections. Tribunal doesn't consider any of this, my lord, is my grievance. Now,
Where is the order of the
my
tribunal?
lord, please be kind enough to come to, it begins at page, my lord, 47, Annexure A. This aspect is not noticed at all, my lord, by the Honorable Tribunal. They would simply say that,
The emergent notice interim order as prayed for.
Lordship, great.
Which is that Justice Kumar's judgment.
Lord, I'll place it. There is one other aspect for the Lordship's consideration. Under section 42A of the Arbitration Act, proceedings are anyway confidential. That is what, my lord. Great.
Yes.
I'm grateful to your lordship for I'm doing.
List was given the other day. What happened to the list of 150 minus 15 minus 15?
I sincerely apologize, my lords. One submission, factual submission, my lords. Before the company went into liquidation in the year 1996 itself, they were no longer employees of the company. Because in the year 1994, from the original management, my lords, one Sri Ram Nivas Goel purchased the entire shares of the company. At that point in time, all these employees came to be retrenched. And therefore, my lords may kindly see for a moment.
No, that's all right. But
The order passed in the review petition also, the learned senior counsel then makes a submission, my lords.
that whether that amounted to transfer and therefore transfer compensation should be given or not was the subject matter. Court said that does not amount to transfer of undertaking.
Transfer of undertaking, very
If
well.
that is so, they would continue in employment.
Now, my lords, what the court in fact held in the labor petition, my lords, the learned single judge held that all these aspects of retrenchment and their compensation would have to be decided by the Industrial Disputes Tribunal in terms of section 33, subsection 2 of the ID Act. Now, therefore, my lords, may kindly see the order that is impugned.
Justice
review
Anand Bhaira
petition.
Reddy's, Justice Anand Bhaira Reddy's
ಹೌದು,
review order.
ಹೌದು. ಅಲ್ಲ, ಅದರಲ್ಲಿ ರಿವ್ಯೂದಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರುವಂತದ್ದು
ಅದೇ
11th
last-
April 2016.
Last paragraph ಓದಿ.
ಹೌದು ಸ್ವಾಮಿ. At
ಅದರಲ್ಲಿ
page number 5, page 43 of the appeal memo.
you said there is a submission made that they would be taken up in
ಅಲ್ಲ,
employment.
ಅದಕ್ಕಿಂತ ಮುಂಚೆ ತಾವು ಸ್ವಲ್ಪ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ.
ಯಾವ್ದು?
The
43,
page 43 at the very top of the page. In page 43.
Yes.
The learned senior advocate Sri so and so would however submit that large number of workmen petitioners are qualified workmen who are capable of rendering useful service to the respondent company, and they should be permitted to make their applications seeking employment with the respondent company, which means to say, my lords, even the learned senior counsel at that point in time knew very well that they were no
not
longer
employed.
employees. ಅದಕ್ಕಾಗಿ ಅವ್ರಿಗೆ ಅಪ್ಲಿಕೇಶನ್ ಸೀಕಿಂಗ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಕೇಳಿದ್ರು. ಅದಕ್ಕಾಗಿ then the submission to that made by this particular respondent, my lord, says she so and so on this would submit that if such applications are made and if they are qualified workmen, the company would not be averse to consider the case for employment. That is an important aspect to be taken note of, my lords.
They did not make any application.
Adadmil, pursuantly, they have not made any application. Rather, my lords, what has happened, they have challenged this review order in this particular OSA. Initially, my lords, also, if your lordship sees, the labor petition, they were granted a liberty to go before the Industrial Disputes Tribunal seeking whether their retrenchment is illegal and whether they are entitled to those back wages also. They do not do that. They challenge that in a writ appeal which comes to be dismissed both on merits as well as on the ground of delay. Against that, my lords, they approach the labor commissioner. The labor commissioner takes a view that they are not entitled, and he also does not entertain their particular petition in terms of section 33 subsection 1 of the ID Act. All these years, my lords, they have sat on their rights. They have not made use of the liberties granted by this honorable court. And in fact, the other company applicants, my lords, for a moment, please see their conduct. Now, it is not the case that they have come before this honorable court only after 8 years. Previously also, my lords, these company applicants were part of all those petitions pending before the learned single judge of this honorable court in those labor matters as well. There they were siding with the union. For a moment now, they make this particular application just as a safety net, my lord. So in the event that this particular appeal gets dismissed, then they can agitate their rights individually. In all these matters, my lords, my humble submission to your lordships is they are collusive in nature. Our employees ಆಗಿರ್ಲಿಲ್ಲ 94ನೇ ಇಸ್ವಿನಲ್ಲೇ ಅವ್ರದ್ದೆಲ್ಲ ಮುಗ್ದೋಗಿತ್ತು. 96ನೇ ಇಸ್ವಿಲಿ the company enters into liquidation for the first time. The question of them being employees of my company when the company entered liquidation does not come. Therefore, 529A of the Companies Act is also not applicable, is my humble submission, my lords.
Anyway, if they apply.
One minute,
to
ma'am.
consider
This statement is not prepared today. This statement is available with the company and it was presented immediately. And they did not file an application. They gave this statement. These are the employees eligible and given. They have not answered. Number one. Number two is, we have given to you already. Second thing is, the company has gone into liquidation, come out of it. Then it wound up, it has come out of it. The scheme is sanctioned, they have come out of it.
But you wanted liquidation only.
Yeah, yes, my lord. We have.
Is it not an unconscionable stand of the
My
employee?
lord educated me on 529A and scope by saying that it is not applicable to the present case, and I shut more.
No, not only that. That you are very fair. We understand that. See the conduct of the workmen. They wanted winding up of the company. That ship in which they were sailing, they wanted to put hole into that.
My lord, this case is
fully,
no, the
along
case-
with others.
I don't want to use the word the bar. The case is wholly mismanaged. That's only one word I can say because too many
But
persons are involved.
What
and-
Samit says, of course, this other day you did not point out.
I
we also-
apologize, my lord.
It's all right, no problem. See, they should be permitted to make their application seeking employment with the respondent company.
Yes.
They offered some concession. Even that you have not made use of. And having, you will see the conduct of the workmen. They want company to be wound up. And now they say, no, we should be given employment. Is it not unconscionable on their part to seek employment? But anyway, whatever has happened, happened. If they make application, what is the problem in
Now,
considering?
Three aspects, my lords. The company was ordered to be revived in the year 2016. The company's entire factory, if your lordship sees the order passed by your lordships in the writ petition directing the KIDB to execute the sale deed, the entire factory premises was demolished when it was in the custody of the official liquidator because illegal activities were happening in the factory, dilapidated factory ಅಂತ ಹೇಳಿ 2015 when it was still in the possession of the official liquidator before he handed over possession to me, the entire factory building was demolished. All that stood, kindly see, my lords, your lordship's order in the year, ನಾನು ಒಂದು ಕಂಪೈಲೇಷನ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಲಾಸ್ಟ್ ಹಿಯರಿಂಗ್ ನಲ್ಲಿ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ರೆಲೆವೆಂಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಹೇಳಿ ಅದರಲ್ಲಿ ಪೇಜ್ 16 ನಲ್ಲಿ ಹೌದು
Where is that?
At page 27, my lords, paragraph F. The last but fifth line, if your lordships kindly sees. Last but fifth line at paragraph F. During the long-drawn legal battle of winding up proceedings, plant and machinery became dysfunctional and the structures too dilapidated is admitted by the KIDB at paragraph so-and-so of the order. And therein, my lords,
Really, where have you read that?
I apologize, my lords.
Page?
ಅದರಲ್ಲಿ
Dilapidated 27.
dilapidated ಅಂತ ಹೇಳಿ ಹೇಳುತ್ತೆ. But I apologize because in that writ petition, one of the averments made, my lords, I'm very sorry because I also represented the respondents in that writ petition. ಅದರಲ್ಲಿ ಒಂದು ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ 2015ನೇ ಇಸ್ವಿನಲ್ಲಿ ಅದು
ಇಂಡಸ್ಟ್ರಿ ಇಲ್ವಾ ಈಗ?
ಇಂಡಸ್ಟ್ರಿ ಇಲ್ಲ, ಅದರಲ್ಲಿ ಖಾಲಿ ಲ್ಯಾಂಡ್ ಇದೆ. Now what has happened subsequent to that?
Intend to start industry?
Did not take off. Not aspirin tablet is not produced. It's estate dealing. He has become estate dealer, nothing else.
No, but where is the obligation on the part of that? We may sympathize with the workmen is one thing. But see the conduct of the workmen. They want to see the company being wound up, unmindful of what is going to happen to them, standing on the branch of a tree and cutting the branch itself. That is one conduct. Number two, what legal right emanated from the observation of the review court? They said,
I have understood, my lord. I will save the time of the honorable court. Let the order seek review, division bench sent it seek review. We sought review on various grounds. I think I should make use of the fact that Mr. Subrao is not the person to give up any ground. And here argue, none of the contentions is considered in the order of review by Justice Honorable. He would raise, Kasturi would say this, Subrao would say this, do this. This is how. There is no determination of the list in the review petition.
where have you taken up a contention that contentions urged before the review court were not addressed? Where is that contention?
It's
Which contention?
no, it's
you
a
have
weighty
taken?
observation of the honorable court. The situation is this, my lord. I used the word earlier. I shouldn't repeat it.
ಆ contention ಇದ್ರೆ
see,
all contentions we had urged. The review judge did not consider ಅಂತ ಎಲ್ಲರ ಆ ಅರ್ಥ ಬರುವಂತ ನಿಯರ್ಲಿ ಮೀನಿಂಗ್ ಆಗುವಂತ ಒಂದು ಸ್ಟ್ಯಾಂಡ್ ಅಂತ ತೋರ್ಸಿ.
I'm feeling the presence of Subrao around and Kasturi. So therefore, Mr. Kasturi would show it to the left and Subrao would show it to the right. And in the bargain, the workmen have gone down.
And kindly come to page 43 now. 43 of Justice Anand Vairalreddy Sahib's judgment.
That is Justice
Page 43 of the appeal memo.
the order and review.
Order and review. Kindly come.
Learned senior advocate. Sri
So and so.
Subrao would however submit that it would however andre that adverb is used for this reason.
ಅಲ್ಲ ಓದೋಣ ಓದ್ಕೊಳ್ಳೋಣ ಆಮೇಲೆ ನಾವು
ಬಾಕಿದೆಲ್ಲ ಹೋಯ್ತು ಅದರಿಂದ ಇಲ್ಲಿ ಅಷ್ಟೇ. Submit that the large number of workmen petitioners are qualified workmen and who are capable of rendering useful service to the respondent company and that they should be permitted to make their application seeking employment
with the respondent company.
With the
You should
respondent
apply seeking employment. Correct?
I am prepared to accept that it's capable of being giving the meaning fresh appointment.
You are fair.
I admit that,
Absolutely
madam.
fair.
Fresh appointment.
Right.
And they should be permitted to make their applications seeking employment with the respondent company.
Yes, 1 second. When will you seek employment? When you are not in employment?
We gave this statement. We gave this was not prepared yesterday or today. This was given at that time. ಓರಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ ಈ ಯೂನಿಯನ್ ಲೀಡರ್ ಒಂದು ಅಫಿಡವಿಟ್ ಹಾಕೊಂಡು ಹಾಕ್ತೀನಿ ಅಷ್ಟೇ ಅಷ್ಟೇನಿಲ್ಲ.
ಅಲ್ಲ ಕರೆಕ್ಟ್. ಬಟ್
ಇದೇನೇ-
see the order, how that is structured, whether it warrants our interference or not in appeal is the question. They, again, we repeat, see the stand of the workmen. They wanted this company to be wound up. And anyway, many will be ignorant sometimes. These things happen, whichever way. This judgment gave some window, if not window, a ventilator, if not a ventilator, a keyhole to you. Where have you made use of this?
In a land acquisition case, my lord has used the word when doors are closed, that should be a chance for peeping through window ಅಂತ ತಾವು ಹೇಳಿದಿರಿ. ಅದನ್ನ I am aware of it.
ಇದನ್ನು ಅವೈಲ್ ಮಾಡಿಲ್ಲ ನಾವು. At least ಎಷ್ಟು ಜನರನ್ನು ತಗೊಳ್ಳಿಕ್ಕೆ ಆಗ್ತದೆ ಇಂಡಸ್ಟ್ರಿ ನೀವು
No,
ಸ್ಟಾರ್ಟ್
Manoj,
ಮಾಡಿದ್ರೆ.
I'm yet to start the commencement of production or erect structures.
ಯಾವಾಗ ಸ್ಟಾರ್ಟ್ ಆಗಬಹುದು?
Now, my lords, because of the passage in time, may I just submit in 3 minutes, my lords, I'll submit the facts that have happened after 2016. May I just, my lords? In 2016, the scheme comes to be approved, my lords. The sale deed, lease cum sale agreement does not transfer into a sale deed by the KADB until
Approached High Court and we made the
Indeed,
order.
my lord.
all that.
In the year 2023, that order came to be passed. That is as of last year, my lord.
Correct.
In between that, the land acquisition by the KADB itself was challenged. Your lordship sitting in the single bench, my lords, had in fact negative the challenge laid by the so-called landowners, my lords. And subsequently, only in the year 2024, my lords, this year, the Honorable Division Bench, my lords, the coordinate bench has upheld your lordship's order and stated that the land acquisition proceedings were perfectly legal. Therefore, my lords, only now I have been able to get hold of the land that is in question. Now I have to commence production. I'm yet to satisfy the debts of various other creditors, my lords, that I have borrowed for this prolonged period of time from the year 2012 when I filed my application seeking for revival until now. For the last 12 years, my lords, I am in court continuously trying to fight all the litigations that have been raised on one account or the other. This litigation, my lords, is espoused by the workmen. Initially, the very first thing that they said is, do not wind up the company, we will revive. Then if your lordships have already seen Justice Bopanna's order, his lordships has observed that despite giving them an opportunity, they do not present any tangible scheme for approval. ಕೊನೆಗೆ ಆ ಶೇರ್ ಹೋಲ್ಡರ್ಸ್ ಮೀಟಿಂಗ್ ನಲ್ಲಿ ಕೂಡ ಇವ್ರನ್ನ ಅಪ್ರೂವಲ್ ಆಗೋದಿಲ್ಲ.
All right, we have understood everything.
I understand.
Whatever has happened, happened. When are you going to start your industry? to consider their application. ಎಲ್ಲರನ್ನು ತಗೊಳ್ರಿ ಅಂತ ನಾವು 145
ಹೌದು.
ಜನರು ನೀವೇನು ಎಸ್ ಟಿ ಬಸ್ನೇ ತುಂಬಿಕೊಂಡು ಹೋದಂಗಲ್ಲ. ನೋಡ್ರಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ, ಅಪ್ಲಿಕೇಶನ್ ಸೀಕಿಂಗ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ they will make up on merits and qualification. See
Understood.
how it is structured.
I understand.
ಅಲ್ವಾ? ಎಲ್ಲರನ್ನು ಕೆಲವರು ತಗೋಬೇಕಾ? ಎಲ್ಲರನ್ನು ತಗೊಳೋದಾಗ್ಲಿಕ್ಕಿಲ್ಲ, as of because no right arises as such arguably.
I understand.
Arguably, we are holding in your favor. We are assuming in
I
your
understand.
favor. This industry ಆದ್ಮೇಲೆ, rightly or wrongly, sometimes the union leaders will take some wrong decision, or sometime it may be wise also. We will not be able to catch what actually they want ಅಂತ ಏನೇನೋ ಆಗ್ತಿರ್ತದೆ. ಈಗ ಅಟ್ಲೀಸ್ಟ್ ಕೆಲವರಾರು ವರ್ಕ್ಮೆನ್ಗಳನ್ನು ನೀವು ತಗೋಬೇಕಾ? ಯಾರನ್ನೂ ಮನೆ ಬೇರೆಯವ್ರನ್ನ ತಗೊಳ್ಳೋ ಬದಲು ಇವ್ರನ್ನ ತಗೊಳ್ಳಿ ಅಂತ. That is the impression you have given to the court.
If and when the industry actually commences, my lords, we will be able to consider their applications once they make their applications. Now, what has happened in the interregnum, because there were so many creditors upon me once again after the scheme was approved, I had to part with a portion of my land to several industries, my lords. About 7 different industries have purchased portions of that land. About 42 acres of land is there.
ಎಷ್ಟು
Out of
ಎಕರೆ
which,
ಮಾರಿದ್ರಿ ಈಗ?
given to
They have sold. They have sold.
How many acres?
about, I'm given to understand 30 acres, my lords. I'll make my concrete submission in some
Out of
42 acres, my lords.
42 acres. ಎಷ್ಟು
Take
ಎಕರೆ
all, all
How many acres you have retained now?
about 12 acres to retain,
ಎದ್ರ ಸಲುವಾಗಿ?
my lords.
For what purpose? Industry only.
Industrial, I cannot do it, do any other
Anything
purpose.
else?
Because it stands in a KDB industrial area. I cannot use it for any other
Anything.
purpose.
So you are going to establish the industry.
Industry.
ಅವಾಗ ನಿಮ್ದು ಎಷ್ಟು ಜನರನ್ನ ತಗೊಳ್ಳಿಕ್ ಆಗ್ತದೆ ಅಷ್ಟು ಜನರನ್ನ ತಗೊಳ್ಳಿ. ಕನ್ಸಿಡರ್ ಮಾಡಿ. ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಅವ್ರು ಏನೇನು ರಿಕ್ವೈರ್ಮೆಂಟ್ ಇರ್ತದೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. You consider for employment because you have given that impression to the court.
I understand, my lords. I do not want to renege back from the, I do not want to
That's
renege back
fair
from the
on your
undertaking.
part.
I do not
Very
want to.
fair on your part to say all this. But we don't say all 135%. ಯಾರ್ಯಾರು ಎಲಿಜಿಬಲ್ ಇದ್ದಾರೆ, ಕ್ವಾಲಿಫೈಡ್ ಇದ್ದಾರೆ, ಅವ್ರನ್ನಾರು ತಗೋಬೇಕಾ in terms of real intent of this order?
The same type of industry or different industry?
I apologize, my lord.
ಯಾವ ಟೈಪ್ ಇಂಡಸ್ಟ್ರಿ? ಮೊದ್ಲಿದ್ದಂತದ್ದು ಬೇರೆ ಇಂಡಸ್ಟ್ರಿ ಮಾಡಿ.
ಬೇರೆ ಇಂಡಸ್ಟ್ರಿನೇ ಮಾಡ್ಬೇಕಾಗಿ ಬರಬಹುದು. ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ the pollution that this industry causes, my lords, with the present environmental norms, I am given to understand and I am instructed to say, my lords, that I cannot establish the same pharmaceutical industry or the chemical industry itself. It may have to be a industry of a different kind. Therefore, my lords, I will consider once the industry is put up, then certainly I can consider. Now, my lords, when I have not even laid a single brick on the land.
That's why.
I am still satisfying the debts of various creditors that I have already borrowed. My difficulty is that, my lords, because of these long drawn litigations, the scheme which came to be approved in the year 2016 has not been able to be successfully implemented because of the continuous litigation. I am being disabled because of this slew of litigations. There were interim orders passed at every stage. And here also, my lords, in the year 2022,
ಆ ಕಡೆ ಇದ್ದೇನೆ.
one last submission, my lords.
ಅಲ್ಲ, ಈಗ ನೀವು ಯಾರ್ಯಾರು ಈಗ ಮಾರಿದಿರಲ್ಲ ಲ್ಯಾಂಡ್,
ಹೌದು,
ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ?
ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ ಸುಮ್ಮನೆ.
ಅವರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಕೆಲವ್ರನ್ನಾದ್ರೂ ಇವರಲ್ಲಿ ಇರುವಂತವ್ರನ್ನ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್
ಅಲ್ಲಿ ಅದಕ್ಕೂ ಕೂಡ ಒಂದು ತಡೆ ಇದೆ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಹಳ್ಳಿಯವರು, they have been continuously interfering with the possession. They have not allowed to lay a single brick on the land. OS 523 of 23 and OS 36 of 24 are still pending before the Dodbalapura court, my lords. There is still an impediment. I am unable to revive it after taking all the risks in the year 2000, from the year 2012 onwards. Till date, I am unable to lay a single brick because of this. One issue or the other, continuously. Those two injunction suits, I am given to understand, my lords, are still pending.
ಅಲ್ಲಿ ಇಂಜೆಕ್ಷನ್ ಸಿಕ್ಕಿದೆಯಾ?
ಅಲ್ಲಿ ಎಕ್ಸ್ಪಾರ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಆಗಿದೆ ಸ್ವಾಮಿ. 2 ಸೂಟ್ ನಲ್ಲೂ ಎಕ್ಸ್ಪಾರ್ಟ್ ಇಂಜೆಕ್ಷನ್ ಆಗಿದೆ ಅಂತ.
ಹೆಂಗೆ ಇಂಡಸ್ಟ್ರಿ?
The net result is
My cause of action has not arisen. ಅಲ್ಲ, ಹೆಂಗಿದೆ, ಯಾವ ರೀತಿ ಇದೆ?
I am to file application only when they start the industry. When they have not started the industry.
They cannot start because villagers are not permitting. They have filed the suit.
Their submission have cuts both ways.
The effort was made by the earlier erstwhile owner of the industry and subsequent persons, and he tried to sell it off and do it. All along, at one point of time, you wanted to cut off
Everything.
ಅದು
I understand.
ಕೋಳಿ ಬಂಗಾರ ಮೊಟ್ಟೆ ಇಡ್ತಿತ್ತಲ್ಲ, ಆ ತರದ ಕತೆ.
ಹಾಗೆ ಈಗ ನಮ್ಮ ಪರಿಸ್ಥಿತಿ ಹೇಗಿದೆ
ನೋಡಿ, ಇಂಡಸ್ಟ್ರಿ ಬಂದಿದ್ರೆ ಎಷ್ಟೊತ್ತಿಗೆ
ಕ್ಲೋಸ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀವಿ, ವೈಂಡ್ ಅಪ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀವಿ.
ಎನಿವೆ, ಇಂಡಸ್ಟ್ರಿ ಬಂದಿದ್ರೆ ಎಷ್ಟೋ ಜನರಿಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಆಗ್ತಿತ್ತು. ಈ ಕರ್ನಾಟಕದ ನೆಲ ಜಲ ಎಲ್ಲದಕ್ಕೂ ಸಹಾಯ ಆಗ್ತಿತ್ತು. ಇಂಡಸ್ಟ್ರಿ
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಬಿಟ್ಬಿಟ್ಟು ತಾವೇನಾದ್ರು ರಿಸಾಲ್ವ್ ಮಾಡ್ಬೇಕಷ್ಟೇ, ಇನ್ನೇನು ಆಗಲ್ಲ. ಇದಕ್ಕೆ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಅಂಡ್ ಟೆಕ್ನಿಕಲ್
ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಆಗೋದಿದ್ರೆ ಆಗುತ್ತೆ.
ಅಲ್ಲ, ಇದು ಅಪ್ಲಿಕೇಶನ್ ಈಗ ಯಾವ್ದು ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿಲ್ಲ.
ಸ್ಟಾರ್ಟ್ ಮಾಡೋದು ಹೆಂಗೆ? ವಿಲೇಜರ್ಸ್ ಬಿಡ್ತಾ ಇಲ್ಲ, ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ.
And you,
what they should do?
And you are sitting aloof and seeing the tamasha.
ಅಲ್ಲಿ ನೀವು ಹೋಗಿ ಅಟ್ಲೀಸ್ಟ್ ವಿಲೇಜರ್ಸ್ ಬರೋರಿದ್ರೆ ಅವ್ರಿಗೆ ತಡೆಗಟ್ಟಿ
ಪರಿಸ್ಥಿತಿ
ಇದನ್ನ
ಅಲ್ಲ, ಉಗುಳು ಹಾಗಿಲ್ಲ, ನುಂಗು ಹಾಗಿಲ್ಲ. ನಾವು ಅಲ್ಲ, ನಮ್ಗೆ ಈಗ
you are seeking your pound of flesh.
ಇಲ್ಲ, ಭಿಕ್ಷಾ ಬೇಡವರು ಪಾಯಸ ಕೊಡಿ ಅಂತ ಕೇಳೋ ಹಾಗಿಲ್ಲ. He who begs cannot insist on ಪಾಯಸ. ಹಳಸಿದ ಅನ್ನ ಕೊಟ್ಟರು ತಗೊಂಡೋಗ್ಬೇಕು ಅವನು.
ಅಲ್ಲ, ಅವಾಗ ಇಂಡಸ್ಟ್ರಿ
I think we should not break bones here. ತಮಗೆ ಬಿಟ್ಟಿದ್ದು evolve a scheme, kindly evolve a scheme so that all are protected. First, the company is protected, because if the company exists, if the company exists, we can exist, otherwise not.
ಆ ಜಾಣ್ಮೆ ಈಗ ಬಂದದೆ, ಅದು ಇಷ್ಟು ವರ್ಷ.
ಈಗ ನಾವು ಆ ಸ್ಕೀಮ್ ನ ಅದ್ ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ಅದನ್ನ ಹೋಗೋದ್ರೆ ವಿಧವೆ ವಿವಾಹ ಮಾಡಿದಾಗ
ಸೂಟ್ ಡಿಗ್ರಿ ಕಾಪೀಸ್ ಇದಾವನ, ಇದು ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಕಾಪಿ ಇದಾವ?
I will just submit my notes. Is fine.
They have time.
I will just submit in 5 minutes my notes. I will get.
Yes. Mr. Shankar, kindly be seated. He wants to argue. Party wants to argue the matter.
Directly the action will hand over all the belongings to the respondent number 2. This is actually handed over all the belongings to the petitioner. That is land building machinery, plant and machinery. After taking the possession of the land building plant and machinery, he sold all the machineries and dismantled the infrastructure. After that, he demolished the buildings.
Who demolished?
The performer.
No, they were in fact, there is a order, my own order saying the building was dilapidated and it is removed by the KDB.
Only part of the missionaries are stolen. So all the missionaries were sold by.
ಈಗ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ನಿಮ್ ಪರವಾಗಿ,
ಹೌದು,
ಮತ್ತೊಂದು ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೆಯಲ್ಲ.
Was in dispute by farmer. Other part of 20 acres was not in dispute till to them.
Anyway, the farmers lost their case in appeal. Farmers, landowners lost their case in acquisition matters even before the appellate court.
They paid only for 22 acres that you can talk. Not part of other part of 20 acres. So in other 20 acres of land, they could have started longer.
ಹಂಗಾಗಿ ಈಗ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತೀರಿ? ಈಗೇನ್ ಮಾಡ್ಬೇಕು ಅಂತೀರಿ? ಈಗ ವೈಂಡ್ ಅಪ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು.
Other part of land also they wanted to sell. That's why I am asking not to sell the land and also.
ಯಾವ ರಿಮೈನಿಂಗ್ ಲ್ಯಾಂಡ್ ಎಷ್ಟಿದೆ ಸೇಲ್ ಆದ್ಮೇಲೆ?
I'm given to understand about 12 acres.
12 acres. ಇನ್ನು 20 acres.
19 point odd acres.
I do not have the sale sheets.
No, we have the information when material print. There's no difficulty. Unless they are sold it yesterday.
I cannot, my lords, because there is an order of the of this honorable court.
Already, you say you cannot do. That's our grievance.
I mean, in their right case, they are telling unreasonable reasons.
ಸ್ವಾಮಿ ರೈತರು ಕೇಸ್ ಆಗಿದ್ದು ಏನಕ್ಕೆ ಅಂತಂದ್ರೆ ಇವ್ರು ಫ್ಯಾಕ್ಟ್ರಿ ರನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅಂತ ಜಾಗ ತಗೊಂಡಿದ್ದು KDB ಇಂದ ಇವ್ರು ಬೇರೆಯವರಿಗೆ ಮಾರ್ಕೊಂಡಿದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ ಈ ಜಾಗ ನಮಗೆ ವಾಪಸ್ ಕೊಡಿ ಅಂತ ರೈತರು ಕೇಸ್ ಹಾಕಿರ ಸರ್.
ಆ ಕೇಸೇ ಹೋಗಿದೆ.
ಫ್ಯಾಕ್ಟ್ರಿನ ರನ್ ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಈಗಲೂ ರೈತರೆಲ್ಲಾನು ಇದು ಮಾಡ್ತಾರೆ. ಇದು ಇಟ್ ಈಸ್ ಇನ್ KDB ಲ್ಯಾಂಡ್. KDBನವರು ಅಲಾಟ್ ಮಾಡಿರೋ ಲ್ಯಾಂಡ್ ಸರ್. ಹಂಗಾಗಿ ರೈತರಿಗೆ ಏನು ಅದರಲ್ಲಿ ಇದು ಬರಲ್ಲ, ಅವ್ರಿಗೆಲ್ಲಾನು ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಟ್ ಇವ್ರು ಈ ತರ ಇಲ್ಲಿಗಲ್ ಆಗಿ ಬೇರೆಯವರಿಗೆ ಮಾರ್ಕೊಂಡು ನಮಗೆ ಇದು ಮಾಡ್ತಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅಂತ ರೈತರು ಕೇಸ್ ಹಾಕಿದ್ರು.
ಎನಿವೆ, ಈಗ ಇಂಜಂಕ್ಷನ್ ಆರ್ಡರ್ ಬಂದ್ಮೇಲೆ ಒಂದು ಇಂಡಸ್ಟ್ರಿ ಒಂದು ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಕು. ಅದನ್ನ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪರ್ಪಸ್ಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಲ್ಯಾಂಡ್. ನೀವು ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ, ಯಾರ್ಯಾರು ಎಲಿಜಿಬಲ್ ಅಂಡ್ ಕ್ವಾಲಿಫೈಡ್ ಇದ್ದಾರೆ ಅವ್ರನ್ನ ತಗೊಳ್ಳಿ, ಕನ್ಸಿಡರ್ ಮಾಡಿ ಫಾರ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್.
Indeed, my lords. I do not, as I said, my lords, that we do not have any impediment.
ಅವ್ರು ಏನೋ ಒಂದು ಕೇಸ್ ಹಾಕ್ಯಾರ ಮಾಡ್ಯಾರ, ನಿಮ್ಗೆ ತೊಂದರೆ ಕೊಟ್ಟಾಗ ಬಿಟ್ಟು ಹಾಕಿ, ಅದು ಆಯ್ತಲ್ಲ, ಆಗಿದ್ದಾಯ್ತು.
ಇಲ್ಲ, ಅದಕ್ಕಾಗಿ ನಾನು ಅವ್ರ ಮೇಲೆ ಏನು ಇಲ್ಲ.
ಏನೋ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದೆ.
I understand, my lords. As a goodwill gesture, at least I have to do that out of humanity, and they have worked for the company in the past.
Humanity under the shadow of this order.
And very well, my lords, because I am saying that we are before this honorable court, and it has to be very solemn, whatever undertaking I give before this.
ಒಂದು ಮತ್ತು ಅದ್ರ ಸಲುವಾಗಿ ಲ್ಯಾಂಡ್ ಕೊಟ್ಟದ್ದು ನಿಮಗೆ.
ಸ್ವಾಮಿ ಇನ್ನೊಂದು ಸ್ವಾಮಿ,
Now,
ನಿಮ್ ಕೇಸ್ ಕಾನೂನು ಪ್ರಕಾರ ಹೋದ್ರೆ ಕಿತ್ ಹಾಕ್ಬೇಕಾಗ್ತದೆ, ಕಾಸ್ಟ್ ಹಾಕಿ. ಏನೋ ಮಿಸ್ಟರ್ ಶಂಕರ್ ಹ್ಯಾಸ್ ಮೇಡ್ ಔಟ್ ಸಮ್ ಎಫರ್ಟ್ ಅಂಡ್ ದೇರ್ ಫೋರ್ don't pollute the atmosphere now. Yes.
No, my lords, what we have sold to is also industries, my lords.
ಅದು ಬಿಡಿ, ಸೇಲ್ ಆಗಿದ್ದು ಆಯ್ತಾ. ಉಳಿದಂತ 19 ಎಕರೆ ನಿಮ್ಮ ಮತ್ತಿಗಿದೆಯಲ್ಲ, ಅಲ್ಲಿ ಯಾವುದೋ ಒಂದು ಇಂಡಸ್ಟ್ರಿ ಬಿಗಿನ್ ಮಾಡಿ, ಅದನ್ನ ಕೊಟ್ಟಿದ್ದು ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ರಿ ಅನ್ಕೊಂಡು ನಿಮ್ಗೆ ಲಾಸ್ ಆಯ್ತು, ನೀವು ಸೇಲ್ ಮಾಡಿದ್ರೆ ದಟ್ಸ್ ವೆರಿ ವೆಲ್, ವಾಟ್ ಎವರ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್. ಈಗ ಇರುವಂತ 19-20 ಎಕರೆದಲ್ಲಾದ್ರೂ ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ಬೇಕಾ? ಅದು ಒಂದು ಇಂಡಸ್ಟ್ರಿ ಪ್ರಾರಂಭ ಮಾಡ್ರಿ. ಅದ್ರ ಸಲುವಾಗಿ ಕೊಟ್ಟಾರ ನಿಮ್ಗೆ ಅವರು. ಎಷ್ಟು ವರ್ಷ ನೀವು KDBಗೆ ಇಂಡಸ್ಟ್ರಿ ಕೊಡ್ತಿರಲ್ಲ, ನೀವು ಎಷ್ಟು ವರ್ಷದಲ್ಲಿ ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕು ಅವರು? ಆಯ್ತು, ಅದು ಬಿಡಿ, ಆಯ್ತಲ್ಲ. ಇನ್ನು ಈಗ ಮುಂದಿನ ಇನ್ನೂ ಇಂಡಸ್ಟ್ರಿ ಮಾಡಿಲ್ಲಲ್ಲ ಅವ್ರು, ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ? ಇಶ್ಯೂಡ್ ಆಯ್ತು, ಹಂಗಾಗಿ ಓನರ್ ಆದ್ರಿ ಈಗ ಅವರು. ಈಗ ಯಾವಾಗ ಇಶ್ಯೂ ಮಾಡಿದ್ರಿ ಸೇಲ್ ಡೀಡ್?
4/10/2023, my lords.
4/10 ಲಾಸ್ಟ್ ಇಯರ್,
my lords. 4/10.
ಅದು ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಆಯ್ತು. ಅದಾದ್ಮೇಲೆ ಮುಂದೆ ನೀವು ಎಷ್ಟು ಯಾವಾಗ ಮಾಡ್ತೀರಿ ಇದನ್ನ? ಸೂಟ್ ಒಂದಿದೆ ಅನ್ಕೊಂಡು ನಿಮ್ಗೆ.
May I take some instructions, my lords, on this aspect, because kindly pass over, my lords. I'll take instructions and I'll make my submissions at 2.
2:30 ಬಂದು ಹೇಳಿ.
2:30.
ನೀವು ಇಂಡಸ್ಟ್ರಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಕ, ಲ್ಯಾಂಡ್ ತಗೊಂಡಿದ್ದು ಇಂಡಸ್ಟ್ರಿ ಸಲುವಾಗಿ.
ಹೌದು.
ಹಂಗಾಗಿ ನೀವು ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ಬೇಕದ್ನ. ಅದ್ರ ಸಲುವಾಗಿ ರೈತರು ಕೊಟ್ಟಿರ್ತಾರೆ. ನಾವು ರೈತರಿಗೆ ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ತಾರೆ, ಎಲ್ಲರಿಗೂ ಉಪಯೋಗ ಆಗುತ್ತೆ, ಬೇಡ ಹಂಗೆಲ್ಲ ಮಾಡಬೇಡಿ ಅಂತ ರೈತರಿಗೆ ನಾವು ಹೇಳ್ತೀವಿ. ಅವ್ರಿಗೆ ಸಿಟ್ಟು ಬರಲ್ವಾ? ನೀವು ಹಿಂಗೆ ಹೇಳಿದ್ರಿ ಅಂತ ಸುಮ್ಮನಾದ್ವಿ ನಾವು. ಈಗ ಇಂಡಸ್ಟ್ರಿ ಮಾಡಲ್ಲ, ಬಿಸಿನೆಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಅಂತ ನಾಳೆ ಹೇಳಿದ್ರೆ ನಾವೇನು ಉತ್ತರ ಕೊಡ್ಬೇಕು ಕೋರ್ಟ್ನವ್ರು?
ಅದು ಆಲ್ ದ
ಉಳಿದಂತ ಲ್ಯಾಂಡ್ ನರ ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ಬೇಕಾ?
ವೆರಿ ವೆಲ್. I understand. I will just take instructions.
ಹೇಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
At 2:30 I'll.
ನಾಳೆ
For the appellant in this case, my lord, the matter may kindly be passed over, my lord.
Passed over?
The senior is just now English.
ಕರೆಯೋಣ ಆಗಲ್ಲ. Call this matter after vacation. Immediately after vacation we call this. Anyway, it's a special order matter ತಾನೇ. Further hearing. ಹಂಗಾಗಿ ನಮ್ಮ ಮುಂದೆ ಬರ್ತದೆ, ವೆಕೇಶನ್ ಮಾಡ್ಮೇಲೆ ಮಾಡೋಣ. You have to give an adjournment to me, to us.
ಆಯ್ತು.
ಭಾಳ ಮ್ಯಾಟರ್ಸ್ ಭಾಳ ಇದೆ ಅದಕ್ಕೆ. ಈಗ
ಪ್ಲೀಸ್.
Bar graciously agreed with the proposal of this court that matter can be taken up immediately after vacation. First, call immediately after vacation.
Okay. I request for a date, man.
One date ಕೊಟ್ಬಿಡಿ. ಯಾವ್ದೊಂದು ಡೇಟ್ ಕೊಡಿ. One difficulty. We do not know whether this, anyway, it will come before us only.
Please, man.
ಡೇಟ್ ಕೊಡೋದು ಗೊತ್ತಾಗಲ್ಲ, ಯಾಕಂದ್ರೆ ಬೇರೆ ಬೇರೆ ಬೆಂಚ್ ನಲ್ಲಿ ಓದಿವಿ ಅಂದ್ರೆ
My lord,
ಸ್ವಲ್ಪ ತೊಂದರೆ.
week commencing.
ವೀಕ್ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ ಅಂತ ವೆರಿ
6th January, my lord.
ಕೊಡಿ.
My lord, interim order may be.
Interim order to continue till then.
May I make one request, my lord? Interim order is fine, my lord. In terms of continued rents, my lord, appropriate rents may be directed to be given even during litigation, my lord.
Not that. ಅದೇ ಕಂಟೆನ್ಷನ್ ಅವ್ರದ್ದು.
This is for That is for rental arrears, my lord. Tingla
Arrears ಬೇಡ, ಈಗ accruing rent ಕೊಡ್ಬೇಕಲ್ಲ.
Accruing rent we are giving, my lord.
You are giving.
We are making accruing rent.
September 2020 ಗೆ ಸ್ವಾಮಿ 9,97,00,000 ಪೆಂಡಿಂಗ್ ಇದೆ.
At least current rent ಅನ್ನು ಕೊಟ್ಕೋತೀವಿ.
Contention, my lord.
Current rent ಅನ್ನು ಕೊಡ್ಬೇಕಲ್ಲ.
My lord,
Arrears ಬಿಡಿ.
I need to seek instructions on this aspect.
ರೆಂಟ್ ಕೊಡೋದಿಲ್ಲ ಅಂತನಾ?
10,43,000 as of now we're making, my lord. We're making payment of rent on a monthly basis.
Continuing rent you have to pay.
That will make.
It may be no.
ನಿಮ್ ಪ್ರಕಾರ ಅದು 1 ಪೈಸಾ ಆದ್ರೂ ಕೊಡ್ಬೇಕು.
ಆಯ್ತು ಸರ್, ಅದನ್ನ ನಾವು
ಅದು
admitted
ಕೊಡದೇನೆ
rent
ನಾನು ಕೊಡೋದೇ ಇಲ್ಲ ಅಂತ
ಇಲ್ಲ ಅದನ್ನ ನಾನು
The order is
ಅದನ್ನ
continued subject to the admitted current rent is being paid.
much of this.
On regular basis.
Great.
Okay.
For the response. Advocate for the petitioner.
Yes, Joshi Saab.
This is that
Yes.
my lord had.
Solomon
or
versus
directed
Solomon.
that- Solomon versus Solomon, and then my lord had said that anyway show that you have not earned anything from the company, therefore file disclosure, income tax returns, affidavit has been, it's on record.
But
Monday. Income tax records have been filed. He had made a statement, my lord will remember.
saying that we have sufficient assets.
So the basis for that also is now demonstrated.
Huh?
And that is also demonstrated on what basis, what was the material at that point of time that caused him to make that statement and how that material is no longer available. Para number 2, I say that as per the directions of this court, I'm producing my income tax returns for the assessment years 2015-16 to 24-25. And para number 3, my lord, I say that I have not taken any money either by way of remuneration or by way of share of profit from the company. My affidavit, my lord. My lord, my ಫೈಲ್ ಆಗಿಲ್ಲ ಆಗಿದೆಯಾ
ಫೈಲ್ ಆಗಿದೆ ಅಂತ
ಫೈಲ್ ಆಗಿದೆ
ತರಿಸಿ ಅದನ್ನ ಅಫಿಡವಿಟ್ ಅಂತ ತರಿಸಿ.
I'll come back.
Great.
Your lordships are passing it over, my lords?
Yes, passing over.
Great.
Any difficulty, Mr. Mukherjee?
No, my lord, just not at all. I'll be there in the second call.
Okay.
Great.
Pass over. In matter.
But it's a money suit that has been decreed. So therefore the defendant is before your lordship.
ಬಹಳ ಟೈಮ್ ಬೇಕಾಗ್ತದ, ಶಾರ್ಟ್ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇದೆಯಾ?
ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕಾಗ್ತದೆ.
ಬೇಕಾಗಲ್ಲ.
I have prepared a synopsis on facts.
After vacation ಕಾಲ್ ಮಾಡೋಣ. Call after vacation.
Great.
Yes. Legal.
Accounts ಮೇಲೆ ಇದೆ.
ಅಕೌಂಟ್ಸ್ ಮೇಲೆ ಇದೆ ಅದು. Yes. ಏನ್ ಮಾಡೋಣ ಸ್ವಾಮಿ ಇದು?
For the petitioner,
bank employee.
my lords, on the last date of hearing, my lords, on your lord's recommendation, we were instructed to bring to our client's notice whether if we pay 25% of the back wages and arrears due as a result of that impugned order, my lords, if the same any settlement could have been reached, we communicated the same to them, but however, no instructions has been received from them, my lords. If some
ಬ್ಯಾಂಕ್ ಅವ್ರು ಜನರಲ್ ಆಗಿ ಎಲ್ಲೂ ಮಾಡಲಿಲ್ಲ ಸುಮ್ಮನೆ ಇದುವರೆಗೆ ಮಾಡಲೇ ಇಲ್ಲ. ಇಟ್ಸ್ ಎ ಸ್ಮಾಲ್ ಪಾಯಿಂಟ್ ಮಿನಟ್ಸ್. ಫಸ್ಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾರೆ. ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಬಂದಮೇಲೆ ದೇ ವಿಲ್ ಡಿಸ್ಕಾರ್ಡ್ ದ ಎಂಟೈರ್ ಎನ್ಕ್ವೈರಿ. ಅಗೇನ್ ಡಿನೋ ಅನದರ್ ಎನ್ಕ್ವೈರಿ ಆಫೀಸರ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿ ಮತ್ತೆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ತಾರೆ. ಲೇಬರ್ ಕೋರ್ಟಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಹೆಲ್ಡ್ ಟು ಬಿ ನಾಟ್ ಫೇರ್ ಅಂಡ್ ಪ್ರಾಪರ್. ದೇರ್ ಆಫ್ಟರ್ ದೇ ಲೆಟ್ ಎವಿಡೆನ್ಸ್ ಆನ್ ಮೆರಿಟ್ಸ್. matter is, charges are not proved.
My lords, my
Labor court has
submission is-
granted 50% back wages
So
and
far.
reinstatement.
in
She
so
has,
far-
one more petition. She retired way back in 2018 or 19. So.
petitioner has superannuated, my lords. Question of reinstatement doesn't exist.
Madam, back which
About, It's about a quantum which has to be settled, my lords, and we have not yet reached we've communicated the same to our clients. my lords.
No, your
Do
client
not have
may not-
instructions, my lords, to argue this matter.
It's
So for
squarely covered by
short
judgments of
time-
Supreme Court.
Small, short accommodation may be given, my lords. At the end of the,
Last time ತಾವು ಹೇಳಿದ್ರಿ ಸ್ವಾಮಿ, next date ಅಲ್ಲಿ ಮಾಡಲೇಬೇಕು ಅಂತಾನು ಹೇಳಿದ್ರಿ ತಾವು.
my lords, if short accommodation may be given, we receive instructions whether the parties can settle the matter or not, or if we receive instructions to finally argue the matter, that will be done.
The
my
other
lords.
day you have argued the matter.
No, my lords, we haven't.
That's what-
Substantively, we haven't argued the matter. my
Substantial
lords.
alla.
It
What
was-
we heard you, then we made this suggestion.
Please,
At
my
least 50 ಅಲ್ಲಿದ್ರು ಒಂದು 25% ಆದ್ರೂ ಕೊಡ್ರಿ, because she has already attained age of retirement and retired.
Please, my lords, and it's being considered by our clients, my lords.
Consider ಮಾಡಲ್ಲ.
My lords, it is, my lords.
Being considered.
It's being considered, the 25% of arrears, my lords.
Counsel for the petitioner, having argued the matter, now submits that the bank is considering the proposal for granting 25% of the back wages to the respondent employee who has since retired on attaining age of retirement superannuation way back in 2019. Correct?
Also.
2019. First, call this matter in the second week of January for further hearing. Further hearing.
Further,
Ah.
please.
Great.
Grateful.
ಏನ್ ಗ್ರೇಟ್ ಇಂತ ಆರ್ಡರ್ ಮಾಡಿ ಅಜರ್ಮೆಂಟ್ ಆದ್ರೆ ಗ್ರೇಟ್ ಒಂದು ಚಲೋ ಆರ್ಡರ್ ಬರೋದು ಗ್ರೇಟ್ ಅಂದ್ರೆ ಅರ್ಥ ಇದೆ ಅದು.
Notice is already issued, my lord.
Huh.
Interim order is not there. Contempt is coming up on 13th.
ಬರ್ಕೊಳ್ಳಿ. This matter is moved by the state on the ground that the cognate contempt proceedings are coming up before the court before long. And therefore, some reprieve needs to be granted. First up, we agree with this proposal. First up, next up, in view of the above, nothing shall be precipitated under the order put in question in the WP. Okay,
Obliged, my lord.
yes.
Seeks a short accommodation to file affidavit.
Prakash Shakya,
Affidavit
Last
applic-
day.
short accommodation.
Short accommodation.
Sure. Call immediately after vacation.
Receipt is already filed in.
You will appear for the,
Already.
Directions was to the KPSC and the,
correct. We remember,
Lord, can it be in further
appear
hearing?
to,
Can it be in further hearing, my lords? I placed all the
not, not. Perhaps it will come before us only,
Any date? Any date.
immediately after vacation, yes.
Great, great.
Next. ಅವ್ರಿಗೆ ಅಟ್ಲೀಸ್ಟ್ ವೆನ್ ದೇ ಆರ್ ಸಿಟ್ಟಿಂಗ್ ಅವ್ರಿಗೆ ಹೇಳ್ಬೇಕು, ನಾವು ಟೈಮ್ ತೊಗೊಳ್ತೀವಿ, ಕುತ್ಕೋಬಾಡ್ರಿ. ಎಷ್ಟೋ ಸರಿ ಆ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ರಾಜಗೋಪಾಲ್ ಮುಂಜಾನೆಯಿಂದ ಹಿಡಿದು ಸಂಜೆವರೆಗೆ ಕುತ್ಕೊಂಡು ಇಲ್ಲ ನಾವು ಟೈಮ್ ಕೇಳ್ತೀವಿ ಅಂತ ಹೋಗ್ಬಿಟ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ಅಟ್ಲೀಸ್ಟ್ ಬೇರೆ ಕೆಲಸ ಮಾಡ್ಕೋತಾರೆ, ತಿಳಿಸ್ಬೇಕು ನೀವು. ಇಲ್ಲ ನಾವು ಟೈಮ್ ಕೇಳ್ತೀವಿ ಅಂತ ಇಷ್ಟು ಹೇಳಿ ಇಡ್ಬೇಕು. ನಾವು ಟೈಮ್ ಕೊಡಬೇಕು ಬೇಡ ನಮ್ಮ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ ಅದು. ದಟ್ಸ್ ಅನದರ್ ಥಿಂಗ್. ಓಕೆ. If I ಡೇಟ್ ಹಾಕಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ದೇನು? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? Call after vacation to enable counsel for the petitioner to come and argue. Okay. Raj Patel.
Yeah, petitioner was applied the post of cook, my lord.
Post of Pune.
Cook, my lord.
Cook.
Yes.
Ah.
And the petitioner has produced the experience certificate as per the annexure A6, page number 64. for 5 years of experience certificate, madam.
6 years.
5 years experience certificate, madam. Annexure A6, page number 64, madam. I have produced, madam, my lord, but at the time of enquiring the officer, my lord, they have taken page number 69 certificate, my lord. ಅದೇನಂದ್ರೆ ಡೇಟ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟಿದ್ರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಐ ಹ್ಯಾವ್ ಗಿವನ್ ಇನ್ ಡೇಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಲ್ಸೋ ಮೇಡಮ್, ಪೇಜ್ ನಂಬರ್ 67.
67.
ಎಸ್ ಮೇಡಮ್.
ಯಾವತ್ತು ಕೊಟ್ರಿ ನೀವು?
ಸೇಮ್ ಅಂದ ಇದು ಅಪ್ಲಿಕೇಶನ್, ಆನ್ಲೈನ್ ಅಪ್ಲಿಕೇಶನ್ ಜೊತೆನೆ ಕೊಟ್ಟಿದ್ದೆ.
ರಿಕ್ವೈರ್ಮೆಂಟ್ ಎಷ್ಟಿತ್ತು? 6 ವರ್ಷ.
5 years ಮೇಡಮ್, 5 years.
Court commonly come to page
6 years ಮೇಡಮ್, ಸಾರಿ 6 years. ಎಸ್.
ಇದು ನೀವು ಕೊಟ್ಟಂತ ಸರ್ಟಿಫಿಕೇಟ್ ಎಷ್ಟಿದೆ?
6 years ಇದೆ.
6 years ಇದೆಯಾ?
ಎಸ್. ಇದು 5 years ಮೇಲಾಡ್, ಆದ್ರೆ ಇದು ಮಾರ್ಕ್ ಕೊಡೋದು 6 marks ಮೇಲಾಡ್. ಪೇಜ್ ನಂಬರ್ ಮೇಲಾಡ್ 41 ಅಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ಇದೆ ಮೇಡಮ್. ಅರ್ಜಿದಾರರು ಸಲ್ಲಿಸಿದ ವೃತ್ತಿಯಲ್ಲಿ 5 ವರ್ಷ ಮತ್ತು ಹಾಗೂ ಮೇಲ್ಪಟ್ಟ ಅನುಭವಕ್ಕೆ 6 marks.
ಬಿ ಗ್ರೂಪ್.
ಎಸ್ ಮ್ಯಾಮ್. ಪೋಸ್ಟ್ ವೇಕೆಂಟ್ ಅದ ಅನ್ಸುತ್ತೆ, ಯಾಕಂದ್ರೆ ಅವರೆಲ್ಲ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದಾರೆ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್. 3 or 4 post ವೇಕೆಂಟ್ ಅದಾವೆ.
He is less meritorious. I can
ಇಲ್ಲ,
substantiate, my lord, that.
No, 96 point.
ಯಾಕಂದ್ರೆ page 41, my lord, is the notification. My lord, work experience is 6 marks they have assigned. If my lords may kindly peruse A6 and A7, how, my lord, this mark is deducted from them? The trade license, my lord, which they were supposed to give, the hotel didn't had the license at that point of time. He's applied for the post of cook, my lord.
ಕರೆಕ್ಟ್. ಲೈಸೆನ್ಸ್ ಹೋಟೆಲ್ ನಲ್ಲೇ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇರಬೇಕು ಅಂತ ಹೇಳಿದೆ ರೂಲ್ ನಲ್ಲಿ.
That is the one of the criteria. Page 41 ಅದೇ ಹೇಳ್ತಾರೆ.
41.
Yes, my lord.
Last
41, there is a trade test, my lord. Separately, they have idರಲ್ಲಿ they have work experience of 5 years and above in respective trade. Trade is, since is applied for the post of cook, trade experience is nothing but cooking experience.
Correct.
Yes, my lord.
But where it says it should be in licensed eatery. Suppose ಯಾವ್ದೋ ಜಡ್ಜಸ್ ಮನೇಲಿ ಕುಕ್ ಆಗಿ ವರ್ಕ್ ಮಾಡ್ತಾರಪ್ಪ, ನಮ್ಮ ಮನೆಗಳೆಲ್ಲ ಇಲ್ಲ 4 ಜನ ಕುಕ್ಸ್ ಇದ್ದಾರೆ.
ಅಂಗಡಿ ಇಟ್ಕೋಬಹುದು.
He's relied on that document, my lord.
Which is that?
A6 and A7.
ಇಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 41 ಅಲ್ಲಿ ಕೆಳಗಡೆ ಇದೆ ಸರ್,
ಇಲ್ಲ.
ಪರವಾನಿಗೆ ತಗೋಬೇಕಂತ ಇದೆ.
A6 and A7.
Which shall be obtained from the employer.
Yes.
The certificate shall contain a valid trade license. License ಇರಬೇಕು ಅಂತ.
ಇದೆ ಸರ್ ಮೇಡಮ್. Annexure A6, Annexure A6 ಮೇಡಮ್.
64.
ಹೌದೌದು. ಟಿನ್ ನಂಬರು, ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಎಲ್ಲ ಇದೆ ಸರ್.
ಎಲ್ಲಿದೆ?
64 ಬಾಟಮ್ ಮೇಲಾಡ್.
64.
Annexure A6, GST number, trade license and food license ಮೇಲಾಡ್. ಟಾಪ್ ರೈಟ್ ಸೈಡ್ ಮೇಲಾಡ್.
ಅಲ್ಲ, license period have to be seen, my lord.
ಅಲ್ಲ ಕಂಟಿನ್ಯೂಸ್ ಇದೆ. Annexure R6, 7 and 8 ಮೇಲಾಡ್.
ಎಲ್ಲಿದೆ?
Annexure A6 and A7 ಮೇಲಾಡ್. ಇದು ಕಂಟಿನ್ಯೂ ಆಗಿದೆ ಸರ್. ಲೈಸೆನ್ಸ್ ಪರವಾನಿಗೆ
7/18
ಎಸ್ ಮ್ಯಾಮ್.
ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್
1/4/2020 31/3/2021 ಮೇಲಾಡ್. ಫಸ್ಟ್ Annexure A6 ಮೇಲಾಡ್.
A6 is from
1/4/2022 31/3/2021 ಮೇಲಾಡ್. ಇದು ಸರ್ 1 2
Date of notification is 37/21.
ಅಲ್ಲ ಕೊಡ್ತೀನಿ. 7th ಪರವಾನಿಗೆ ಅವಧಿ ಮೇಲಾಡ್. ಪರವಾನಿಗೆ ಅವಧಿ
1/4/20.
1/4/20 31/3/2021.
3 ವರ್ಷಕ್ಕೆ ಕೊಡ್ತಾರ ಅದನ್ನ?
ಅಲ್ಲ 1 ವರ್ಷ ಮೇಡಲ್, ಯಾಕಂದ್ರೆ ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ತಾನೆ ಇರುತ್ತೆ.
20 ಅಂತ ಕೊಟ್ಟಾರೆ.
ಅಲ್ಲ 21 ಮೇಲಾಡ್, 21. ಎಸ್ ನೆಕ್ಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮೇಲಾಡ್ Annexure A7.
ಇದು 20
ಎಸ್ ಮೇಲಾಡ್. ನೆಕ್ಸ್ಟ್
ಡುಪ್ಲಿಕೇಶನ್.
ಅದು ಡುಪ್ಲಿಕೇಶನ್.
ಡುಪ್ಲಿಕೇಶನ್ ಆಗಲ್ವಾ?
ನೆಕ್ಸ್ಟ್ 20
21 ಮೇಲಾಡ್.
ಸೇಮ್ ಮಾತು.
ಎಸ್ ಮೇಲಾಡ್. ವೆರಿ ನೆಕ್ಸ್ಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮೇಲಾಡ್ Annexure ಪೇಜ್ ನಂಬರ್ 67 1/4/21 to 31/3/2022 ಮೇಲಾಡ್.
ಇಲ್ಲಿಗೆ 1 ವರ್ಷ ಆಯ್ತು.
1 ವರ್ಷ.
2 ವರ್ಷ ಆಗ್ತದೆ.
2 ವರ್ಷ ಆಯ್ತು ಸ್ವಾಮಿ. ಇದು ಯಾಕಂದ್ರೆ ಲೈಸೆನ್ಸ್ ಇರೋದು. ಡೇಟ್ ಆಫ್ ನೋಟಿಫಿಕೇಶನ್ ಮೇಲಾಡ್ 30/8/2021.
23.
ಎಸ್. ನೆಕ್ಸ್ಟ್ ಲೈಸೆನ್ಸ್ ಮೇಲಾಡ್ 1/4/2022 31/3/2023.
ಆಮೇಲೆ
ಇಷ್ಟೇ ಸ್ವಾಮಿ. ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಸಬ್ಮಿಟಿಂಗ್ ದಿ ಅಪ್ಲಿಕೇಶನ್ 30/8/2021 ಮೇಲಾಡ್.
5 ವರ್ಷ ಬೇಕಲ್ಲ?
ಅಲ್ಲ 5 ವರ್ಷ ಬೇಕು. ನಂದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇಲ್ಲಿದೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 64 Annexure A6 ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಎಲ್ಲಿಂದ ವರ್ಕ್ ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು. ಪೇಜ್ ನಂಬರ್ 64 Annexure A6.
64.
ಎಸ್ ಮಾನ್ಯರೇ, ಲಾಸ್ಟ್ ಬಾಟಮ್.
ಹಾಸನ ಜಿಲ್ಲೆ ಎಚ್ಲಘಟ್ಟ ಗ್ರಾಮದ ಕುಮಾರಾಚಾರಿ ಮಗನಾದ ಶಶಿಕುಮಾರ್ ಎಂಬಾತ ಹುಡುಗನು ನಮ್ಮ ಹೋಟೆಲ್ನಾದ ಸರಸ್ವತಿ ಹೋಟೆಲ್ ಕೇಟರ್ಸ್ ದಿನಾಂಕ 26/8/2016 ಕೆಲಸಕ್ಕೆ ಸೇರಿಕೊಂಡಿದ್ದು 19/8/2016
ಪೀರಿಯಡ್ ಎಲ್ಲಿದೆ ಲೈಸೆನ್ಸ್ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಅಂತ ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೇಳೋದು.
ಇಲ್ಲ, ಅದು ಪ್ರತಿ ವರ್ಷ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ. ಇದು ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ ಅದು?
ಎಲ್ಲಿದೆ?
ಅಂತ ತೋರಿಸಿ.
16ರಿಂದ ಇದ್ದದ್ದು ಎಲ್ಲಿದೆ?
ಅದು ಬೇಕು ಅಂತಾರ ಅವರು.
ಇಲ್ಲ, ಅದು ಬೇಕಂತ ಹೇಳ್ತಾರೆ. ನಮ್ದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇನ್ ಟೈಮಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ಅಲ್ಲ, ಈಗ ಅದರ್ವೈಸ್ ಆಲ್ಸೋ ಯು ಹ್ಯಾವ್ ರೆಡ್ ದಟ್ ಪೇಜ್ 44
Yes, 41
41 ಕೆಳಗಡೆ
Yes.
ನೀವು ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇದ್ದಲ್ಲೇ ವರ್ಕ್ ಮಾಡಿರ್ಬೇಕು.
ಹೌದು ಸ್ವಾಮಿ, ಹೌದು.
ಅದೆಲ್ಲಿದೆ ನೀವು 2016ರಿಂದ ಕ್ಲೇಮ್ ಮಾಡಿರಿ ನೀವು?
ಇಲ್ಲ, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ 5 years ಇರ್ಬೇಕು ಸ್ವಾಮಿ. ಅದು ಲೈಸೆನ್ಸ್ 5 ವರ್ಷ ಅಲ್ಲ,
ಮತ್ತೆ
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಮೇಲೆ.
ಎಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್?
ಇಲ್ಲಿಂದ ಹಾಕಿದೆ ಸ್ವಾಮಿ.
ಲೈಸೆನ್ಸ್ ಡೀಟರಿಯಲ್ಲಿ ಇರಬೇಕು.
ಅಲ್ಲ, ಯು ಮೀನ್ ಟು ಸೇ ನಾವು 2024 ಲೈಸೆನ್ಸ್
ಒಂದು ಹಿಂದಿಂದೆಲ್ಲ
2010 ನನ್ನ ಹತ್ರ ಕೆಲಸ ಮಾಡ್ತಿದ್ದ ಅಂತ
ಇಲ್ಲ,
ಹಂಗ್ ಬರಬಾರ್ದು ಅನ್ನೋದಕ್ಕೆ ಹಿಂಗೆ
ಅಲ್ಲ. ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಪ್ರೈವೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ ಥರ್ಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಮೇಲೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ಈ ತರ ಇದೆ. ನಾವು ಸೇಮ್ ಇದೇ ತರನೇ ಇದು ಮಾಡಿದ್ದಾರೆ. ಕನ್ಸಿಡರ್
ಅಲ್ಲೇ ಇಲ್ಲಿ ಬರ್ರಿ 41 ಬರ್ರಿ ಪೇಜ್ಗೆ. ಪ್ಲೀಸ್ ಹೇಳ್ರಿ. ಅವ್ರು ಹೆಂಗ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತಾರಲ್ಲ, ನಾವ್ ಹೆಂಗ್ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ತೇವೆ ಅನ್ನೋದು ಲಾ. ಅವ್ರು ಏನೋ ಹೋಟೆಲ್ನಾಗ ಇರಲ್ಲ ಎಂತ ಮಾಡ್ಕೊಳ್ಳೋದು. ಜಡ್ಜ್ ಹೇಳೋದು ಲಾ. ಏನ್ ಹೇಳಿದ್ದು? ಆಲಿವರ್ ವೆಂಡಲ್ ಹೋಮ್ಸ್, ವಾಚ್ the prophecies, the inarticulate prophecies of the judge is law. Ilbani, go to the rock bottom of 41.
Yes. ವೃತ್ತಿ ಅನುಭವ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು
ಸಂಬಂಧಪಟ್ಟ ಮಾಲೀಕರಿಂದ ಪಡೆಯಬೇಕಿರುತ್ತದೆ. ಸದರಿ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ಮಾಲೀಕರ ಅರ್ಹ ವೃತ್ತಿ ಪರವಾನಿಗೆ GST, ಟಿನ್ ಸಂಖ್ಯೆ, ಪ್ಯಾನ್ ಸಂಖ್ಯೆ ನಮೂದಿಸಲ್ಪಟ್ಟಿರಬೇಕು. ಆ ಪೀರಿಯಡ್ ಇರಬೇಕು.
ಎಸ್ ಮೇಡಮ್. ಇಲ್ಲಿ ಅನುಭವ ಮೇಲೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್, ಅರ್ಜಿ ಸಲ್ಲಿಸಲಾದ ವೃತ್ತಿಯಲ್ಲಿ 5 ವರ್ಷ ಮೇಲ್ಪಟ್ಟ ಅನುಭವ ಮೇಲೆ.
ಕರೆಕ್ಟ್. ಆ ಅನುಭವ ಲೈಸೆನ್ಸ್ಡ್ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇರುವಂತ ಎಂಟಿಟಿಯಲ್ಲಿ ಇರಬೇಕು. ನಾಟ್ ವಿತ್ ಸಮ್ XYZ. Otherwise everybody will say.
ಅಲ್ಲ, ಇನ್ ಸೋ ಫಾರ್ ಆಸ್ ಸೆಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ ಇಸ್ ಕನ್ಸರ್ನ್ಡ್ ಅಲ್ಲ.
ನೀವು ಹೆಂಗ್ ಟ್ರೀಟ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಸೆಲೆಕ್ಟೆಡ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಬೇರೆ ತರ ಟ್ರೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ಲೀಸ್,
ಅದು ಪ್ರಶ್ನೆ ಅಲ್ಲ. ಇಲ್ಲಿ ಈ ರೂಲ್ಸ್ ಪ್ರಕಾರ ಇದ್ರೆ ಇನ್ನು ಉಳಿದವ್ರಿಗೆ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ನೀವು?
Private respondent is more meritorious.
More meritorious.
My lord, he is scored, my lord, the required cutoff marks is 96.3.
ಯಾರ್ದು?
For this particular post.
ನಿಮ್ ಕ್ಲೈಂಟ್
96.3.
ಏನು ಅದು ಯಾವ ರೀತಿ 96.3? ಅದು ಹೆಂಗ್ ಅಸೆಸ್ಮೆಂಟ್ ಎಲ್ಲ ಹೆಂಗಿದೆ? ಅದು ಯಾವ ಆಧಾರದ ಮೇಲೆ?
10th ಮಾರ್ಕ್ಸ್, ಆಮೇಲೆ ರಿಟರ್ನ್ ಟೆಸ್ಟ್, ಆಮೇಲೆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್.
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಡಿಗೆ ಮಾಡಿ ಹಾಕ್ತಾರ ಅವ್ರು?
ಹೌದೌದು, ಅದಕ್ಕೆ ಇದು ಮಾಡ್ತಾರೆ 30 ಮಾರ್ಕ್ಸ್ ಮೇಲೆ.
ನಮಗ್ ಕರೆದಿಲ್ಲಲ್ಲ ಅಲ್ಲಿ.
6 marks ಫಾರ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್.
Fourth respondent has scored 96.
ಆಮೇಲೆ SSLC ಒಂದು.
ಎಸ್ ಮೇಡಮ್.
ಆಮೇಲೆ
ಟೆಸ್ಟ್ ಮೇಲೆ ರಿಟರ್ನ್ ಟೆಸ್ಟ್ ಮಾಡ್ತಾರೆ.
ರಿಟರ್ನ್ ಟೆಸ್ಟ್.
ಎಸ್ ಮೇಡಮ್.
ಅಲ್ಲೇ ಪಾಕಶಾಸ್ತ್ರದ ಮೇಲೆ ಕೇಳ್ತಾರೆ.
ಹೌದು. ಅಂಡ್ 6 marks ಫಾರ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್.
ರಿಟರ್ನ್ ಟೆಸ್ಟ್, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್.
ಎಸ್.
ಈ ಪ್ರಕಾರ ಒಂದು ಅಡ್ಮಿಟೆಡ್ಲಿ 5 ವರ್ಷಕ್ಕೆ ನಿಮ್ಗೆ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ, ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ. ನೀವು ಎಲ್ಲಿ ವರ್ಕ್ ಮಾಡಿರ ಅವರಿಗೆ?
ಅವರು ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ 5 years. ಎಸ್.
ನಿಮ್ಮ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ನೀವು ಎಲ್ಲಿ ಬೇರೆ ಎಲ್ಲಾರ ಒಂದ್ ಕಡೆ ಹೋಗಿ ಆ ಹೋಮ್ ಸ್ಟೇದಲ್ಲಿ ಎಲ್ಲಾರ ಮಾಡಿದ್ರೆ ನಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಇಲ್ಲಿ ಈ ಪ್ರಕಾರ ಇದೆ ಅಂತ ಒಂದು. ಆಮೇಲೆ ನಿಮ್ ಇವ್ರಿಗೆ ಪರ್ಸೆಂಟೇಜ್ ಎಷ್ಟು?
My lord, he scored 96, my lord. He present petitioner, my lord, he scored 90.91.
91. XT 90.91, my lord. Excluding 5 marks.
Excluding 5 marks of
ಹೌದೌದು. ಅದನ್ನ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಸೇರಿಸಿದ್ರೆ 96.91 ಆಗುತ್ತೆ.
ಅದನ್ನ ಹೆಂಗ್ ಸೇರ್ಸಾಕ್ಬಾರ್ದು? ಅದನ್ನ ಆ ಪೀರಿಯಡ್ಗೆ ಲೈಸೆನ್ಸ್ ಆಗಿತ್ತು ಅಂತ ತೋರಿಸು. ಇವ್ರದ್ದು ಹೆಂಗಿದೆ?
ಇವ್ರದ್ದು 96 ಇದೆ.
ಅಲ್ಲ, ಲೈಸೆನ್ಸ್ ಆಗಿದಂತ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಹೆಂಗಾಗಿದೆ? ಯಾವ ರೀತಿ?
Excluding that experience.
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ನಿಮ್ದಾಗಿದೆಯಲ್ಲ, ಅದು ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇರುವಂತ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಅಥವಾ ಇಲ್ದಂತ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್?
Excluding melody. Excluding that experience melody. Therefore I am materialized then the.
ನಮ್ಮ ಪ್ರಶ್ನೆ ಅದಲ್ಲ.
Please melody.
ಲೈಸೆನ್ಸ್ ಅಂತ ನಿಮ್ಮ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಕೌಂಟ್ ಮಾಡೋದಿದ್ರೆ
Please melody.
ಬರೀ ಎಲ್ಲೋ ಒಂದ್ ಕಡೆ ಕುತ್ಕೊಂಡು ರುಚಿಯಾದ ಅಡಿಗೆ ಮಾಡಿ ಹಾಕ್ಬಿಟ್ರೆ ಆಗ್ಲಿಲ್ಲ.
Please melody.
ಲೈಸೆನ್ಸ್ ಇರುವಂತ ಈಟರಿ ಇರುತ್ತಲ್ಲ, ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇರ್ಬೇಕು ಅದಕ್ಕೆ,
Please,
ಅಲ್ಲಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳ್ತದೆ ರೂಲ್.
true, my lord.
ನಿಮ್ದು ಇದೆಯಾ ಅಂತದ್ದು?
Is my lord, sir. Without excluding that experience, my lord, my score is this, my lord.
ಎಷ್ಟು
96.91.
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಿದ್ರು?
Please, my lord. That is,
ಏನು ನೀವೇ ನಳ ಮಹಾರಾಜ ಹೇಳ್ದಂಗೆ ಹೇಳ್ತಾ ಇದ್ದೀರಿ? ಅದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇಲ್ದಿದ್ರು ಇಷ್ಟು ಮಾರ್ಕ್ಸ್ ಬಂದದೆ ಅಂತ.
ಇಲ್ಲ ಇಲ್ಲ.
ಇನ್ಕ್ಲೂಡಿಂಗ್ ಇರ್ಬೇಕು.
ಹೌದು,
Including, my lord.
It
It is
cannot be
including,
without
not excluding. my lord.
ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಇಲ್ದಂಗ್ ಮಾಡಕ ಬರಲ್ಲ. ಅದೇನು ಪುಸ್ತಕ ಓದ್ಕೊಂಡು ಬಾವ್ಯಾಗ ಹರಕ್ ಬರ್ತದ ಈಸ್ಲಿಕ್ಕೆ? ಆ ನಮೂನಿ ಆಗ್ತದೆ.
Para 7 of the KT order, my lord. ಇಲ್ಲ, that is including
ಅಲ್ಲ,
96.
ಆ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ಗೆ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇತ್ತ? $96.3 ಆಗ್ತದೆ. ನಿಮ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ 6 ವರ್ಷ ಕುಡಿಸಿದ್ರು 96 ಅಷ್ಟ ಆಗ್ತದೆ.
ಹೌದು, ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ತಗೊಂಡ್ರೆ
ಹಾ,
96.91 ಆಗುತ್ತೆ ಸರ್.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
ಇದು ಅವ್ರದ್ದು ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಐ ಹ್ಯಾವ್ ಟೇಕನ್ ಅಂಡರ್ RTI.
My lord, para 6 of the KT order, my lord.
ಹಾ, ಏನಂತಾರೆ?
It is further contended that the committee held a meeting on 4/3/23 and after examining the certificates, the committee recommended deducting the marks scored based on the experience of trade license submitted by the applicant as well as the within the cutoff period. Insofar as fourth respondent is concerned, the committee decided to deduct 4 marks for the experience certificate as trade license did not have GST TIN. These documents are placed
4 ಮಾರ್ಕ್ಸ್ ಆದ್ರೆ
ಅವ್ರ್ದು-
100.3 ಆಗತ್ತೆ. ಅವಾಗ ಪ್ರಿಸ್ಕ್ರೈಬ್ಡ್ ಮ್ಯಾಕ್ಸಿಮಮ್ ಕಿಂತ ಜಾಸ್ತಿ ಆಗಿಬಿಡ್ತದೆ ಗಣಿತದ ಪ್ರಕಾರ.
4 marks, it was deducted, my lord, because there was no GST TIN in that.
ಅಲ್ರಿ,
Yes, my lord.
ಈಗ ಡಿಡಕ್ಟ್ ಆಗಿಲ್ಲ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ,
Yes, my lord.
ಅವಾಗ ಎಷ್ಟಾಗ್ತದೆ ಅವನಿಗೆ? 100 ದಾಟಿ ಬಿಡ್ತದೆ. ಏನು? How
ಅಲ್ಲ,
can that be? You will be doing violence to all arithmetical principles. It exceeds 100. ಎಲ್ಲದೂ ಎಕ್ಸೀಡ್ ಆಗ್ತದೆ ಅದಕ್ಕೆ ಕೇಳ್ತೇವೆ. How can that be? If your contention is accepted, 96.3 plus 4 will be
100.
as we have been taught in primary school, 100.3 ಆಗ್ತದೆ. How it exceeds 100%?
May I submit?
Ah.
Page number 76, my kindly be seen, my lord.
ನೋಡಿದ್ವಿ ನಾವೀಗ, ನಾನು ನಮ್ಮ ಬ್ರದರ್, ಅದ್ ಹೆಂಗಾಗ್ತದೆ ಅಂತ.
Serial number 63. The name of the fourth respondent is found at serial number 63, my lords.
96.
Alla, 76. 76. Page number 76.
ಹಾ,
Serial number 93, 63, my lords. The petitioner name is found at 63.
63.
Please, my lords.
ಮುಕ್ಕಣ್ಣ.
Please, my lords.
ಹಾ,
He scored total 100 marks, my lord.
100 ಮಾರ್ಕ್ಸ್ ನೋಡನೆ.
76 plus 24.
76
plus
plus
24.
24. 100ಕ್ಕೆ 100.
100, my lord.
ಹಾ,
100, my lords.
ಹಾ.
So
Minus
minus 4 marks, my lords. Experience
4.
certificate. So
60 point.
then it comes to 96, my lords. Whereas the petitioner
96.3 ಅಲ್ಲ.
Illa, he scored
96
only 96, my lord.
96, my lord.
But you said 96.
No, my lord, 96, my lord, that is the cutoff marks. 96.3 is the cutoff marks.
So he will get 96. ಅದು ಮೈನಸ್ ಮಾಡಿದ್ರು.
Please, my lord.
So which he is not. ಮೈನಸ್ ಮಾಡಿದ್ರು 90 ಬಂದು
90
ನಿಂತ್ಕೊಂಡ್ಬಿಡ್ತದೆ.
ಬರುತ್ತೆ.
So comparative merits lies with you.
Please, my lord.
But experience compulsory ಅಲ್ಲನ ಅಲ್ಲಿ ಸರ್ಟಿಫಿಕೇಟ್.
ಅಲ್ಲ ಮಾಡಿ.
Where do you stand? ಈಗ ಅವರು 96.3 ಅಲ್ಲ, 96.3 is the cut off. ನಿಮ್ದು
90.91.
90.91 ಅಷ್ಟೇ
ಇವ್ರು-
ಇದೆ. ಸರ್ಟಿಫಿಕೇಟ್ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಇರೋ ಇಯರ್ಸ್ ಅನ್ನು ಆಡ್ ಮಾಡಿದ್ರು ಸಹಿತ ಸ್ಟಿಲ್ ಯು ಫಾಲ್ ಶಾರ್ಟ್ ಆಫ್ 2.
ಇಲ್ಲ, ಇದನ್ನ ಮಾಡಿದ್ರೆ 96.91 ಬರುತ್ತೆ ಸರ್.
ಹೆಂಗ್ ಬರ್ತದ? ನೀವೆಲ್ಲವಕ್ಕೂ ಅಷ್ಟು 6 ವರ್ಷಕ್ಕೆ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಬೇಕು.
5 marks 6 marks ಆಡ್ ಮಾಡಿದ್ರೆ
6 ವರ್ಷ ಮಾಡಕ್ ಬರಲ್ಲ. 7 ಮಾರ್ಕ್ಸ್ ಆಡ್ ಮಾಡಿದ್ರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಆಗ್ತದೆ.
ಇಲ್ಲ
ಹಂಗ್ ಮಾಡಕ್ ಬರಲ್ಲ. ನಿಮ್ಮ ಟ್ರೇಡ್ ಲೈಸೆನ್ಸ್ ಎಷ್ಟು ಪೀರಿಯಡ್ ಇದೆ ಅಷ್ಟನ್ನು ಮಾತ್ರ ಮಾಡ್ಲಿ. ಅದ್ ಮಾಡಿದ್ರೆ ಅದು ಆಗಲ್ಲ.
ಅಲ್ಲ, ಫೋರ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಸರ್ಟಿಫಿಕೇಟ್
ಬರ್ಕೊಳ್ಳಿ. Petitioner is knocking at the doors of writ court for assailing the tribunal's order dated 9/2/2024, whereby his application number 4282 of 2023 has been negative. Full stop. In the said application, he had called in question the order dated 19/6/2023, whereby the private respondent having been selected for the post of cook in question, he was denied selection to the same on the basis of comparative merits. First, next one. Learned counsel appearing for the petitioner draws our attention to page rock bottom of page 41, wherein it is prescribed that the experience certificate would be reckoned if such experience in cooking is gained in a licensed eatery and not otherwise. First off, he immediately adds that once eatery has some trade license, pre-trade license experience also needs to be counted. First off, this is where learned EGA appearing for the official respondents and later private counsel appearing for the private respondent disagree. First off, both they submit that the private respondent herein had secured 96 marks, had secured 100 marks. However, 4 marks came to be discounted for lack of trade license, wherein the trade license of the eatery. First off, that being the position, the private respondent would be more meritorious apparently, and therefore order of the tribunal cannot be faltered. First, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned EGA and the private counsel appearing for the private respondent. First, apparently, the petitioner had the experience in the eatery having trade licenses, not for 6 years, but short of that, much short of that. First off, therefore 6 years cannot be added to his score, that is 90.91. First off, it is on this principle that 4 marks of the contesting private respondent has been discounted. First off, arithmetically speaking, the private respondent has secured 96 marks because it is 100 minus 4, and the petitioner has scored only 90.91 marks. First, this being the operative position, the order of the tribunal cannot be faulted. First, in the above circumstances, petition being devoid of merits is liable to be, and accordingly it is rejected. For 7 days. Next. ಯಾರು ಅಫಿಡವಿಟ್ ಬಂದು ಜೋಶಿ ಅವರು ಕರೀತಾರೆ. ರಾಜಗೋಪಾಲ್ ಯಾವ್ದಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ದೀರಿ? ತೋಡ್ರಿ ರಾಜಗೋಪಾಲ್ ಅವ್ರು ತೋಡ್ರಿ. ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ.
What I have questioned is suspension.
ಹಿರೇಮಠ್. ಹೌದು, ಹಿರೇಮಠದ್ದು ಒಂದು ಅದಾದ್ಮೇಲೆ ತೋಡ್ರಿ. ಅಥವಾ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ, 2:15 ಬನ್ನಿ. This will take some time. Remitted matter. Are you ready in the matter? Please come. Alle 41 ಇದೆಯಲ್ಲ, page 41 ಅಂತ call out my read as and bottom. Yellow ಹಾಕಿದೆ ನೋಡಿ. Yes, ಏನಿದು Remitted?
My only grievance before the tribunal in the original application was to consider my request for the claim for promotion to the post of the sub-inspector of excise from the feeder cadre of drivers and senior drivers. There is a recommendation of the high power committee as well as my head of the department as per the 8 and 4.
Why tribunal denied?
Rejected on the ground of delay, and there is no such power for the tribunal to issue such direction, relying on The
Thank-
Joshi's case.
Kindly see the prayer sought by the petitioner.
Where is your prayer in the application?
Madam, my
In
application.
page 83, my lord.
83. Oh, 83 ಅಲ್ಲ, 80 is not.
KT order ಅಲ್ಲಿ
80 ಅಲ್ಲ, your prayer ಎಲ್ಲಿದೆ? Your
My prayer is at page annexure, page 32.
30?
32, 32. 31, live sought for, page 31.
Consider recommendation of respond for dated so and so, therefore amending the proviso to Karnataka Excise so and so. Consequently, direct respondent to consider the request of applicant for promotion to the post of sub-inspector Excise.
The recommendations of 1816 and 18 by the high power committee as well as the fourth respondent commissioner, who is the head of the department.
Rules amend ಆಗಿದ್ದೇನಿದೆ ಅದು?
My lord, Karnataka Excise Service Recruitment Amendment Rules
Up to
2002.
page 43, 44. 44. 2% by promotion from the cadre of senior drivers.
Yes, ma'am. That was only for 3 years, my lord.
That
That was only that,
Well,
my lord, that
two
rules
five-
which were amended. Senior driver could be promoted to superintendent. That was applicable only for 3 years.
ಎಲ್ಲಿದೆ?
Rules, my lord.
Which rule? Time bound ಇತ್ತ ಅದು?
Yes, my lord.
Oh, 3
Time
years.
bound ಇತ್ತು. That is, and my lord, insofar as amending or that is the domain of the respond number 2, my lord.
ಅದಾಯ್ತು, ತೋರಿಸಿ,
Yes.
ರೂಲ್ ತೋರಿಸಿ.
Rule, yes, my lord, I will. Notification.
Excise. Don't quote it.
Subdivision assistant substantial in the ratio between. Vacancy being-
83. Page 83.
Idon.
Page?
83 is the notification. This is amended.
83.
83 ಅದು
ಯಾಕೆ 83 ಇಂಪ್ಲಿಮೆಂಟ್ ಆರ್ಡರ್ ಅದು? ಟ್ರೈಬ್ಯುನಲ್ಸ್ ಆರ್ಡರ್ ಬಗ್ಗೆ ಹೇಳ್ತಾ
ಅಲ್ಲ,
ಇದ್ದಾರೆ.
A1
ಆಸ್ಕಿಂಗ್ ಯು
ಅಲ್ಲ,
that rule
page-
says.
Pagination, my lord. It was only, I have to point out that it was only for 3 years.
That you should
Yes,
show
Yes, my
the
lord.
text of the rule only.
Yes, my lord. I understood, my lord. Page 51, my lord. It's
Page?
highlighted. 51. ಅಲ್ಲೂ ಹೇಳ್ತಾರೆ, this is
51.
3 ವರ್ಷದ ಅವಧಿ.
3 ವರ್ಷಗಳ ಅವಧಿ ಮಾತ್ರ ಜಾರಿಯಲ್ಲಿ
ಬೇಸ್
ಇರುತ್ತದೆ.
ಏನಿದೆ ಅಂತ ರೂಲ್ಸ್
Yes.
ಪ್ರಕಾರ ತೋರಿಸ್ಬೇಕು. ನಾಟ್ ಸಮ್ ಸರ್ಕ್ಯುಲರ್.
But I
Rule
had-
should say that this is for only particular period because of special circumstance. ಅದು ತೋರಿಸ್ಬೇಕು. ಅದೆಲ್ಲಿದೆ?
I'll point out, my lord.
3 ವರ್ಷಕ್ಕಂತ ಇತ್ತ ಅದರಲ್ಲಿ?
3 ವರ್ಷಕ್ಕಂತಾನೆ ಇದೆ. my lord. That
2000
is
ಹಂಗೆ ರೂಲ್ಸ್ ನಲ್ಲಿ ಬೇಕು. ಯಾವ್ದೋ ಸರ್ಕ್ಯುಲರ್ ಇಂದ ಮಾಡಕ್ ಬರ್ತದ?
No,
ರೂಲ್ಸ್
my
ಹಿಂಗೆ ಇರುವಾಗ.
Rules, I'll point out, my lord. KT has also relied on PU Joshi's case also, my lord.
Huh?
PU Joshi case also they have relied on, and
ಅದು ಪಿ ಯು ಜೋಶಿ ಕೇಸ್ ಏನದು?
that is regarding, my lord,
ಯಾವ ಸ್ಟೇಟ್ ಅದು? ಅಹಮದಾಬಾದ್.
it's Ahmedabad, my lord, Ahmedabad.
ನಿಮ್ ರೂಲ್ಸ್ ಹೇಳ್ರಿ, ನಮ್ಮ ಸಪರೇಟ್
ma'am.
ರೂಲ್ಸ್ ಇದಾವಲ್ಲ. ಆ ರೂಲ್ಸ್ ನಲ್ಲಿ
kept
ಇದು
the rules,
3
madam.
ವರ್ಷಕ್ಕೆ ಅಂತ ತೋರಿಸಿ ನೋಡೋಣ.
Files ಅಲ್ಲಿ rules ಇಟ್ಕೊಂಡಿದ್ದೆ. I had
ಅಲ್ಲಿ
kept the
ಏನೇನ್
rules.
ಇರ್ತಾವ್ ನಮ್ಗೇನ್ ಗೊತ್ತು? ಒಂದೊಂದ್
Monday, my
ರಾಜ್ಯಕ್ಕೆ
lord,
ಒಂದೊಂದು-
I have kept the I had kept the rules with me. Monday I'll point out.
All right.
Madam, given,
ಅವ್ರೇನೋ ಹೇಳ್ತಾರೆ ನಿಮ್ಗೆ.
ಅಲ್ಲ ಅವ್ನು ಕೊಟ್ಟಿದ್ದೇನೆ ನಾ rule. 5302ಗೆ 3 years ಅಂತ ಮಾಡಿದಾರೆ, ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿದಾರೆ 3 yearsಗೆ ಅಂತೇಳಿ. ಅದನ್ನ ರಿಲ್ಯಾಕ್ಸೇಷನ್ಗೆ ಈ ರೆಕಮೆಂಡೇಶನ್ ಮಾಡಿರೋದು.
ಮೂರು ವರ್ಷಕ್ಕಂತಿದೆ. But then she is right.
ಅಲ್ಲ,
3 ವರ್ಷಕ್ಕಿಂತ she is right there.
ಇದು
ಅದು overcome ಮಾಡೋದು ಹೆಂಗೆ?
ಇದು ಅನ್ಜಸ್ಟ್ ಅಂತ ಹೇಳೇನೆ there is a recommendation by the high power committee. It causes 3 decades.
Rule amend ಮಾಡ್ಬೇಕಲ್ಲ. ಹೈ ಪವರ್ ಕಮಿಟಿ
ಅದನ್ನ ಮಾಡಕ್ಕೇನೆ ಪ್ರಪೋಸಲ್ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮ್ಯಾಗ ಒಂದು ಡಿಸಿಷನ್ ತಗೊಳ್ರಿ
At least
I-
high power committee said,
ನೋ ಪ್ರೆಜುಡಿಸ್ ವುಡ್
ಏನೋ ಅನ್ಯಾಯ ಆದಂಗ ಆಗಿದೆ, ಹಂಗಾಗಿ ರೂಲ್ಸ್ ಅನ್ನ ಅಮೆಂಡ್ ಮಾಡಬಹುದು ಅಂತ ಕಳ್ಸಾರ. ಅದ್ರ ಮೇಲೆ ಒಂದು
Committee has recommended, I understand.
ಆ ರೂಲ್ಸ್ ಅದ್ರ ಮೇಲೆ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅದಿಷ್ಟೇ
ಅದನ್ನ
ಕೇಳಿ
consider
ನಾ ಕೇಳಿದ
ವಿಲ್ ಕೀಪ್ ಓಪನ್ ದಟ್ ಪಾಯಿಂಟ್ಸ್, ದಿ ರೂಲ್ಸ್ ಏನಿದಾವ ಅಮೆಂಡ್ಮೆಂಟ್ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ದು ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಅಷ್ಟೇ ಸಾಕು.
ಇರಲ್ಲ,
ನಿಮ್ಗೆ ಹೆಂಗೆ ಅದೇ ಹಂಗೆ,
Yes.
ವಿಚ್ ಎವರ್ ವೇ ಯು ವಾಂಟ್. We are not saying because we cannot direct, you should make rule like this only. We can undo the rule. We cannot ask you to do the rule.
My only request is to consider this.
Berkali. Petitioners who aspire promotion to the higher level are grieving before the writ court against the state administrative tribunal's order dated 29 May 2024, whereby their application numbers 1827 to 1834 of 2024 have been negatived. First off, in the said applications, they had made the following prayer, application del prayer hakumbudu, note count. First, learned counsel appearing for the petitioners submits that the Karnataka Excise Services Recruitment Rules 1996 as amended vide notification dated 5/3/2002 prescribes a particular period for considering the claims for promotion of employees in the cadre to which the petitioners do belong. And therefore, and that having resulted into prejudice, comma, a high power committee constituted by the government itself, wide recommendation dated 6/4/2018,
A4.
a copy whereof avails at annexure A4, opined that the time, the period restriction which otherwise would come in the way of eligible candidates being considered for promotion should be relaxed. First, that having not happened, comma, the KT fell into error, comma, submits the counsel for petitioners. First, next one. Learned AGA appearing for the respondents, resisting the petition, argues in support of the reasoning of the KAT. First, she further contends that what rules are to be made and what amendments to be made to the existing extant rules are a matter of policy, and the KAT could not have said anything about that, and accordingly it did not. And therefore, even the writ court cannot say in matters like that. First, in support of that contention, she banks upon the decision of the apex court in Yaudadu.
P.U. Joshi versus
Huh?
P.U. Joshi.
P.U. Joshi.
2003
State
to
of-
SCC 632.
Joshi versus so and so,
SCC.
2003
2003.
SCC, 6 SCC,
2003 part 2 SCC 632.
2 SCC, 632. First. Next, having heard the learned counsel for the parties and having perused the petition papers, we are of the considered opinion that the government, being the rule-making authority under the provisions of Karnataka Civil Services Act 1978, stroke 309, Article 309 of the Constitution of India, cannot sleep over recommendation of the high power committee eternally. eternally. First up. When it has constituted the committee, comma, it owes a duty to consider recommendation of such committee, this side or that side. First up. This aspect of the matter having not been adverted to by the tribunal, comma, its order has error apparent on its face, warranting interference at our hands. First, in the above circumstances, this petition succeeds. Semicolon. The impugned order of the tribunal is set at naught. Semicolon. A direction issues to the government to consider high power committee's recommendation ಅಲ್ಲಿ high power ತೆಗೆದು
Like proceedings of the, it is just a
the
proceeding.
recommendation of the committee
for
dated the
C&R
6/4/2018.
for revision of the C&R rules.
Committee for revision of C&R rules dated 6/4/2018.
Of Excise Department.
ಅಲ್ಲಿ all in
Page 57 ನಲ್ಲಿ.
7 ದಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕು. First, time for compliance is 6 months. Okay. All contentions are kept open.
Please.
We have not expressed any opinion
Please.
as to the merit or otherwise of the recommendation.
Obliged.
Very easy. Very easy. Ah. 7. ಮಧ್ಯಾಹ್ನ ಇದು ಇದೆಯಾ? ಎರಡಿದೆ. After vacation ಹೋಗುತ್ತೆ mostly.
To whichever industries the land has been sold to, my lords, we will make an attempt to impress upon them if both eligible as well as qualified workmen make an application. We'll try to impress upon them, my lords, to take them into employment.
That's a good gesture. Just give us the modality, how you are going to do that.
My lords, let whoever is eligible as on date, my lords, whoever has not passed the age of superannuation, make an application. And along with their qualifications, whatever is their skill that is there, the industries, my lords, are likely to be put up within 2 to 3 years' time. I'm given to understand that 2 to 3 years' time is the requirement time, because as it stands, even today, the land is vacant, my lords. Because of all these disturbances, the land stands vacant. Even as of today, my lords, there's a PIL listed before the Honorable Chief Justice's bench
Against your
against the party, stating that this is a government land, government Gomala land. Aduna mutation entry na change ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿ. Even as of today, my lords, it's listed at serial number 35 before the Honorable Chief Justice's bench.
ಏನಾಯ್ತು?
ಅದು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ಅವರು ಪಿಟಿಷನರ್ಸ್.
ಬರ್ಕೊಳ್ಳಿ. Mr. Shankar, anything you have to say?
Yes, something more to be stated. His vendor has given an undertaking to the court that he is not an estate dealer, he would not sell the property. 1, 2 is, he would re-employ all these persons as in the date of winding up.
When it was given?
That document, as I submitted, ನನಗೆ
where it is given, where is the indication to that effect? Can you show that?
By responding to the statement of the official liquidator, pointing out the irregularities, he has admitted, yes, and vendor has gone and ಇದು
of 2013 was submitted by SDOR for waiver of the company. That was admitted and directed by SDOR to talk of the meetings of the interested parties. Majority of the interested parties approved the scheme of arrangement. Then he filed a public petition 34 of 2014. For that, he issued a notices to the company, all the interested parties, including company now about actual liquidator. Actual liquidators made serious observations and also raised a serious question. In that, after analyzing some of these things, he mentioned that he is spending around 16 crores of amount for the expenses of the scheme of arrangement, whereas the cost of the land was about 60 crores. Therefore, for current commitment, he insisted that he should give a written affidavit that he should not sell the lands in real estate business. He should use the lands for waiver of the company.
That is against whom?
Against SDOR.
Wendy's. They're Wendy's. Take action against them.
He's supposed to bring in his own for waiver of the company. He should take.
Is he a party here?
Yes, ma'am.
He's a party. Yeah, which party?
SDA, propounder. He's the propounder of the scheme.
Who appears for the ST?
Both the propounder of the scheme as well as the company I appear, my lords.
He appears for the propounder.
I appear.
Vendor and Wendy, he both.
I am not aware of this affidavit, my lords.
For that, sorry, assisting the court, my lord, I am for one of the employees. My application is before my lord. In 2014, my lord, the propounder of the scheme files an affidavit, my lord, to say that he will not dispose of his property, he will accommodate his working. My application is only for implementation of the scheme, as far as I am concerned.
That comes only after this is 391 na estadu? 391 to 390.
One aspect, my lord, is now the actual propounder of the scheme has now sold part of this land to a third party. Now the affidavit filed is by the propounder. Now the third party would come before this court and say, I have not filed any undertaking, I have not given any affidavit, so it is not my business to employ you.
Now, you seek implementation of the scheme.
Yes, all that I am seeking is give me my employment. That's my prayer, my application.
All right, you are 390.
That is a part of the record. It's ಹುಡುಕ್ ಕೊಡ್ಬೇಕಷ್ಟೇ. In the haystack, I have to search for a pin. Very sad. And my lord's hands are strengthened by the judgment of Ray, Beg, and Jaswant Singh is exactly in identical circumstances. They must be purged. They must be asked to purge the contempt.
Where is the contempt?
The court says, giving an undertaking to the court and violating that is a contempt, and that contempt can only be resolved by purging. I'm giving it to the moment.
If there is a contempt, very well. That's the law.
No, contempt bere, contempt bere. They have serious, author of several contempts. No problem. The only thing is, we will be wearying your lordship with dusty papers. That's that if my lord will excuse us. I don't mind getting going. I may have to go to doctor next evening. Another matter. But ತುಂಬಾ ಹಳೆ ಪೇಪರ್ಸು ಮುಟ್ಟಿದ ಒಡೆದೋಗ ಪೇಪರ್ ಆ ಥರ ಇದೆ ಇದು. ಒಂದೇನಾಗಿದೆ, he may be new to the records. I do not know who was the earlier advocate. We are all set of new persons now in charge. Subrao is no more. And the reason is, we have got to put it across to the court. Adana, and my lord mentioned Ramakrishna Menon's case. I have cited it already and made it available. Para 13, Justice Chinnappa Reddy, dissenting from the view of Honorable Justice E.S. Venkatramaiah, who is in the majority of the 3:2, in the majority, says, I give this, ಅಲ್ಲ ಅವರು ಶೇಕ್ಸ್ಪಿಯರ್ನ ಕೋಟ್ ಮಾಡಿ ಬರೆದಿದ್ದಾರೆ, ಅದನ್ನು ತಮಗೆ ಹೇಳಬೇಕು. These are the only two submissions I have to make.
Ultimately, it boils down to whether you want to go ahead with the contempt, putting him
No,
jailik ಕಳಿಸಿ ಅದು ಏನ್ ಮಾಡ್ತೀರೋ
ರಿವೈವ್ ಅದಕ್ಕೆ ಅದು ಅಸಿಸ್ಟ್ ಮಾಡಿ. ಇಲ್ಲೇನಾಗಿದೆ, ನಮ್ಗೆ ಏನೂ ಇಲ್ಲ, ನಾವೇನು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಇವರು. ಇವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ, ಈ ಹೊಲ ನಿಮ್ಮ ಮಾರ್ದವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು ನಾನು. That runs with the land. Covenant runs with the land.
ಈ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ, ಆಯ್ತು, ಅವನು ಆಮೇಲೆ ಇವ್ರಿಗೆ ಮಾರ್ದ.
ಮಾರ್ದೆ ಅವನು.
ಈಗ ಅವ್ರನ್ನ ಜೈಲಿಗೆ ಕಳಿಸ್ಬೇಕು.
ಇವ್ರದ್ದು ಲೀಗಲ್ ಒಪಿನಿಯನ್ ತಗೊಂಡಿದ್ದಾರೆ. ಆಲ್ ದಿಸ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ಸೀನ್. ಟೈಟ್ಲ್ ಇಸ್ ಕ್ಲಿಯರ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವರು. We will see. So
that person propounder, he lifted his hand.
ನಮಗೆ ಇಷ್ಟೇ, ನಮಗೆ ಕೆಲಸ ಕೊಡಿ, ನಮಗೆ ಕೆಲಸ ಕೊಡಿ.
ಹಾಕಿದ್ದು ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ? ಈಗ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಆರ್ ನಾಟ್.
We are exploring the possibility of requesting the honorable court to give us some relief. ಆಗತ್ತೆ, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಓನ್ಲಿ ನಾವು ಹೇಗಿದ್ದು 14 ವರ್ಷ ಕೋರ್ಟ್ಲಿ ಕಳೆದಿದ್ದೀವಿ, ಇನ್ನೊಂದು ವಾರ ಏನ್ ತೊಂದರೆ ಇಲ್ಲ. ಟ್ಯೂಸ್ಡೇ ಆರ್ ವೆನ್ಸ್ಡೇ ಹಾಕ್ಬಿಟ್ರಾಯ್ತು. ಸಬ್ಜೆಕ್ಟ್ ಬೈ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಬೋರ್ಡ್ ಇಸ್ ವೆರಿ ಹೆವಿ.
ಇಲ್ಲ, ಅದೇನ್ ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ ನಾವೇನ್ ಕೇಳ್ತಾ ಇದೀವಿ ಅಂದ್ರೆ, ಇಷ್ಟು ದಿವಸ ಯು ಟುಕ್ ಅಪ್ ದ ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ಕಂಪನಿ ಶುಡ್ ಬಿ ವೌಂಡ್ ಅಪ್ ಅಂತ ಮಾರ್ನಿಂಗ್ ನಿಂದ ನಾ ಹೇಳ್ತಾ ಇದ್ದೀನಿ.
ಇನ್ಕನ್ಸಿಸ್ಟೆಂಟ್ ಸ್ಟ್ಯಾಂಡ್,
ವೆರಿ ಇನ್ಕನ್ಸಿಸ್ಟೆಂಟ್. ದೇ ಆರ್ ವೆರಿ ಟ್ರೆಚರಸ್ ಸ್ಟ್ಯಾಂಡ್. Very treacherous stand, because you want the honey, but you want to pick the hive.
Subrao has made a note. I can take mutually destructive defense ಅಂತ ಹೇಳಿ ಬರ್ದಿಟ್ಟಿದ್ದಾರೆ. ಅದು 99 ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 1441 ಹೆಡ್ ನೋಟ್ ಬಿ.
ನಾವು ಮಾಡ್ತೀವಿ, ನಾವು ನೀವಂಗ ಆರ್ಗ್ಯೂ ಮಾಡ್ರಿ, ನಮ್ಗೆ
ಅಯ್ಯೋ, ಈಗ ಉದ್ದ ಮಾಡ್ಕೊಂಡು ಹೋಗೋದು ಬೇಡ, ಉದ್ದ ಮಾಡ್ಕೊಂಡು ಅಫಿಡವಿಟ್ ತೋರಿಸಿ ತಮ್ಗೆ ಹೇಳ್ತೀನಿ ನಾನು.
ಅದರ ಆಸ್ಪೆಕ್ಟ್, that apart, where did you allow him to found the industry at all? You made him to
ಅಲ್ಲ, ಅದು ನಾವೇ ಅಲ್ಲ,
in the court hall, court corridors throughout.
ನಾವಲ್ಲ, ಯಾರು ಸಹ ಅವ್ರಿಗೆ ಎಕ್ಸೆಪ್ಟ್ ದಟ್ ಗೋಮಾಳ್ ಲ್ಯಾಂಡ್ ಅಂತ ಹೇಳಿ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡಿದ್ರೆ ಅದರಿಂದ ಅವ್ರು ತಾಪತ್ರೆ ಆಗ್ತದೆ, ನಮ್ದು ಯಾರ್ದು ಅಲ್ಲ.
ಅಲ್ಲ, ನೀವೇ ಕೇಸ್ ಹಾಕಿದ್ದು ವೈಂಡಿಂಗ್ ಅಪ್ ಮಾಡಬೇಕು ಅಂತ ಅನ್ಕೊಂಡು. You took up the stand that the company should be wound up, and it was ordered to be wound up.
Please do not forget, we carry a red flag, sickle and hammer in our hand. Therefore, we owe it to ourselves to obstruct anything that is lawful.
Now, number one. Number two, he is facing the villagers, and therefore he has filed a suit. Two suits are pending.
And today, my lords,
a PIL is pending, where the villagers are saying the land granted to him is a Gomala land, and therefore grant should be.
Another striking feature is KIDB sold it to them for 2 lakh. They have sold it for 15.8 on record, 153 on black and white. We get that. We'll get all that information. We lawyers have some responsibility to assist your lordship.
Correct.
To go from page 1 to the end, I took 1 week's time. It's a little difficult. I have now laid my hands on the proper papers. Kindly have it on Tuesday.
All right.
And that way, my lord can proceed to judgment.
Before your lordship's adjourns, I'll not take your lordship's time much. My lords may kindly see my objection statement to this OSA, where, my lords, the very list that they have prepared today, all of them, my lords, on 27/4/1994 itself, they stated that it was your full and final settlement and your employment will cease from the aforesaid date. ಅಂತ ಹೇಳಿ ನಾನು objection ಹಾಕಿದ್ದೇನೆ. ಪೂರ್ತಿ ಅವರು ಕೊಟ್ಟಿರುವಂತ ಲಿಸ್ಟ್ ಪೂರ್ತಿ ಇವತ್ತು ಕೊಟ್ಟಿರುವಂತ ಲಿಸ್ಟ್.
Where
May
they have
kindly
stated.
request your lordships to see page 78.
They have taken money.
They have taken money, my lords. I'll
No, no,
just
there are
demonstrate.
two- there
I'll
are
just
two,
demonstrate.
amount due, there are two heads, O and N, 25 O and 25 N. One head, they have paid the money, the other head they have not paid. Ramakrishna Menon is on the other head, namely closure of the company without permission of the government.
ಆ ರೀತಿ ಇಲ್ಲ.
Objection to
ಅದು
original
ಟ್ರಾನ್ಸ್ಫರ್
statement.
ಆಗಲ್ಲ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ರು. ನಿಮ್ಮ ಚಾಲೆಂಜ್ ಅನ್ನು ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
That-
Division bench
yes,
also
yes, yes.
rejected it. Transfer of share capital will not amount
It's not amount to transfer the undertaking.
ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ. Anyway, ಅವರೇನೋ
10/11/2016
ಏನೋ ತೋರಿಸ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದೇ
paper ಅಲ್ಲಿ.
ಇವರಿಗೆ
Call
he
this
must
matter.
purchase peace.
If you have already taken money.
No, no, under two heads. That's exactly the ground on which it is restored.
Under-
Ms. Kasturi made its opening statement that we have paid, same statement, we have paid the money, paid money for the layoff. The other head under which we had entitled to is closure of the company without permission of the government. There are two separate heads. That's the ground on which OSA is entertained. Fourth court ಎಲ್ಲ detail
ಆ ಗ್ರೌಂಡ್ ಇಲ್ಲಿ ಹೆಂಗ್ ಬರ್ತದೆ? If closure is unlawful, your remedy lies elsewhere. ಅದು ಇಲ್ಲಿ ಹೆಂಗ್ ಇದು ಈ
ಇಲ್ಲೇ ಬರುತ್ತೆ.
It has already been adjudicated, my lords. By the learned single judge has adjudicated clearly that whether the question of whether the retrenchment was illegal or not, and whether the closure of the undertaking itself was illegal or not had to be decided by the Industrial Disputes Tribunal. That not having been decided at all, even as of date, admittedly, my lords, them coming and re-agitating this before the company court, my lords, my humble submission is it speaks volumes about their conduct. Because they have taken money, the very first name, my lords, who have they have stated, I have produced along with my statement of objections, my lords.
ಮಂಗಳವಾರ ಏನ್ ಹೇಳ್ತಾರೆ ಹೇಳಿ ಬಿಡಿ.
Very well, my lord.
Wednesday for further hearing. One small note ಮಾಡ್ಕೊಂಬಂದು.
Because I will endeavor, my lords. My instructions are that whoever puts up the industry there, we will endeavor to impress upon them to take qualified and eligible workmen. Because it is all industries that are going to come up. We do not want to scuttle any industry coming up there.
ನೀವು ತಗೋಬೇಕು, ನಿಮ್ಮ ಇಂಡಸ್ಟ್ರಿಗೂ ತಗೋಬೇಕು. ನೀವು ಯಾರಿಗೆ ಮಾರಿದ್ರಲ್ಲ ಅವ್ರ ಇಂಡಸ್ಟ್ರಿ ಮಾಡಿದಾಗ ಅವರು ತಗೋಬೇಕು.
ಹೌದು, ಅಂದ್ರೆ ನಾನು we will impress upon them whoever is qualified and eligible. 30 years, 1 second sir. 30 years have lapsed, my lords. From the year 1994 they have been
ಯಾರು ಏಜ್ ನಲ್ಲಿ ಇದ್ದಾರೆ, ಯಾರು ಕ್ವಾಲಿಫೈಡ್ ಅಂಡ್ ಎಲಿಜಿಬಲ್
Very well,
ಅವ್ರು ತಗೋ. ಎಷ್ಟು ಜನ ಇರ್ತಾರೆ?
ಅದಕ್ಕಾಗಿ ನಾನು that is the undertaking that I am instructed to give, my lords, and I am giving that.
That's the best of the bad bargain.
That's what. ಅದನ್ನ ನೀವು ಒಂದು ದಿನ ಹಾಕಿ,
ಹೌದು,
ಒಂದು write up ಹಾಕಿ.
We are agreeable. ಅವ್ರು 10 ಪೈಸೆ ಕೊಡೋ ಬದಲು 1 ಪೈಸೆ ಕೊಡಿ ಅಂತ ನಾವು ಕೇಳ್ತಾ ಇದ್ವಿ, ಅದು ಕೊಡಲ್ಲ ಅಂದ್ರೆ
ಅದೇನ್ ನೀವು ಎಲ್ಲ ತಗೊಂಡು ಎಲ್ಲ ಕೊಡು ಅಂದ್ರೆ ಮತ್ತೊಂದ್ ಸರಿ
ಈಗ ಅವ್ರಿಗೆ ಅಡ್ವೊಕೇಟ್ಸ್ ಬಿಟ್ಬಿಟ್ಟು ಪಾರ್ಟಿ
ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಆನ್ ಸೊ ಅಂಡ್ ಸೊ. ಆಲ್ ರೈಟ್, ಇದು ಮುಗಿಸ್ಬೇಕು. ಮತ್ತೆ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಮತ್ತೆ ಹೊಸ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ರಿ. ಆದ್ರೆ
Wednesday, my lords.
ವೆಡ್ನೆಸ್ಡೇ ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
I'm grateful, my lords.
ಸ್ಮಾಲ್ ರೈಟ್ ಅಪ್ ತೊಗೊಂಬರ್ಬೇಕು ಎರಡು ಸೈಡ್.
Very well.
ನೀವೇನ್ ಹೇಳ್ತೀರಿ ಅನ್ನೋದನ್ನ.
I'm also trying to convince my party, my lords, for some sort of monetary compensation, at least if they.
At least ಅಷ್ಟು ಮಾಡಿದ್ರೆ ಮುಗಿಸಿ ಬಿಡ್ಬೋದು.
Very well, ma'am. I'm just.
ಏನೋ ಒಂದು ಬೈಯಿಂಗ್ ಪೀಸ್ ಅಪ್ಪ ತಗೊಂಡದ್ ರೈಟ್.
Therefore, my lords, I will also make my attempts.
ಮೋಕ್ಷಂ ಬನ್ನಿ.
I'm grateful.
ಮೋಕ್ಷಂ ಅತ್ಲಾಗೆ ಬರುವಾಗ ಸ್ವಲ್ಪ ಒಂದು ಚೆಕ್ ಬುಕ್ ತೊಗೊಂಬಂದ್ಬಿಟ್ರೆ ಒಂದ್ ಎಂತದ ಕೊಟ್ಟತ್ಲ ಮುಗಿಸಿ.
ಕಷ್ಟ ಏನು ಅಂದ್ರೆ ಅವ್ರು ಆಂಧ್ರ ಪ್ರದೇಶದಲ್ಲಿ ಇದಾರೆ, ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕಷ್ಟೇ.
ವೆಡ್ನೆಸ್ಡೇ.
Very well.
ವೆಡ್ನೆಸ್ಡೇ ಅಡಿಲ್ವಾ?
Very well. Very well.
ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್.
I appear for the petitioner. Petitioner in 19135 is being led by Mr. Dhananjay Joshi. He's in court hall 2, my lord. A short passover may be granted.
2.
Yes, my lord.
After vacation, Mr. Mukherjee will have this immediately after vacation because our board is late.
I leave it to the court, my lords. Otherwise, this matter has been prolonged for quite a while, my lords, by the indulgence which are.
In fact, we are asking for the adjournment.
No, sir. No, lordship.
This,
Never ask for an adjournment. I've seen my lords board, my lords, how heavy it is, and how your lordships have been trying to revive this company and work out something for the betterment of the workmen.
Next,
Lordship may kindly
all
have it
these
part heard.
matters in the second week of January 2025.
Lord, interim orders may be extended.
Interim order to continue till then.
My lord, any particular date, that is all I would request. Whatever is convenient to the court, any date.
The second week of January.
Very well.
In that week it will come.
All right. I'm grateful.
Next. ಯಾವ್ದೋ ಒಂದೆರಡು ಮ್ಯಾಟರ್ಸ್ ಏನಾದ್ರು ಯಾವ್ದೋ ಒಂದು ಕೂತ್ಕೊಂಡಿದ್ರು ರಾಜಗೋಪಾಲ್ ಒಂದು ಯಾವ್ದು ಕೂತ್ಕೊಂಡು
where suspension has been challenged on the ground that this whole allegation against me is that even after being relieved from the office of the Deputy Commissioner Mysore, I have attended a file in that office. Then, my lords, I placed before my lords, though the transfer, the CTC states that I have been relieved on 10th of February. Actually, I was relieved on the morning of the 13th February, and I have placed e-files also in support of my contention. Now, my lords, all that may not be necessary to be gone into. What has happened is, the page 100, order of suspension is dated 5th of June 2024. Yeah. 6 months have expired on 4/12/2024. No decision has been taken within 6 months to continue my suspension. And by virtue of
what Apex Court said?
Oh, not the Apex Court said not there in that
central,
case 3 months ಅಂತ ಹೇಳಿದ್ರು.
ಅಲ್ಲ ಸೆಂಟ್ರಲ್ ರೂಲ್ ಹಂಗಿತ್ತು ಅನ್ನೋದು.
ಸೆಂಟ್ರಲ್ ರೂಲ್ ಅಲ್ಲಿ ಹಾಗೇನು ಇರಲಿಲ್ಲ. ಸೆಂಟ್ರಲ್ suo the court said, since the right to speedy trial is a part of service law also, 3 months only, if you do not issue a charge sheet, it is deemed to have been vacated. Subsequently, my lords, perhaps based on that judgment, the Karnataka, the state government has amended its rule and inserted clause B of sub-rule 5 of rule 10.
Providing 6 months.
6 months, and there is a further rider there, my lords. If a decision is not taken to extend the suspension within 6 months' time, the suspension is deemed to have been vacated. Now what that is the now say before 4/12 no order has been served on me extending the suspension. Now what they say is that we have dispatched the charge sheet.
9/12 we have we have on 9/12 your lordship we have issued.
9/12 ಹಿಡಿದ್ರು 4/12 ಗೆ ಟೈಮ್ ಮುಗಿದು ಹೋಗ್ಬಿಡ್ತು.
ಅಲ್ಲ ಆಕ್ಚುಲಿ 4/11 ಗೆ ಮುಗಿದೋಗ್ತು.
4/11 ಗೆ ಮುಗಿತು.
ಹೌದು 4/12 ಗೆ ಆಗೋದಿಲ್ಲ.
4/12 ಆಗುತ್ತೆ. 5/6 ಅಂದ್ರೆ 12. 6
months. ನಿಮ್ ರೂಲ್ ಕೆಳಗಡೆ 6 months ಇದೆ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 3 months ಹೇಳಿತ್ತು. ಬಟ್ ಅಮೆಂಡೆಡ್ ರೂಲ್ ಕೆಳಗಡೆ 6 months ಇದೆ.
6 months.
ಹಂಗಾಗಿ 5/6 ಇದ್ರೆ 4/12
ಗೆ ಕಳಿಸಿದ್ರು.
ಅಂದ್ಮೇಲೆ ಸಸ್ಪೆನ್ಷನ್ ರಿವೋಕ್ ಆಗಿದೆ ಬೈ ಆಪರೇಷನ್.
It is deemed to have been revoked.
He cannot be reinstated to the same place. That is
wherever ಅಲ್ಲಿ ಕಳಿಸಿದೀನಿ. ಸಸ್ಪೆನ್ಷನ್ ರಿಸೈನ್ ಮಾಡ್ರಿ. ಮಾಡೋ ಅಗತ್ತಿಲ್ಲ. ಅಮೆಂಡ್ ರಿಸೈನ್ಡ್ ಆಗಿದೆ. posting ಕೊಡಬೇಕಾಗುತ್ತೆ.
My lords may declare that it is deemed to have been vacated, and my lords may say, my lords, treatment of suspension period and all may be agitated and final order is passed. All contentions on this aspect are kept up.
ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ ನೀವು ಇದರಲ್ಲಿ? KAT ಅಲ್ಲಿ ಏನ್
KAT ಅಲ್ಲಿ ನಂದು ಅವರು KAT
para 6 euro. Para 6 ಅಲ್ಲಿ
came with the it has dismissed my application, holding that there has been application of mind without looking into the electronic file evidence that I have placed on record. There is no whisper of consideration of the e-file.
Right, ಕೂತ್ಕೊಳ್ಳಿ. A civil servant is knocking at the doors of Writ Court for assailing State Administrative Tribunal's order dated 19/7/2024, whereby his application number 2012 of 2024 has been negative. Full stop. In the said application, he had called in question the order dated 5/6/2024, a copy whereof avails at Annexure A9, whereby he was placed under suspension in contemplation of disciplinary inquiry. Full stop. Next, learned senior advocate, Mr. Gopal appearing for the counsel on record for the petitioner. raised only one legal issue as to automatic rescinding of suspension in question because of operation of rule, amended rule, ಕೂತ್ಕೊಂಡೆ ಹೇಳಿ
10(5)
B, 10(5) small b na? Small b of CCA,
CCA rules
KCS
1957.
CCA rules 1957. 57. Semicolon. He states that his client was kept under suspension by order dated 5/6/2024, and the maximum period that it would continue came to an end on 4/12/2024, and therefore, regardless of the reasons which the tribunal has assigned in its order, comma, the suspension of petitioner needs to be treated as having been statutorily rescinded by a deeming provision. First up. Next paragraph. Learned AGA appearing for the respondent submits in justification of the impugned order of the tribunal and the reasons on which it has been constructed. First off, he points out that in December 9, on 9/12/2024, already the charge memo has been sent to the petitioner, and therefore the contemplated inquiry stands initiated, and therefore, in the absence of an express order rescinding the suspension, comma, that position would continue. First, having heard the learned counsel for the parties and having perused the petition papers, we are broadly in agreement with the submission of learned senior advocate Mr. Rajgopal that the maximum period of suspension would be 6 months unless continued otherwise. Semicolon. Petitioner having been suspended on 5/6/2024, comma, the said period expired on 4/12/2024, comma, in the absence of any demonstrable records to show that in the absence of any record to demonstrate the continuation of the suspension. Idiya yenadru? Illa. First, when asked, comma, learned AGA in so many words and in all appreciable stand, says that there is no such order whereby suspension of the petitioner has been continued after its statutory expiry. First up, the rule, next paragraph. The amended rule cited by the learned senior advocate has the following text. First up, it appears that this amendment took place in the light of what the apex court observed in so and so, to the effect that after the expiry of 3 months, comma, the suspension automatically stands rescinded. First up. However, the above rule has prescribed a period of 6 months instead of 3. First up, a deeming effect of a provision will have full force. First up, next one, in the above circumstances, this petition is disposed of, declaring that petitioner's suspension dated 5/6/2024 came to an end on the evening of 4/12/2024, and therefore a direction issues to the official respondents to give him posting elsewhere in accordance with law. First up, Any dispute relating to what should happen to the suspension period in terms of monetary aspects are kept open.
Great.
To work out the remedy in accordance with law. Again, elsewhere.
ಇವ್ರು ತಮ್ಗೆ ಎಷ್ಟು ಪ್ರೆಷರ್ ಇದ್ರು ಅಂದ್ರೆ ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಅಲ್ಲಿ ಮುಗಿದೋಗುತ್ತೆ ಅಂತ ನಾನು ಹೇಳಿದ್ದೆ ಅಷ್ಟೇ. ಸಾರಿ
ಅಲ್ಲ, statutory deeming ಇದೆ ಮಾಡಕ್ಕೆ. 53 Supreme Court. Deeming should be given full effect. ಒಳ್ಳೆ ಪುಸ್ತಕ ಇದೆ. Law of Fiction by Raghavacharya. Very beautiful book. Law of Fictions ಅಂತ. I did not see any European and American book on that way, but I have read such judgments like Neely of a particular state Supreme Court judge in America. So beautifully has explained what is the effect of deeming clause. One judgment which Mr. M.R. Naik had argued under deemed conversion is also a very good judgment by Justice G.P. Shaw Prakash and another bench. So beautifully they have treated that. Anyway,
great.
ಬಂದಿಲ್ಲ.
Only the order sheet is challenged.
ಕರೆಕ್ಟ್. ಅವ್ರು ಇದ್ರೆ ನಾವೇನ್ರ ಹೇಳ್ಬೋದು. ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ಗೆ ಆರ್ಡರ್ ಶೀಟು, ಆರ್ಡರು, ಜಜ್ಮೆಂಟು, ಡಿಕ್ರಿ ಹೆಂಗ್ ತಿಳಿಯೋದು ಹೆಂಗೆ? Call this matter on last week of 27th of January to enable party in person to come and argue. Okay. 30. Some last one. Yes, brother.
Case of premature transfer, my lords.
Just this premature. ಎಲ್ಲಿಗೆ? From which place to which place?
My lord, from Joint Director Town and Country Planning East Division BBMP
to
Joint Director Dasarali Zone.
Dasarali. ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ಆಗ್ತದೆ?
Not around 10-15 kilometers.
10 kilometers.
Please, my lord.
ಇವರಿಗೆಲ್ಲ ಕಾರ್ ಇರುತ್ತಾನ? ಅವರ ಡೆಸಿಗ್ನೇಷನ್ ಕಾರ್ ಇರುತ್ತಾ?
Not sure, my lord.
Not sure.
Not sure about.
My lord, in this matter.
Before the tribunal, earlier she had been repatriated, my lord. She is on deputation. She had been repatriated. That order was set aside, and there was a direction to direction to give her the same posting. However, my lords, she has been given posting to the Dasarali zone.
ನಿಮ್ ಕಡೆ ಹೋಗಿ ಕೆಲಸ ಮಾಡಿ.
And moreover, my lords, one
ಗಳು ಇತ್ತು. ಪೇಜ್ 54 ಅಲ್ಲಿ ಅಲಿಗೇಷನ್ ಮಾಡಿ ಅದನ್ನ ಮಾಡಿರೋದು ಸರ್.
54
Page 54, lords. Annexure A5.
Lord, that was considered by the tribunal on the earlier round of litigation.
Repatriation ಆಗಿದೆ, but we have posted her to a vacant post. Where additional charge.
ಏನು ಪೇರೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಯಾವುದು?
PWD.
Send her back to PWD. How long she has been?
ಅದಕ್ಕೆ repatriation set aside ಮಾಡ್ಬಿಟ್ರು.
Set aside ಮಾಡಿದ್ದಾರೆ.
My lords, repatriation order has been set aside by the tribunal.
My lord,
BBMP has.
Thereafter, my lords.
My lord, may I submit? I had one matter before the Gulbarga bench, my lord. I will come back to the office. My lord, in this matter, she has already gone and reported to the transferred place. She, after my lord on the last occasion said that why she has not reported, though 3 months is over after the tribunal order. Now, my lord, she has already reported to the said place, my lord. And now they have taken consent, my lord, and she is to be given the work there, my lord. She has already reported at Dasarali.
Yes, all right. Consent ಏನಂತ ಕೊಟ್ಟರು?
My lord, what has happened? Under protest, I have joined.
Protest.
Under protest.
ಅಲ್ಲ, they should join because
because of the apex.
ಆಗ್ತದೆ, ಹಂಗಾಗಿ they have to join ಅನ್ನೋದು. That will not go against her.
Please, my lords.
All right.
My lords, one more aspect.
How long you were there?
My lords, from 8 to 2023.
8 to
2023, my lords. I was deputed to BPMP from that day.
23 to?
Lords, the posting is for 2 years. The tenure is for 2 years.
8 to 23 ಆದ್ಮೇಲೆ ಯಾವ ಡೇಟಿಗೆ ಆಗಿದೆ ಆರ್ಡರ್?
My lords, repatriation was on 28 to
24.
Yes, my lords.
Repatriation transfer ಅಂತ hold ಮಾಡ್ಯಾರ?
No, my lords, on an earlier occasion, within 1 year, that is at 28 to 2024, she was repatriated. I challenged it before the tribunal. Tribunal allowed my application and set aside the repatriation order. And there was a direction given to let her continue in the same place. But here in Lords, they transferred me to Dasarali zone instead of East Division.
No, no, liberty was granted, my lord, to transfer her. Your lordship may see the order copy of the
2
tribunal.
years retention, whether it amounts to transfer under the guidelines or not.
It is, my lord, the liberty was granted to the BBMP, my lord.
That's all right. Liberty means not to violate the transfer guidelines. Whether it amounts to transfer or not is the question now.
She has been transferred because, my lord, there were certain complaints against her, my lord. That is why we did not want her to be there.
My lord, that contention of allegations made, complaints against her was with respect to repatriation order. However, that was rejected by the
You are
tribunal.
working there now.
No, my lord, I because
3 months you did not appear, you did not go and
because of
join
the
the duty
pending
at all.
during the pending litigation, I did not appear, my lord. Due to pending litigation, I did not appear.
Yaudadu? Where they do not join duty, they should not be shown mercy by the writ court ಅಂತ ಬರ್ದ್ವಲ್ಲ ನಾವು. ಯಾವುದು judgment?
And one more aspect, my lords, this post, my lords, has to be by way of deputation. Now, the current person who is holding that post is a BBMP official, my lords. He is not entitled to hold that post.
But in Lakshmi Narayana versus KSFC, it is integrity judgment. The court has held, even when there is such a rule, the inside employee is entitled to hold the post. HP Lakshmi Narayana versus KFDC. It's held against you.
But this
ನಮಗೆ ನೀವು ಎಲ್ಲ ನಾವೇ ಹೇಳಂಗಿದ್ರೆ ಮತ್ತೆ ನಿಮ್ ತಗೊಂಡು ಏನ್ ಮಾಡ್ಬೇಕು ನಾವು ನಿಮ್ ಬಾರ್ ನಲ್ಲಿ ನಾವೇ ಮಾಡ್ತೇವೆ ಎಲ್ಲ ಅದನ್ನ ಎಲ್ಲಿದೆ ಎಫಿಷಿಯನ್ಸಿ ವೇರ್ ಇಸ್ ದಿ ಎಫಿಷಿಯನ್ಸಿ
Which I appeared.
where they did not report for duty.
Petition number 22 of 20.
ಬರ್ಕೊಳ್ಳಿ
ಅಲ್ಲ ಇದರಲ್ಲಿ ಗೈಡ್ಲೈನ್ಸ್ ಇದೆ ಸರ್. ಇದು 2013 ಗೈಡ್ಲೈನ್ಸ್ ಇಸ್ ಅಪ್ಲಿಕೇಬಲ್. ಆಗ ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ, ವಿತ್ ಇನ್ ಸಿಟಿ ಮಾಡಿದ್ರು ಟ್ರಾನ್ಸ್ಫರ್ ಬರೋದಿಲ್ಲ.
ಟ್ರಾನ್ಸ್ಫರ್ ಆಗೋದಿಲ್ಲ.
ಬರೋದಿಲ್ಲ.
ನೀವು 2024 ಗೈಡ್ಲೈನ್ಸ್ ಅನ್ನ
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅವರಿಗೆ.
ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲ.
2013 ಏನಂತ ಇದೆ?
2(3) D ಸ್ವಾಮಿ. Transfer means the posting of a government servant from one headquarters to another headquarters, from one office to another within the same headquarters to take up duties of a new post or in consequence of change of headquarters. Note, moment or government servant within the same office, unit from one post to another one, or desk compilation to another one under the same head office shall not be treated as transfer.
Lords, however, this note has been interpreted in S.N. Gangadhara full bench judgment, and it has been considered to be
holding that
it amounts to transfer.
You under 2013 full bench judgment.
Full bench judgment, my lords. And
that amounts to transfer.
And it has
but you were away from duty for 3 months.
3 months.
That is that.
Huh.
Due to pending litigation.
Petitioner, a PW employee on deputation to corporation, was before the tribunal in her application number 1988 of 2024, calling in question her transfer from
Joint Director, Town and Country Planning, East Division.
From the post of Joint Director, Town and Country Planning,
East Division, BBMP.
East Division, BBMP 2.
Town and Joint Director, Town and Country Planning, Dasarhalli Division.
To the same office at Dasarhalli, of the corporation, city corporation. First, the tribunal did not favor her case and therefore denied relief. First, aggrieved thereby, petitioner is knocking at the doors of writ court. First, next part. Learned counsel for the petitioner vehemently argues that within the meaning of transfer as given under the provisions of 2013 government guidelines of transfer, a movement of an official from one office to another, even within the headquarters, amounts to transfer in the light of full bench decision in Chandru versus
S.N. Gangadhara.
S.N. Gangadharaya versus State of Karnataka. Citation code.
AR 2015, Karnataka 146.
Sorry. First, the retention period being 2 years, deployment an official from one office to another, even within the headquarters, should amount to transfer, comma, vehemently argues counsel for the petitioner. First, learned AGA appearing for the state and learned panel counsel appearing for the municipal body, as also learned counsel appearing for the
Miss colleague.
only
Colleague.
body oppose the petition, making submission in justification of the impugned order of the tribunal and the reasons on which it has been structured. First, learned senior panel counsel appearing for the corporation points out that petitioner has been away from the transferred place, though there was no stay of the transfer order, and that has hampered work of the corporation, and therefore should not be shown any leniency in constitutional jurisdiction. First, in support of this, he banks upon a decision of this court in WP number. So and so, between so and so, disposed of by us on so and so. First, having heard the learned counsel for the parties and having perused the petition papers, we do not think that it is necessary to treat contention of the petitioner, counsel for the petitioner on merits when her client is unjustifiably away from the seat of duty, resulting in hardship to the consumers of service, public service. First of such a view gains support from the decision supra. So first of, in the above circumstances, the petition being unworthy of merits is liable to be and accordingly dismissed. Costs having been made easy. ಈಗ 3 ತಿಂಗಳಿಗೆ ಏನಾರ ಆಕ್ಷನ್ ತೋತಿರನೋ ಮೇಲೆ ಅವ್ರ ರಿಪೋರ್ಟ್ ಆದ್ರೆ ನೀವು ಆಕ್ಷನ್ ತಗೋಬಾರ್ದು.
I have already reported, my lords.
First off, since petitioner has now already reported for duty, comma, no disciplinary action be taken for the period she was away from service, although that would be treated as dice non for all practical purposes. Okay.
Salary also.
That's what. Dice non ಮಾಡ್ಬಿಟ್ಟೆ.
Okay. I'm sorry again, Manoj.
Correct. Correct. Alle idondu ಒಂದು paragraph ಹಾಕ್ತಿ ಮಾಡ್ತೀನಿ. In the said decision, para 3 reads as under. It is observed in para 3 as under. ಹಾಕಿ ಎಷ್ಟು ಹಾಕಿರಿ? All right. Mr. Naik wanted to read Dikshitalu judgment.
No, I'll skip that, my lord. So I wanted to read the division bench judgment of Andhra Pradesh, which was later judgment than Dikshitalu, but which went into the aspect of these concepts, namely, let's say concepts which are ingrained in 371, equitable opportunity, subject to the interest of the state as a whole.
Correct.
And proportionate reservation. These three concepts, my lords, which according to me are the guiding principles
for this case
by the parliament in the provisions of 371J itself, have been explained in that judgment.
Okay.
And that judgment, my lords, went to the Supreme Court, and Supreme Court has, by a short order, my lords, has dismissed it, but giving certain further directions. But that judgment, my lords, once I read, would avoid my arguing, my lords, explaining these principles inbuilt in Article 371J.
Very.
So therefore, my lords, I wanted to argue that.
Correct. Which is
My lords, I have just to recapitulate, I have already pointed out to your lordships that there was a notification in 2000, under which, keeping in view the provisions of 371J and the Governor's order,
2001.
Let's
How can
the
2013 it could be?
no, let's the special rules which were on 8/7/2020.
For Hyderabad, Karnataka?
No.
No.
Let's the first of the rules which are called as special rules, which were made, Lords, on 8/7/2020. That was the starting point of my submission, Lords, on the factual position qua the notifications.
Yes.
8/7/2020.
Page 31 you are reading from your.
Page 30. Page 30.
Correct.
That's it, my Lord. Under that provisions, it provided for appointment of these posts, keeping in view the 371J principles and the Governor's order, pointing out that there shall be a determination of the total vacancies in HK region and outside, also indicating that this shall be done in accordance with it shall be done keeping in view the principles in 371J. It directed deciding the cadres, bifurcating. It also pointed out so many vacancies arise under that, the total for appointment.
Correct.
It also provided for proportionate reservation by spelling out at 75 and 25.
Correct.
And 8% outside the HK region. That was the overall scheme, Lords, under the notification issued by the government as a special rule. Thereafter, my Lords, several circulars were issued by the government. The first of the circular was 6/6/2020, under which the circular pointed out that it shall be done in this manner. I won't go in detail.
Yes, you have read it, that also. We have read it yesterday.
Based thereon, my Lords, examinations took place. Based on the options given under that circular, the option was to the persons for a larger benefit of residents of that area to decide beforehand that if there is a vacancy based on my merit outside the reserved category, he is given an option. It is an additional benefit, my Lords, which is accrued under the circular.
Correct.
Based on that, my Lords, the selection takes place. That is, examination is conducted. The results are notified. Provisional list is drawn based factoring in the options exercised, factoring in the relative merits of the examinees, my Lords, who had taken the examination. 2 days after notifying the provisional select list, there's a change by the government withdrawing the last of the clause under previous circular, which had said whatever we want to do, we'll do it in future. Withdrawing that.
Ongoing process will be continued.
Will continue. Withdrawing that clause, my Lords, disrupted what had happened by that time, giving rise to the persons who were in provisional select list being pushed out. They were aggrieved and they invoked the jurisdiction of the tribunal, challenging the process. That's the background, my Lords, of this case. Now, the basic thrust of argument, my Lords, of the petitioners is that having started the process, you can't disrupt it and take altogether a different route. For purposes which you have spelled out in your order, are in the teeth of the spirit of the provisions of 371J and the Governor's order, you have no such power. The second is that once you start, you can't disrupt that to the disadvantage of persons who have had some kind of a notional benefit, my Lords, out of the process that had commenced. Now, our thrust of the argument was that it would be in violation of what is required to be done, keeping in view 371J and the Governor's order. In these two, there are principles spelled out by the Parliament as to what should be the criteria in working out, my Lords, the provisions of 371J. Now, to understand those concepts, instead of my enunciating them independent of each of these concepts, my lords. I wanted to read the judgment
That discusses these aspects.
which discusses, my lords, and therefore your lords may kindly take that judgment in the compilation.
Page number?
This is volume 2, compilation of case laws related to statutory orders. At page 86, my lords, the pagination is on top, my lords, which is sometimes smudged with the description of, my lords, the subscriber of SCC online.
Page?
Page 86, my lords.
6.
That's the third judgment in this compilation.
Okay.
Lords,
Division bench judgment.
Yes, my lords, but this has gone before the Supreme Court. I'll explain that, my lords, little later.
Okay.
But I find that this is the judgment which explains in clear to drive home the point that this is the limitation thrust on the governments in providing for 371J provisions, my lords, under the constitutional scheme. My lords, the very opening sentence, my lords, of this judgment: repeated attempts by the government of Andhra Pradesh to bring about a unified cadre of teachers in government, Mandal Parishad and Jilla Parishad schools have met with little success. The last such effort prior to Act 25 of 2007, which met with its Waterloo, was when the rules 2011-1998 were declared ultra vires the presidential order and were quashed by the division bench of this court in Kesuvalu versus State of. Lords, this judgment is available in the very previous judgment. I will not trouble pointing out because this judgment itself explains what is Kesuvalu's judgment. Para 2. As the order of division bench in M. Kesuvalu was not suspended by the Supreme Court, the state government then commenced efforts to obtain approval of the president for organizing the cadre of teachers in Mandal Parishad and Jilla Parishad schools into local cadres in yet another attempt at achieving integration of the two cadres, the teachers cadre in government schools and Mandal Parishad and Jilla Parishad schools. The central government, via letter dated 7/3/2005, sought information from the government of AP whether 1. The organization of teacher and non-teaching staff of Jilla Parishad and Mandal Parishad schools in Andhra Pradesh into local cadres would cause disquiet among the teaching and non-teaching staff. 2. Whether it was legally tenable and procedurally appropriate to issue the proposed orders when the principle behind the proposed orders had been challenged in SLP filed by AP United Teachers Federation before the Supreme Court, notwithstanding the fact that the Union of India was not a respondent in the SLP. While furnishing information to the central government, in its letter dated 18/3/2005, the government of AP informed them that the President of India permitted teachers working in Panchayat Raj institutions to be organized into local cadres, and they were integrated with government teachers. The SLP pending before the Supreme Court would become infructuous, and therefore there was no legal objection to issuing the proposed orders. Concurrence of the Government of India was sought to enable the state government to organize the teaching and non-teaching staff of Jilla Parishad and Mandal Parishad schools into local cadres. However, presidential approval has not been accorded till date. The legislative route was then taken and Ordinance 12 of 2005 was promulgated on 13/7/2005. And under Section 12(1), thereunder, the rules notified in GO dated 25/7/2005 were made. Just to avoid reading in detail, let me just give a background. The presidential order directed it being operated within a time frame. That is, they were required to integrate, they were required to organize the cadres in the state of Andhra Pradesh within a time frame.
That was under 371D.
371D. Now, that time frame had expired, but then there was a necessity to integrate people who were not organized under the earlier orders of the government of Andhra Pradesh. They attempted to do that. In Kesu Velu, the Supreme Court said, no, once the time is over, government doesn't have any such power to meddle with the president's order. Therefore, it is bad in law. Now, having done that, which was by an executive process, they attempted a legislation through the Government of India to bring in to the same effect the integration required to be made of the teachers and teachers of the government and of the Jilla Parishad.
Oh, Government of India.
No, state, I'm sorry. State government by act, the act is 27 of
2005 Act.
2005 Act. Now that
They challenged section 7 of that act.
Yes.
As being counter to the order of the president under 371D.
That's right.
That's
I
the
stand
position
correct.
of this.
I stand corrected. It is in that context, my lords, the issue arose as to whether A, it is permissible for the state legislature to enact, and whether it can provide for integration in the face of the existing
Scheme under
presidential order. Lords, unlike our 371J, it is the president himself makes the order.
Here it is governor makes.
It is the governor, because government has been given the responsibility, but the scheme of both the provisions are somewhat similar, except that the person to order is president in Andhra Pradesh and it is governor in Karnataka.
How that 371D reads, let us just see the text.
Yes.
Where you say your friend said he has produced it at page 1, na? Page 1. No, that was our 371J. 371D.
Where is he? He is reading it.
The entire scheme is operated by the president himself.
Yes.
He envisages the scheme and he operates also.
Yes.
Correct. There's no role to governor at all.
Almost similar text, which are spelled out as responsibility of the governor, are incorporated.
Responsibility of the
Are incorporated in this. Let's read this judgment, my lords.
Okay. Yes.
So its broad feature of this judgment is that the Supreme Court explains, or the court explains, that the presidential order is made to overcome the constitutional bar under 16(2).
16(2).
Yes. 16(2), among others, says you can't discriminate based on the residence.
One of the factors.
Place of birth or residence. Now, that's a express prohibition under 16(2). Now, question was whether 371(1) or 371D would be in the teeth of that prohibition and how far it is permissible.
But that notwithstanding, even then that pales into insignificance.
Even despite, notwithstanding, that's why, my lords, it analyzes and explains these concepts and how it is to be understood. For that purpose, my lords, I am reading this in little detail so that, my lords, my burden of explaining what is, first thing your lords asked me was, what is equitable opportunity? That's explained, my lords, in this. The equitable opportunity, my lords, just to digress from reading this, is that insofar as Andhra Pradesh is concerned, it had drawn, my lords, the regions from different states, Karnataka, Maharashtra, and Andhra Pradesh, Hyderabad. So when you provide for the opportunities, can you provide only for one reason? That is where, my lords, the issue of it being in conflict with the prohibition under 16.2 was taken note of. But if you provide for these cadres for the different reasons to all, that is state as a whole, then it may be permissible is what the ultimately, my lords, the judgment speaks of. Therefore, my lords, kindly permit me only relevant paragraphs, my lords,
Yes.
which deal with this, I will read.
Very. Which paragraph, Mr. Mike?
Lords, this went before the tribunal as is noted, my lords, in page 87. Then, my lords, the last 5 lines, tribunal by order dated 14/8/2006, my lords, page 87. That is para 2, my lords, of the judgment which I was reading. Tribunal by order dated 14/8/2006 allowed OA and quashed section 1(3) of Act 27 of 2005 as ultra-virus the presidential order. The tribunal further
just clarification, whether tribunal has power to strike down provisions of the act also, they have power.
Was constituted as 371.
Huh?
Tribunal itself was constituted by
As a substitute for the High Court.
371D.
Separate tribunal itself is constituted for.
And your lordships have seen, my lord, the provision which says even the High Court have no power to interfere with the order of the tribunal. The Honorable Supreme Court has struck down to that extent of the
non-interference.
Because it affects the basic structure. Therefore, to the extent of saying criminal order is final, even the High Court shall not interfere.
That's
Not
bad.
have been struck down.
Samba Murthy's
Yeah.
case.
371D ದಲ್ಲಿ your lordship could find, my lord, the constitution of the tribunal
also. Okay.
And it said the rules under GO also are not enforceable.
Yes.
Then, my lords, para 4, sorry, para 5. We are satisfied that Act 27 of 2005 and rules notified are ultra-virus the presidential order and Article 16(2) of the Constitution of India and are required to be struck down. It is therefore unnecessary for us to refer to the other submissions made challenging the validity of Act 27. Before referring to the previous provisions of Act 27 of 2005 and rules, it is necessary to make in brief prefatory observations on the scope and purport of Article 371D and presidential order made thereunder. Circumstances which necessitated its introduction, state action, be it legislation, plenary or subordinate, or by an executive order which denies citizens equal opportunity and access to public employment on the ground only of place of birth or residence, would be invalid qua the provisions of Article 16(2) of the Constitution of India. Article 16(3) of the Constitution, which makes an exception to the limitations under Article 16(2), is confined to enabling Parliament to prescribe the qualification and residence in the state as a whole. Kindly mark this, as a whole.
As it appears in 371J.
Yes.
Yes.
And not to any part thereof. No legislation is permissible even by Parliament making the requirement of residence in a part of the state for employment or appointment to a public office in that state. Several earlier judgments have been referred. Now, let's para 7. It is with a view to enable prescription of residence in a part of the state for employment and appointment to post, and in matters of admission in universities, that the Constitution under Article 371D has made special provisions with respect to state of Andhra Pradesh. It is necessary in that context.
The historical background is 8, 9, 10, 11. As to why 371D came to be introduced.
Yes.
It's mentioned in this.
Yes. It is necessary in that context to refer in brief to the event which led to the introduction of Article 371D by 32nd Amendment to the Constitution. The former state of Hyderabad comprised, as I explained, different parts of were brought into the state of Andhra Pradesh.
Yes.
Therefore, they could not have made provisions of residence only a part of the state. It had to be as a whole.
It will fall foul of 16(2).
Yes.
Is the theme.
Yes. Let's para 10.
Yes.
Soon after formation of state of Andhra Pradesh, Parliament enacted the Public Employment Requirement as to Residence Act 1957, making special provision for requirement as to residence for public employment, and brought it into force with effect from March 21, 57. The constitutional validity of this act was challenged by persons employed in the ministerial services of the government of Andhra Pradesh.
That was struck down by the apex court in Narasimha Rao case.
Yes.
He says. Yes. Go to next point.
On the ground that it is in the teeth of Article 16.
Yes.
Then, Lords, they noticed widespread the agitation and demand, all that. Then, Lords, there was a the state government passes a resolution setting out a 6-point formula, that is para 11, Lords, at the bottom, was evolved by the political leaders to provide for uniform approach.
Equitable opportunities of employment to the people of those parts which came to Hyderabad.
Correct.
In the formation of the state.
Your Lords put it, Lords. That's exactly what, Lords, this judgment seeks to explain.
Okay.
Then the 6-point state as a whole, and to provide equitable opportunities to different areas of the state in matter of education and employment in public service. Then the various points, Lords, which were evolved out of 6 points have been explained.
Yeah.
Then para 12, implementation of the 6-point formula envisaged, inter alia, amendment of the Constitution conferring power on the President of India in order to secure smooth implementation of the measures based upon 6-point formula without giving rise to litigation and consequent uncertainty. Then statement of objection is mentioned, Lords, in para 13, which sets out the historical background, but in effect repeats, Lords, the hesitation, how the different judgments are taken.
14, just 2 sentences.
Yes.
Primary purpose of introducing 371D
was twofold.
To
promote accelerated development of the backward area of the state of Andhra Pradesh, so as to secure balanced development of the state as a whole, and to provide equitable opportunities to different areas of the state in the matter of employment, career prospects, and public service. To achieve this primary object, Clause 1 of Article 371D empowers the President to provide by order for equitable opportunities and facilities for the people belonging to different parts of the state in the matter of public employment and matter of education. Clause 2 is complementary to Clause 1 and particularizes matters for which an order made under Clause 1 may provide. Subclause C1 thereof enables the President to specify in the order the extent to which, the manner in which, and the conditions subject to which preference or reservation shall be given or made in the matter of direct recruitment to posts in local cadre under the state government or any cadre under any local authority. So those concepts, my lords, of local cadre and the cadre which are also found, my lords, in the Garner's order were enunciated.
But one sentence in 15, first sentence.
Yes, is a special provision
which makes a departure from the general scheme of the Constitution.
Correct me. The area of, this is actually an extract from Dikshitulu. Just
That,
above that
particular thing.
Yes,
Above
two
they have
lines
given
above, lords, the Dikshitulu is mentioned,
LVA Dikshit.
as well as Sambamurthy.
Yeah.
The 371D is a special provision which makes a departure from the general scheme of the Constitution. The area of departure cannot therefore extend beyond what is unmistakably and specifically delineated by the words employed therein or in the presidential order made thereunder. Article 371D, in effect, enables President to make an order enabling
prescription of
residence in a part of the state for employment or appointment to a public office in that state. Clause 10, that is, my lords, non-obstante clause in 371D. Clause 10 of Article 371D gives overriding effect both to the provisions of Article 371D and an order made by the President thereunder over other provisions of the Constitution and any other law in force. Thus, prescription of residence in a part of the state of Andhra Pradesh is permissible, notwithstanding the prohibition under Article 16(2), provided such a prescription has been made under Article 371D or the presidential order made thereafter.
The exception could be made for 16(2) also. The only limitation is what has been in so many words said by the president.
Correct.
That's all.
Therefore, my lords, taking that, my lords, analogy to our case, the Garner's order prescribes. The 7525 is what is prescribed by the Garner, identical to what President has done by organizing the cadre. Now that cadre which is, my lords, organized, identifying the posts and apportioning proportionate reservation is permissible in terms of the Garner's order. But unless it is provided by Garner's order, the state executive does not have anything to meddle with that. That's the basic principle, my lords, evolved in discussing this special status, etc. It's also necessary to note that the scheme of Article 371D was held to be valid intra vires the amending powers of Parliament, and as to
its validity was challenged and apex
that it was not in the teeth of basic structure is what is explained.
Correct.
Then, lords, the next page, presidential order, scope and extent of power of the state government thereunder. This would be relevant, lords, because notwithstanding clause 10, which is, my lords, non-obstante clause, they explained what is the scope. The scope is that you can provide for residential qualification as long as it is traceable to the presidential order, not outside. Here, my lords, it would be traceable to this Garner's order. The Garner's order
stand on the same footing is your
yes. Therefore, my lords, when Garner prescribes 7525 by a surreptitious method of giving them a larger benefit, you can by a subsequent circular say, I give a go by, I allow people to choose whatever post is available outside their HK cadre and based only on their merit, which, my lords, is the provision which is under attack, my lords, in these cases. I'm only trying to point out that this had fallen for consideration before the court qua the presidential order.
All this was not argued before the tribunal,
Lords, apparently, before the tribunal, unfortunately,
not argued.
unfortunately, before the tribunal, if your lords have seen the order, up till para 65 of the tribunal's order, it is verbatim copy of a judgment of this honorable court made in KPTCL case, which did not go into.
This aspect of the matter has not been treated.
No, but then it was urged before the tribunal that these are the aspects which require to be considered. It's not as though it was not urged. The tribunal merely said, I am bound by the order of the High Court rendered by the
KPTCL matter.
matter, and therefore I incorporate. If you're allowed to see verbatim, it is repetition of what is contained in that judgment.
But even in KPTCL, these aspects of the matter have not been duly
No.
adverted to at all.
Let's say it did not arise in that case.
Yes, at all.
Yes. Nor, my lord, 16.2 was something which would have fallen for consideration in KPTCL judgment. So therefore, my lords, there is a...
The gist of your submission, as perhaps we have understood, is the scheme to be seen from the words employed by the governor under the order of the president promulgated under 371J.
Yes.
If what these people are doing runs counter to that or breaches anything of that,
Yes.
then that is impermissible. Is your version.
Especially in the context of the concepts evolved by the pronouncements, qua what is equitable opportunity, b what is keeping in view the entire state's
Requirement of the state as a whole.
3, proportionate reservation. Now, these things having been addressed in the governor's order, you can only supplement by circular somehow to work out that.
To effectuate the same. Not run
Not
counter to that.
destroy or derogate, my lords, is the submission. I'm sure.
In other words, these three concepts which you have said, equitable opportunities, etc., and regard being had to the requirement of the state as a whole.
Yes.
And proportionate reservations. They are not new things as such.
No.
They have already been treated by the apex court.
Yes.
And there is a presumption that Parliament has read all the judgments of the apex court.
Yes.
And has made the law. Therefore, they need not be treated in variance with what has meaning the apex court attached to these terminologies.
Yes.
Is your submission.
Yes.
And impugned circular is offensive of governor's order.
Look, slight addition to what has been decided here, unlike in Andhra case, which had clause 10, which said notwithstanding anything contained, including the constitution, 371J was enacted at a later point of time. The Parliament was conscious of the limitations under the constitution which required to be kept in mind while legislating.
And even otherwise also, Mr.
Therefore,
Nayak.
advisedly, by then 16.2 had been enunciated. There were various nuances under Article 14, under 15, under 16, by several judgments, of the Supreme Court, including Indrasani. Therefore, they were conscious of the position in law and therefore did not provide for the notwithstanding anything contained provision, unlike the other provisions of 371.
But even otherwise also,
yes,
notwithstanding has been watered down to a great extent.
Correct. No, in this itself,
itself subject to one.
Correct.
That it should be within the teeth of the order of the president.
Correct. If you can even violate some of the protections under the constitution, as long as that has been permitted by the president himself in the presidential order. That applies to governor's order because the president mandates that governor shall make this order. In terms of
as good as
president's order.
Words,
yes,
it is as good as presidential order.
Correct. Now that your lordships would look into. I can only give paragraphs because my purpose was to draw to your lordship's attention very interesting consideration of what is Article 16.2, how it can be
To some extent
meddled with
within the terminology of President's order.
Correct. And what is the reservation proportionate? That also comes into picture because Garner has already decided what is proportionate. Now, once that proportion is determined, you can't, by your executive order referring to clause 19 of the presidential order, which gives you power to interpret and clarify, try to destroy that very concept which has been
Order or governor's order?
Governor's order. In our case, Milords, it's Governor's order. Milords, clause 19, which I read yesterday.
Of governor's order.
Governor's order.
Power to interpret.
Yes.
That you cannot, in the guise of interpretation, you cannot offend the intent and policy content of governor's order.
Yes.
That appears to be your submission.
Milords, may I, in that case, Milords.
We have another bench also, Mr. Nayak.
I didn't know that.
We are all part-timers now.
Oh. Milords, what I have done is Milords, I have in fact set out all my submissions in writing. I know, Milords, you lords do not take the submissions, but then just to make the submissions complete, I'll seek your lordship's.
Your oral arguments will be necessary.
Yes.
You have to.
I'll do that. No, I'm only pointing out that the details of these paragraphs I've set out in that submission.
Note.
Yes, I'll hand it out to the court. Milords, in addition to this issue of exceeding what is prohibited, I have an argument on the disruption of the game, which Milords had virtually concluded. Though, Milords, the councils have pointed out the 5 judges' judgment, Milords, on this aspect as to how it should be viewed. There's a direct judgment, Milords, which has considered Bevin Katti, which unfortunately did not go into the decision making by 5 judges, which has explained once by invitation you set out how you will work it out.
That
You
should
can't
be permitted to
disrupt.
go
Yes.
throughout.
So I need to read that judgment, Milords, before your lordships. Next date, Milords, I will assist.
Whichever date you want. But we request you that you should personally come and argue the matter.
No,
Note will not be sufficient.
No.
After hearing, we may understand the note.
That's why, Milords, after I point out to the nuances of my case,
Correct.
I want to, because the details of my submission, Milords, which I may make it short, should not go out of, Milords, the consideration at the hands of the court.
There is no substitute for oral argument.
That's true, Milords. I agree with you.
If everything were to be in writing,
Yes.
where was the need for the bar at all?
I realize. No, I'm only saying for details of my submission, because I may skip some of this which need to be looked into. So I've given paragraphs, Milords, which deal with that aspect.
Okay. Mr. Nayak wants it on Tuesday, no? No, let him complete it. Yeah, which day you want?
Milords,
Whatever day you want.
except 16, Milords, any day is okay with me. 16, Milords, I'm going to my hometown for a family function, marriage.
17 we will have.
Any day convenient.
17. 17, all right. 17. Because now I do not, we do not want to disrupt your argument, flow of your argument.
Yes.
After you complete, suppose in the meanwhile, if somebody argues, we may lose the track of your argument only for that reason. Otherwise, we would have posted this matter on Monday itself. Tuesday we will have. Okay. At 2:30.
17th it would be convenient, Lords. I'm sorry, I was
17.
But 17th it would be convenient.
17th.
I'm sorry, I was not able to come to the court. Please.
Tuesday.
No, that's what MR Naik sir also wants.
Very well.
Please.
Then entire argument will not be over before the vacation commences. May not be. Of course, some serious consequence, we understand. employer.
Lords, if 17 their argument is over,
Whose
I will
argument?
try to keep it as short as possible. Lords.
ಹಂಗಿಲ್ಲ ಅದು. ಅದು
MR Naik sir's argument is.
Argument over ಮಾಡ್ರಿ ಅಂತ
Please,
ಹೇಳಿದ್ವಿ.
ಅಲ್ಲ ಹಂಗಾಗಲ್ಲ. ಲಾರ್ಜರ್ ಇಶ್ಯೂಸ್ ಇದಾವೆ ಇದರಲ್ಲಿ. ಸಿಂಪಲ್ ಆಗಿ ಹಿಂಗೆ ಯಾವುದೋ ಒಂದು ಸರ್ಕ್ಯುಲರ್ ನೋಡಂಗ್ ಇಲ್ಲ ಅದು. ಮೆನಿ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇದೆ. ಸ್ಕೋಪ್ ಆಫ್ 371J in the light of Dikshitalu and Kesur. We do not know. After reading, it may happen also. That's true. That's correct. We can't haste in such matters. We can't haste because we also want to reflect on what you have argued all these days. ನಮ್ಗೆ ಎಷ್ಟು ಕನ್ಫ್ಯೂಷನ್ ಇದೆ ಈಗ.
There was yet another attempt to again bring back by central government itself making Lords the provision. That again went before the Supreme Court. Supreme Court said, no, you can't, because it would be again in the teeth of the presidential order. It doesn't fall.
After Sambamurthy.
After this judgment, Lords, which I was reading, there was yet another attempt.
Even thereafter.
Yes, Lords. That's the third round of. Therefore, Lords, it needs a little detailed examination of the issue.
No issue. All, thank you so much.
ಒಂದಷ್ಟು ಎತ್ಕೋಬೇಕು ಅಷ್ಟೇ. ರೈಟಿಂಗ್ ಪೆಟ್ರೋಲ್ ಇಟ್ಬಿಟ್ಟೆ. ಮಾಡಲ್ಲ.
ಏನ್ ಸಾಕಿದೆ ಜಾಸ್ತಿ. ಪೆನ್ ಒಂದು ಇದನ್ನ ಹಿಡ್ಬಿಡು.